Hmm? Mine is 174, 175. Hmm. Mr. Babu. അറ്റ്ലാന്റിസിന് പോയില്ലേ? അറ്റ്ലാന്റിസിന് ജോൺ ഉണ്ടാവും അവിടെ അല്ലേ? ആ പോള് അത് അവരെ അറേഞ്ച് ചെയ്യുന്നോ? അല്ല സ്പോൺസർ ഉണ്ടല്ലോ, മെയിൻ സ്പോൺസർ അല്ല ഉണ്ടല്ലോ അല്ലേ? ബിസി ഉണ്ടല്ലോ അല്ലേ? അതെ, ഇപ്പോൾ ഇവിടെ രണ്ടാൾ വന്നിട്ടുണ്ടായിരുന്നു, വീഡിയോഗ്രാഫറും ഫോട്ടോഗ്രാഫറും ഒക്കെ ഇവിടെ വന്നിരിക്കുന്നത് അറ്റ്ലാന്റിസിൻ്റെ ഇവൻറ്റിന് റീറ്റെയിൽ സമ്മിറ്റ്. ഇപ്പം തന്നെ
Expecting the session to start in the next 15 minutes.
How are you doing? Good. Ready for more chaos? As usual. I'm good. Yeah, all good, all good. Always like reading. Yeah? Yeah. Oh, I like reading, especially this week. You know, Friday is St. Patrick's Day. So I'm kind of this coming Friday. Yeah, so I'm kind of building up. Yeah. I won't interrupt you. Yeah, taking us out or something? Oh, yeah, well, yeah, yeah. Over here on the left, we've plenty of seats. Yeah, yeah, please come on in. Yeah, thank you. Yes, Pavel, encourage people in, please. Thank you. Great, wonderful, wonderful. So nice to see you all. So nice to see you all. Come on in and get comfortable. And we're starting in 47 seconds exactly. Okay, please. Yeah, that's it. Habib, you can close the door, and anyone who's outside can't come in anymore. Yeah, wonderful. Take a seat. And on this side, great. So everyone, here we are at the 2023 Annual Trade Law and Compliance Conference, a gathering of practitioners in trade, law, compliance, KYC, all challenging issues, and all here to have a really, really good debate and discussion. So we're here physically in the room, but also we're virtually beaming around the world. So to our virtual viewers, thank you for being here. So we're going to start the proceedings, and I'm going to ask the chairman of the ICC Banking Commission and board member of ICC UAE, our chairman Ahmed Louta, to say the welcome remarks. Ahmed, thank you very much.
Well, good morning. Okay. Let me start by telling you I feel so lucky today because I got stuck in traffic, but you started late, so I'm on time. Thank you for coming here today. I would like to welcome you to the 2023 Trade Law and Compliance Conference hosted by the Dubai Chambers. Dubai Chambers has had a relationship with the Institute of International Banking, Law and Practice for the past 20 years. Today, ICC UAE and the institution have brought the leading minds in the trade finance, law, and compliance together to debate, have a discussion, argument, counter-argument to reach a viable solutions to what we have as problems. All done through friendship, good laughter, and humor. And I have seen, that happens. Thank God, no fights. So we are thankful for joining us today. I know the organizing for a successful technical and legal event would have been such a tough task. Therefore, I greatly appreciate the teams of the Institute and the ICC UAE. I'm also thankful to the Dubai Chamber, as always, for hosting this event and also for beaming out this to the world. Distinguished guests, we have a very interesting program today discussing legal cases in trade finance and compliance, risk management regulations, which are all mission-critical facets of the trade facilitation. I know that for sure because I'm a banking expert with the Dubai courts as well as the legal entities in the UAE. So I see a lot of these cases happening that needs detailed technical analysis for it to be, because at the end of the day, the courts are the real judge or the real test for any banking transaction. If it's concrete or not, that's where it happens to the court, and I see that almost on daily basis. Today's event is very important component of the Global Trade Facilitation Summit taking place all this week in Dubai. We are honored to have representatives of the World Trade Organization, the World Bank, and leading multilateral development banks with us in this week in Dubai. I understand by you being here and participating in this event, you will be automatically become a VIP guest of the summit. So that's another way to learn and exchange and have a dialogue with people around. Ladies and gentlemen, I extend my profound thanks and appreciation to the organizers, IIBLB, ICC UAE, and the host of our organizations, Dubai Chamber, our local sponsors, China Systems, and CIB. Last but not least, I thank you for your continuing support and for attending this conference, and make it another successful event in partnership with you. I wish you a productive, informative day, and you also enjoy the summit. Thank you for being here today.
Much appreciated, Mr. Chairman, and your support, continuous support, is always greatly appreciated. And just a word about the leadership in ICC UAE and Dubai Chamber. For me, it's actually quite unique, because when we're organizing these events, it's never about the money ever we're going to make. It's about bringing people together for discussion, dialogue, and as the chairman said, argument, counter-argument, but all done in a very positive way. So we all move together. So the summit is on this week, and again, we will have about 400 delegates, 350, 400 delegates from something like 62 countries. And again, it's debate, dialogue, argument, counter-argument, and fun, okay? And enjoying it as we go forward. So I'm going to ask we're going to have a welcome video from the CEO of the IIBLP, the Institute of International Banking Law and Practice, Michael Byrne, and we're going to play this video, which was recorded just a day ago, just to set the scene for the proceedings today. So if we could go ahead and play the video, that would be really, really appreciated. It's nice and short. You know, short is good. I'm very short, and I'm very good, okay?
Everyone, and welcome to the annual Trade Law and Compliance Conference. Welcome to Dubai. It is very exciting to have you all here. I'm very sorry that I can't be here in person, but our spirit is here, and the spirit of these events is here. We have interactive events. We want you to raise your hand, to ask questions, to speak. We are here because of Jim Byrne, my father, and in his spirit is interactions. We want you to disagree. We want you to agree. We want you to participate. I want you to walk out of this event and go, hey, I learned something that I can apply today in my practice. And you will. That's the hallmark of these events. You speak, we have conversations. You're not just being lectured to, you're going to have to participate. And we are very excited to be able to bring this event to you. And again, I'm very sorry that I can't be there, but Vin is here. Vin is right over there. And Vin will take care of you. Vin knows how to run an event like nobody can. And we're so excited to partner with the Dubai Chamber, with ICC UAE. We look forward to a wonderful, incredible, exciting event. Thank you so much for joining. Vin, I'm going to hand it back to you.
Well, thank you, Michael. I think we can give him a round of applause, even though he's virtual.
ICC UAE makes it possible.
Oh, very good. So if I can ask Chiseng and maybe Derek Ennis to join me up here on the podium, and we will just set the scene for you for maybe 15, 20 minutes, and then we will get underway with the heavy-duty proceedings. So good morning, everyone. How are you all feeling? Very good. Well, that's going to change now, okay? because we're going to get into the very boring topics of trade law for the morning, and then in the afternoon, of course, it's compliance and regulation and tales from the trenches. So be ready for a tough day. KP, you already look like you're losing interest, but you're back. Okay. So we're going to set the scene right now and tell you what we're going to actually be doing this morning and the afternoon. After we finished our little introduction, which is setting the scene on key developments in trade and compliance in the last year and setting out some opportunities and challenges, we immediately get back to the basics, okay? So we have a discussion and a dialogue and a little bit of argument and counter-argument between someone who is supposed to be an expert in trade finance, but he's not really, okay? He's supposed to be, and that's me, okay? Supposed to be. And Michael actually mentioned his father, Jim Byrne, who actually initiated these type of events a long time ago, and they became unique around the world. And I just want to say a few words about them and about Jim. When I first met Jim, I was a very young trade finance professional in a bank, and I felt I knew, in fact, in the bank I worked in Ireland, I kind of was the guru, okay? You know, a long time ago. I was. Well, I thought I was, and everyone else thought I was, but I've learned since definitely not, okay? But I remember a little conversation I had with Jim maybe 25 years ago when I really thought I was really hot guy in this trade finance stuff, you know? And I said, Jim, because we'd been at many conferences together and he was giving me speaking opportunities. And I said, Jim, I'm just curious, what do you think of my opinions and my interactions at the conferences? And he said, well, Vin, to be honest, he said, they're better than most people's. I said, yeah, I kind of thought that myself. Yeah, I kind of felt I was a little bit better than most people. And he said, in fact, you're really very good. I said, okay. I said, you know, when I give my opinion on everything, you know, how often do you think I get it right? And he said, oh, you're far better than average. I'd say you get it right about 10% of the time. So not exactly what I expected to hear 10% of the time. And then the years go by and you learn and you experience and you gain knowledge and maybe you lose some friends, okay, as you gain knowledge. And then you may know about 3 years ago, Jim passed away. And before he passed away, we were at a conference together in London. You were there as well, Derek. And as Jim used to say, we should go out because we'd catch up. So he wasn't really feeling very well. So I kind of felt he may not be around much longer, and he wasn't. But as always, he was very good company and lots of fun. So I couldn't resist because I thought he might be departing soon. And I wanted to know how much I had improved over the years, over 25 years. So I said to Jim, I hope you don't mind me asking you a question. I said, but I think I have improved over the years. And he said, definitely. Well, that's a good start. And I said, so if you don't mind me asking, you know, many years ago I said, how often do I get it right? And you said 10% of the time. So I take it you think I've improved, because he was the guru. And he said, you have improved immensely, Vin. So I'm feeling very good. So I said, if I can ask that question again. Now, when I give my opinion, my technical analysis and opinion, what percentage of the time do I get it right? He said, oh, you've improved immensely. I would say 50%. 50. So if you ask me a question today, the answer you're going to get is going to be 50-50, okay? So please bear that in mind, because every time we have an event, someone comes back to me afterwards and said, I followed your advice and it got me into a lot of trouble. Okay, so 50-50. So if you're lucky, you're going to win the case by listening to me, but 50% you need to be careful. So here on my right-hand side, I have Associate Director of the Institute of International Banking Law and Practice, Dr. Sochi Singh. Again, a long-term friend of mine, and Professor Byrne. And maybe she's saying you could say a few words of introduction about yourself, just short.
Okay. Yeah. Actually, I worked in the bank before. Then after I retired from the bank, I work as a consultant, okay, on this trade finance issue. So currently, I'm the technical advisor to the Association of Banks in Singapore, and also associate director of the institute, the IIBRP. All right. So this is about my background. Thank you.
Thank you very much, Chising. And I'll turn to Derek. And Derek, again, has been traveling with me and Jim Byrne and Chising for must be 20 years now, Derek. I'd say 20 years. And Coastline Solution, when they got underway, they brought us a real big innovation. And you might remember it was a DC Pro Focus, and then which was opening up a world of information on trade finance we never had before. And then, of course, the Coastline Solution training with ICC has been so successful in the past. But Derek, just a few words of introduction, even though I've given you a good introduction.
You've pretty much covered it there, Vin. Yeah, no, but happy to be back in Dubai again. We've been coming here with the Institute for 20 years. We travel around the world to the various events supporting the Institute. Sometimes I describe what Coastline does as income redistribution, where we take money from banks for the services and we give it to hotels and airlines. No, but we've been working in this area for so long now. I mean, most of you know what we do in terms of training systems and online systems. But the trend in recent times has been a huge increase in the whole compliance area. So while we're still working in the whole area of the trade operations technical training, there's so much focus now on compliance. So that's an area we're giving a bit more focus to, which is really why I'm here today.
That's great, Derek, and you've set me up nicely for a program, because I said in terms of traditional trade, we have bills of lading as collateral, a discussion dialogue between a trader and a banker, which is coming up. Then that'll be followed by something really interesting, and this is letter of credit guarantee and standby legal cases in the past 2 years. And some of these cases are really exciting. I know you're going to enjoy them. You know, UCP has not been revised for a long time, and a lot of people ask why. So we will be discussing with an expert in the rules on UCP fit for purpose, yes or no, and we'll expect you to join in this conversation. And then coming up to lunch, still on the trade law compliance related issues, we'll be looking at alternative dispute resolution. We'll be looking at DocDex. We'll be talking to a DocDex expert who has worked as a DocDex expert. I told him I would like him to share details of a case. He said he didn't think it would be appropriate, but it is appropriate, but you just don't need to mention the names, so be ready, okay? And then we're going to have a lunch break. Okay, P is smiling again when he heard me mention the lunch. Okay, right, okay. So we have the lunch break from 12:30 to 1:30, and then we're into trade compliance. And then we're going to have a demonstration simulation of UAE Trade Connect, an initiative in the UAE for fighting financial crime and catching duplicate financing on transactions. Very innovative, very creative, and it's up and running, and it's going to be exciting. And then we're going to look at, where's Khalil? ICC opinions that have a compliance part. So ICC issues official opinions on a regular basis. And the opinions provide guidance to the industry. And a few years ago, there were never any queries about compliance issues or compliance or sanctions clauses, but there are now. And we're going to have a look at some of these with Khalil. And then actually it gets very heavy, I think, for a short period of time, because it focuses on what I think is one of our biggest challenges, and that's correspondent banking challenges. And this is the de-risking in emerging markets, but not only in emerging markets, it's de-risking for SMEs who we're all talking about inclusiveness, but on one hand we're saying inclusive, and on the other hand we're pushing them away. So this is going to be a serious dialogue. I'm looking forward to this a little bit later on. And then, of course, we have a networking break, and then we have Tales from the Trenches. And this is where various experts are sharing horror stories or problems they have experienced. Of course, now without mentioning names, but this will be really good. We have senior bankers, we have investigators, we have compliance officers, and it's going to be really interesting. And then we have a launch coming up. If you could hand me the second thing there, yeah, the brown one, yeah. In terms of compliance, in the UAE, a recent guide has been launched on trade-based financial crime, Middle East and North Africa. So this is the last thing we have this afternoon. It'll be presented. This new guide has been launched, and ICC have been supporting this initiative, so we'll be there. And finally, hand me this one, just to let you know, for IIBLP, the leading trade journal, technical, legal, and compliance, I guess, is Documentary Credit World monthly edition. It has been upgraded, new facelift, so please bear this in mind. So getting underway, just to set the scene, she's saying, you know, if I was to say to you, in the last year or so, pick three, but only three critical things that have impacted trade and supply chain finance, but trade finance in the last year or so.
Okay. Actually, I would say, because of this pandemic, I think when it first started, a lot of banks, because of the trading volume come down, so they scale down the staff size. So quite a number of staff are retrenched, okay? Now the business come back, and they try to recruit back these people, and they have difficulty to get them back, because people say they will not want to work for the bank anymore. I have two sons. I told them when they are young, never work for the banks, because I was a banker. So anyway, they are quite successful now. So this is an issue. Now, shortage of manpower in Singapore. We really shortage of manpower. That's why we bring in a lot of foreign talent and pay them high salary. This is one of the issues, cost increase, all right? Second issue, you know, during that period, because of oil price, and a lot of oil traders, they speculate, and end up they speculate too much, they lost and become bankrupt. And not only that, they also try to make use of the LC system to take some money from the bank. I don't use the word cheating. I don't use the word cheating. They try to use the LC system to take some money from the banks. And they are not able to pay back. Okay, this is a problem. So the third one is a sanction issue. Okay, recently there's a court case in Singapore. Of course, the beneficiary tried to appeal. Later on, when we come to another session, I will elaborate more on the sanction clause. Whether we need to provide a sanction clause in our LC or perhaps in our confirmation advice. If you don't do that, will there be any problem? Because it seems that in the court hearing, the judge say, since the confirmation advice given by JP Morgan in Singapore, they have incorporated the sanction clause. Okay, so this become part of the terms and conditions. Listen carefully. Become part of the terms and conditions of the confirmation. So in that case, as a beneficiary, must also comply with that.
Okay, well, Chasing, I know that's a really good teaser, because we'll be talking about this case in detail later. Yeah. But just going back to the pandemic, you know, I kind of want a yes or no answer to this question, okay? Because we'll be discussing it later on. But what do you think? You know, you said there's a lack of talent in trade finance now in Singapore due to being let go and whatever. But a lot of people are saying this can be solved by AI, okay, artificial intelligence. So what do you think? Could we get a robot to do your job? Well, I don't think we could get one that looks as good as you, but maybe brighter than you. I don't know. Will AI solve this problem?
Yeah, actually, I think, say, come to this AI. But it also depends on the future, whether all the trade processing rely on this AI. For example, electronic documents. If come to electronic documents, I believe most of the time the so-called compliance may be handled by the system. Possible, because you just try to match the data. But no matter how, someone needs to write the program. So maybe the future checker become the programmer, who knows?
That's really good, and I remember it must be maybe 15 years ago, or maybe longer, with Jim Byrne, and it was in Singapore actually. We had a session where Jim got 10 bankers, okay, who were supposed to be experienced, and I was one of them. I think you were one as well, to check a set of documents, okay? 10 of us to check a set of documents, okay? Separately, okay? And he gave us 30 minutes to do it. So we managed to do it in the 30 minutes, okay? And actually, when the list of discrepancies came from the 10 people, there were 10 different lists. So you've highlighted the problem, okay?
Yes.
You've highlighted the problem. In fact, in the mention of artificial intelligence, just to let you know, my mother recommended that I should try artificial intelligence because she said my natural intelligence was never really much good. So she said, this new artificial intelligence sounds like something you need to buy, and you should buy it as soon as possible. So I'm looking forward to that day. So Derek, getting back to you, and you've just reminded me of our session last year, because last year you were sitting in the same seat, as I remember, and you were telling us about this, the Compliance Association that was being, what's the actual name of it?
It's the Association of Trade Finance Compliance Professionals.
Okay, Associations of Trade Finance Compliance Professionals. Okay.
Catchy name.
Yeah. If I get my artificial intelligence, I'll remember it. But until then, I have no hope. Okay. But last year, I do remember is like, if you don't mind me saying it, you were saying that how much, how we can bring information to the business community, kind of like DC Pro Focus did some years ago. But at the same time, I asked you last year, well, what is available right now? And frankly, there wasn't much. Okay?
Not last year.
So maybe you could tell us what you've got and why it's of value to the trade and compliance community.
Again, what we've done for many years is the technical, operations-based kind of content, but with the move towards compliance and everything, there's a huge amount of information in compliance, in banking and stuff, but not necessarily related to trade. And a lot of the compliance people don't understand what happens in trade. And a lot of traditional trade people don't know what happens in compliance or don't know what they need to be doing. So we identified this need to create a network of people who are working in trade finance, who are trying to deal with the new challenges of compliance. Last year it was an idea, now it's real. So it's an actual association. There are several hundred members already worldwide. There is a website, and we'll put it through the chat for people who are watching remotely and distribute it otherwise, the ATFCP.com.
But if you have 700 members, like I'm not a member, but I'm curious. But if I was to be a member of anything, I want to know what value I'm going to get for it. So if someone comes a member...
It's all about information and education. Okay. So what we're doing is we have a reporter writing articles specifically on trade finance compliance, and we have a number of news articles every week. It's a live site. This is
so it's not a monthly newsletter?
It's not a monthly newsletter, no. This is a live site. As soon as things come to light, a reporter is reporting on these and publishing them online.
Okay, well, I'm going to check your memory now. Is it better than mine? Maybe you could share one or two stories in the last week or two that might be of interest to this audience. Briefly, and we'll come back to it later, maybe.
Yeah, we'll just kind of give a flavour of a few things. We hear lots of reports in trade finance about commodities frauds and the big things, but the transactions that you guys and the banks are dealing with are so wide and diverse. There are so many areas that fraud or money laundering or sanctions evasion can take place. For example, there was a story last week about a lady in Chicago, and she stole $1.5 million worth of chicken from a school. When the report chicken it's a foul crime.
It's a foul crime, and when she got the money, she flew the coop, I guess.
There you go. Yeah. But when we actually looked into it, it's still being investigated now. 17 people have been arrested for this through Canada. The money has flowed into Lebanon, some through the UAE, through China, through Russia, and they think most of it has ended up in Colombia and Mexico with the drug cartels. So it's a small transaction in terms of the commodity trade or whatever, but it's real money and it's real fraud.
Oh, well, that's interesting. It's interesting you mentioned chicken wings, because I won't go into it now, but I was involved in a case regarding synthetic letters of credit, and Robert is familiar with this case in the audience. So it was regarding a trading company in the US that was supposed to be chicken wings, okay, to the United States. And from the United States under the U.S. Department of Agriculture GSM 102 program. Everything I'm saying is in the public domain, because every time I speak and it's virtual, someone complains about what I'm saying. But it's all, I'm careful, everything is in the public domain. But the beneficiary is in the US, a small trading company, and they're exporting chicken wings per se, but there's no chicken going anywhere, okay? But we have letters of credit being issued in emerging markets in favor of the beneficiary. They're all using LCs, 360 days, okay? The documents are presented, but they're all copy documents. Jin Saibo is paying attention now. He's familiar with this cases, but in a different jurisdiction. Documents are presented, the documents are discounted, and the money doesn't disappear, okay? In these fraud cases in the past, the money used to disappear. The money is sent by the beneficiary immediately back to the issuing bank, but there's no goods whatsoever. So basically, it's a pyramid scheme. The guys were charged with fraud. They ended up doing a little bit of time, but it turned out that everyone was aware of the scheme. So we'll be talking about, it's kind of connected to what happened in Singapore, but not exactly the same story, but we'll come back to that a little bit later. So Derek, in terms of members, can they connect online, or is it the kind of physical events, or what are the plans for the future?
The association there's the website which allows everybody to connect online, stay up to date with the news and stories. For members as well, when you sign up as a member, you also get quarterly technical webinars about what's happening in the technical side of the area, and also news quarterly updates from people in the industry. So you get your quarterly updates, your daily, weekly news, and then the ability to connect. We also then, these conferences are part of what we're doing as well, because people then need to, again, keep up to date with everything. So these conferences are another thing. If you're a member of the association, you get discounts for attending the conferences, discounts for participating in webinars, all that sort of stuff. I have to say, sorry, the basic membership of the association is completely free. You have, you have to join as a member, and then you'll get access to the news stories. And then there are different levels of membership, and depending on which level of membership you want to be, you get additional discounts on some of the other training and conference products.
Okay, and going back to you, she's saying, and you mentioned the pandemic first, okay? Yes, yeah. And with the pandemic as well, the IIBLP events all went virtual. But is IIBLP coming back to Asia this year? In physical, I mean, physical terms. Yes.
Yeah, this year IIBLP will come back to Asia. So we start from Hong Kong. So after Hong Kong, then they will move to Singapore. Coming May.
Coming May?
Yeah.
Okay, well then I may be there for the event in May. And we're going to wrap up this session because in 4 minutes I'm starting with Ashish regarding the bills of lading. And so just wondering, any questions from the audience or any comments you'd like to make? Or may I ask you, I just wanted you to say a word. If I had to ask you, I asked you, but now I'm asking the audience. And I don't need to pass the mic because you can just shout the words. If you had to pick 3 words, which are the 3 biggest challenges for the trade community globally. And don't worry, there's no one right or wrong today. As Michael said, we've different views, different perspectives. We just say what we think in a friendly way. And if you had to pick 3 words, what words would you pick to identify the 3 biggest challenges for trade? Shout, Trinit, yeah?
I can think of just 2 right now. Shrinkage of trade finance capacity, that's a long one.
Okay. Compliance, okay. And I guess we'll be talking about the shrinkage of trade capacity a little bit later on, and I look forward to hearing you on that. And the other one is compliance. Jin Saibo from China?
Yes, if the words I can choose would be the supply chain finance.
Okay, the biggest challenge or opportunity?
Opportunity and the challenge. We use 2 words.
Yeah, you're...
We means risk.
Yeah.
Means opportunity.
Okay. Yeah, you're beginning to sound like my mother-in-law now, so that makes me very nervous. Okay, so Robert.
Yeah, I think one of the biggest challenges is really making trade finance attractive to distribute outside the traditional club of banks that used to finance it. We all know that's got to broaden. We have to get more people interested. How do we make that attractive?
I think that's really important. And you know, Robert, this is one of the reasons the Global Trade Facilitation Summit is happening here, to bring all the development banks and to bring so many counterparties from emerging markets. That's why it's actually happening here in Dubai this week. And this is driven by the vision of ICC UAE and Dubai Chamber, and of course the government of the United Arab Emirates, which wants to be a bridge for trade. We haven't heard from any of the ladies yet. If you had to give me a word of biggest challenge for the trade finance community, what would your word be? Yes, please. AI. Yeah, because she thinks I need it badly, you know. Artificial intelligence. Okay, so is that the biggest challenge or opportunity? Both. Okay, wow. Okay, great. Okay. Challenge and opportunity. You know, for me on AI, there are certain areas where it really works very well. But there are so many other areas where people say it will work and it'll never work. So it's a matter of application for the correct focus. Please, at the back. Yes. Really, yeah. I think we've identified absolutely everything here, and everything you've spoken of here, we will actually be elaborating on today during this event in various panels during the day. Compliance, geopolitical risk, the impact of sanctions and compliance on our day-to-day activities, de-risking, correspondent banking, legal cases, and of course we will also be talking about technology a little bit later, and I'm sure someone is going to mention artificial intelligence. So with that, we're on time, unless you have a final word or you'd like to say?
Okay. Let's come to this compliance. I think this is one of the biggest challenge, because the issue over here is that you have to screen through all the transactions you have, and say, for example, you check because of the regulatory requirement, so you want to check whether sanction or not. Subsequently, nothing. Okay, nothing happened, but you discovered that, let's say, the BL is fraudulent. Then the reason is, under the UCP, the provision, banks should not go beyond the documents. So if you discover that the BL is fraudulent, will you reject? It happened in Singapore many years ago, and the bank checked but discovered that the airway bill is fraudulent. So the confirming bank refused to honor. Okay, beneficiary subsequently sued the bank. Beneficiary said, fraudulent, yes, but I'm also a victim. I did not participate in this fraudulent event. I'm a victim because I sell under EXW the airway bill provided by the buyer. So I presented this airway bill together with my documents to the bank. Banks do not go beyond the documents. First hearing, the bank won the case, but beneficiary not happy with the judgment and appeal. Court appeal reversed the judgment and said, sorry, banks should not go beyond the documents. So we may face a big challenge over here when you discovered, oh, this BL is fraudulent, but you have to find out evidence whether beneficiary had participated. If no, problem.
And actually, she's saying we're going to finish, but at these events we discuss all of these things. And someone made a comment last year. It was a very good comment that Mr. O'Brien, your opinion is very, very useful. She's saying your opinion is very, very useful. But could we please have an expression from the ICC itself on dealing with trade fraud and how to manage trade fraud? So this year, the grand finale of the Global Trade Facilitation Summit is a lecture organized by the Institute of Chartered Shipbrokers with ICC, and we have the director of ICC Commercial Crime Services, okay, coming here to address this directly to the audience. And when he came, before we were speaking, I said, are you prepared to answer direct questions from the audience? And he said, yes, but of course I will not mention any names. So this will be the high point of our event. because we hear from you is what we need. And this will be on Thursday, I think about 3 o'clock KP in the afternoon on Thursday. So with that, Derek, let's find a quick word.
No, very quick. I think the few things we've touched on are going to come back during the day in more detail. But picking up on geopolitical risks, for example, I mean, that's a huge area. One of the things that a lot of banks have been working for 10, 20 years dealing with sanctions, for example, for Iran, for North Korea. But now you're dealing with new things in places like Russia and Belarus, which are brand new, they're evolving. Even last week, OFAC named another 13 banks in Russia that were being sanctioned. So it's evolving, and I think for banks dealing with these changing geopolitical things is a big issue, rather than older things we're used to.
So as practitioners, we'll be talking about it today, but even during the summit, we have a presentation from a real sanctions expert, and it's on the ever-changing sands of compliance. So it's how to give some guidance on how to navigate your way through this. And so, yeah, absolutely very, very important, Derek. So, gentlemen, I'll say thank you, and I'm going to ask Ashish to come up here and join me, please. Thanks a lot. Can we give them a round of applause, please? Yes. See you later. Thank you, Chairman, and we look forward to seeing you later during the summit. Thank you very much. Thank you. So, everyone, how are you feeling now? Getting better? Yeah, good. So, I think you're okay there, KP, for now. Yeah, but you're like the referee here today for this session. So you all know me, Vincent O'Brien. I'm Associate Director of the Institute. I'm also Director of ICC UAE. And I know actually at least 60-70% of the audience for quite a while. So I'm among friends. So it's really nice to see some of you hadn't seen for quite a long time. So I'm among my friends here, but then I look over here at this guy. I don't know. I don't think I can hold him in that category. Okay. No, Ashish is one of my best friends. But Ashish, just give us a 30-second, 1-minute introduction of your background.
So I'm basically a trade finance consultant. Consultant is I think, sophisticated word. I'm a trade finance broker, and we deal with trade finance products, typically post-shipment, typically bank risk. And last few years, to survive and make some more money or make money, we have got involved in the supply chain. So we provide end-to-end solution for standard commodities like edible oil, from the Indian perspective, edible oil, export of rice, and things like that.
So we're here to talk about something that you all learned the first few weeks during trade finance. So it's on one level really, really basic, and on the other hand, it's mission critical. So you'll see on the stage here, there is a ship, okay? And that's there for a reason. That's there to focus your minds, okay?
You made that ship, or?
Of course I made it. I can make anything I decide to make. So yeah, I made the ship. No, I didn't make the ship, okay? So we're going to be talking about the bill of lading. And again, that's why it's so basic, okay? So don't get too bored, please, okay? It will promise you be kind of interesting. And later on, when we get talking about the cases, okay, such as the cases in Singapore and elsewhere, what we're talking about now is really important, okay, even though most of you know it already, but I just want to go step by step. So actually, from the trading background, and he's on the other side, I'm on the trade finance, I guess, the banking background, we want to talk about bills of lading. And while not specifically, we're going to talk about bills of lading that would relate to a chartered vessel like this one, you know, and I'm no expert in ships, but KP is here to correct everything I say wrong, okay? So, for example, if we have a chartered vessel, when the goods are shipped on board, I guess we'd agree that bills of lading will be issued showing the goods are shipped on board, okay? So let's talk about a bill of lading. Would you agree with me, Ashish, that a bill of lading is evidence of a contract of carriage?
Yes, it is.
Yeah, I think.
And if it comes to evidence being the key word, and if it's a standard commodity, then the charter party contract will provide evidence of carriage and therefore be the shipping contract.
Okay, so the bill of lading, we all agree, is evidence of contract of carriage. Okay, this is what you learned years ago. And then you'd also agree with me that when this bill of lading is issued, it's a receipt for the goods being shipped. Yeah.
Yes, issued by the carrier to the shipper.
Oh, okay.
In respect of the goods shipped.
In respect of the goods shipped. Okay, well, that's easy. We all agree so far. And then you'd agree with me, the third one we all learned years ago, that the bill of lading is a document of title. Yeah, you'd agree? It's a document of title? Yeah.
It's not so straightforward. And
no, but just would you agree?
Yeah, okay.
Yeah.
But if I may add quickly.
No, you may not. Okay, it's okay. So, do you agree it's a document of title or not? Okay, it's like the CTCS exam. Okay, do you agree? Yes or no?
Okay.
Yeah. Okay.
If you insist.
Okay. Okay. So it's a document of title. So this makes it kind of sound like it would really be a good. It sounds like it would make it really a good document as collateral in trade finance. The evidence is pretty good, I think. No, very good. The receipt, good. But this documented title thing, so it would be pretty good collateral for a bank in financing import of a commodity.
Yes, particularly for commodity financing transactions. However, it depends how the BL, in which manner it's proposed to be used in structuring the trade finance transaction. How you intend using it.
Now you're getting complicated. So we got to wind back the clock one more time. Okay. So let me give you a scenario. Okay. So we have an importer in Singapore, because we'll be talking about Singapore later. Yeah. So I may as well say Singapore, but I could say anywhere. Okay. But we have an importer in Singapore, and I'm looking at the ship and the importer of oil. Okay. Yeah. So the importer of oil most likely is going to issue a letter of credit.
Yes.
Yeah, and we all no need to explain what's a letter of credit. And that letter of credit, the documents required, maybe commercial invoice. I guess it depends on the Incoterm. Or do you think the Incoterm is important?
Incoterm is important, yes.
Yeah. Okay. Well, if it's an oil shipment, very often it will be a CIF shipment, and in cases later on, they're all CIF shipments. So, what does CIF is cost, insurance?
Yeah, we need to know the minimum from the supplier's perspective when he has delivered, when we can say he has delivered. So Incoterm is important.
Okay, so when the goods are delivered. Okay. Now that is a very interesting word, when the goods are delivered. Okay, so here we are. The importer in Singapore, we'll come back, KP, in a little bit. I just want to cover the story first. The importer in Singapore goes to the bank, they do a credit assessment, they issue the letter of credit. The letter of credit is calling for documents required, invoice, insurance, full set clean on board, bills of lading, charter party bills of lading acceptable. Okay. The letter of credit in my particular case is available by deferred payment. Okay, deferred payment, and we'll say it's available by deferred payment at 120 days, but it could be different, 120 days. The LC is issued, the beneficiary gets the letter of credit, the exporter ships the goods, and then, of course, the bills of lading are issued, shipped on board the named vessel at the port of shipment. It takes a month from the goods to get from port of loading to port of discharge, typically Europe to Singapore. Okay? So getting back to the bill of lading as collateral, the goods are shipped, the documents are then presented to the bank, okay? And in terms of, and I guess there would have been a pledge agreement with the applicant at the time the LC was issued that the bills of lading would be pledged as collateral. So just trying to get objective here, when the documents are presented to the bank, including the bills of lading, how would you rate the collateral of that bill of lading or the bills of lading at that period of time?
At that point in time, I think the bank is probably at its best in terms of security. If it wanted, it could go and take delivery of the goods itself from the carrier. Of course, practically, it doesn't work that way. You'll endorse the BL to the applicant, who will then go and take the delivery. But if it wanted to, it could go and take delivery.
Okay, so the bills of lading are consigned to the order of the bank. Yeah. At that point in time, the bank...
Yes, could take delivery, and therefore it's best in terms of security.
Okay. At
that point, yeah.
Okay, and as a banker, I generally don't like buying and selling oil, but if things had deteriorated, it would be good to have this. Yeah. Okay, I'll agree. So, and as you kind of inferred, in day-to-day trade, what is going to happen is the bills of lading are going to be endorsed because the applicant needs the oil, and then we have a maturity date coming up at least 2 months later.
120 days, you said.
Okay, 3 months, nearly 3 months later. He's listening. This guy is paying a lot of attention. Okay. So now the good bills of lading have been endorsed into the hands of the applicant. The applicant has collected the cargo. So now time passes, 2.5 months or whatever it is, okay? And now we come to the maturity date, okay? And on the maturity date, we take a credit risk when we issue a letter of credit, although some banks seem to have forgotten that, okay? So when we come to the maturity date, how good is this collateral for that shipment of oil right now? Generally speaking, in most cases.
Well, if the applicant funds his account, then it's good security.
Yeah, but no, but I'm coming to the situation, he doesn't have any money in his account because we take a credit risk and we're looking at the price of oil that has gone into minus territory during these cases. How good is that collateral?
So there are two ways to look at it. Please allow me. Okay. So we don't know if the beneficiary, you have not mentioned whether beneficiary took prepayment, requested prepayment from the LC Bank or not. If it doesn't, if it didn't, then it's fine.
Let me clarify. Actually, let me put you in the spot a little bit more of your own jumping in the spot, but it's a good point. The document, it was available by deferred payment. The documents were presented, and you said it's pretty good collateral. But being a smart beneficiary, as I would be, or all my customers would be, I would have asked to prepay or discount. So I would have discounted the letter of credit. So if I discounted, would I get that money without recourse?
A beneficiary would prefer and would always insist upon, without recourse.
Okay, don't use prefer.
Insist.
Okay, insist. So if it's an issuing bank or a confirming bank, I get the money without recourse. So back to the end of the story now. We're on the maturity date of the 28th of February and the applicant has no money. How good is this bill of lading as collateral?
Well, we don't know what happened to the cargo. We don't know whether it was
oil.
to a third buyer. It was commingled. For all we know, it's up in the smoke. So your guess is as good as mine,
Okay.
So the bank has the problem. Of course, since the BLs were presented to the bank, there is a pledge agreement which you mentioned. So I guess there will be a legal right of pursuit in almost all jurisdictions. But practically, and you have not mentioned any other collateral that the applicant gave to the bank.
Yeah.
So I think this is not a very good place for the bank to be in.
Okay. And there's a very, very important point here. And this important point is the benefit of that. The benefit at that time is if there was misdelivery by the carrier, and KP, you can join in anytime, as a bit now or a little bit later. If there was misdelivery by the carrier, there is some value here. But if you have to follow the carrier, and this is from my experience, sad experience, and I succeeded. But if you're following the carrier and if you win, you now have a credit risk on someone you never assessed.
Yes.
Yeah? And that's a dangerous place to be. Now, I want to move our story on just a little bit, and KP can join in. Please, KP, I'll give you a microphone, KP, please. And briefly, but by all means, we need your input, Thank you.
Yeah, thanks, Vin. I'll go back to the question you asked, Ashish, whether the bill of lading is a document of title.
Yeah.
I would say perhaps not. It's only a possessory title.
He allowed you to speak. He didn't allow me to speak.
Yeah. It's only that's why I'm coming in. Yeah.
Thanks for coming in.
Yeah. It's only a possessory title which those stakeholders in the chain have. When I say possessory title, because classically we learned that BL is a title of goods. Right?
Okay.
When I say possessory title, it means that, okay, let's say the buyer gets the bill of lading, but he has got another, as he said, 120 days to pay.
Yes.
Unless he pays, he doesn't own the goods. When you say title to the goods, you mean that he owns the goods, but he has not paid for it, so he has not really, he doesn't own it. So he has got the right to possess it, maybe use it.
Yeah. So
but he gets the title only when he pays for it.
Right. So just to clarify, because you're absolutely right. You're absolutely right in 99.999% of the cases. So when we say documented title, from your explanation, it means the lawful holder is entitled to take delivery.
That's
but that doesn't mean they own it. The ownership will be in the contract from...
You have to infer from the contract. So title passes when the parties intended to pass.
Okay.
Now, you mentioned contract. Yeah. This is where I wanted to come in earlier part of the discussions, because very often before even discuss whether bill of lading is a real collateral for documentary credits or credits offered, very often what I have come across is the stakeholders, whether it's the traders, the buyer, the seller, the banks in between, the financiers in between, they all mix up the contract of sale and the contract of carriage.
Okay.
Mind you, these two are very different contracts entered into by different parties with different objectives, different terms.
So,
and the mix-up of these two contracts get the bill of lading into a complex mix of misunderstandings.
That's very helpful, KP. And then just to summarize so we have it crystal clear, document of title means entitled to take delivery. The ownership of the goods will be determined by the contract, if there is a contract. That's really, really helpful. Really, thank you. So now just to go back.
Just to complete
very
that.
short.
Yeah, very short. Theoretically,
yeah,
and it doesn't happen in such large value contracts, but theoretically, even if the title clause is not there in the passing of title is not mentioned in the contract,
okay,
then we would have to see, like KP said,
yeah,
payment from buyer to supplier is when the title, in most courts, I think, I'll stick my neck out, will say that is when the title changes.
Okay, but let's just keep it very simple for now.
Yeah.
There is a contract, okay? Otherwise it gets unclear,
sure.
okay? There is a contract. Now the next point I want to make is, because it's just setting us up for our discussion later. Going back to our letter of credit case, the documents are presented to the bank, the beneficiary has discounted, he got the money without recourse. Now we fast forward to the maturity date. Okay, so what would happen if, for example, it's on the maturity date and the customer came to the bank, you're the customer, and said that, for example, I would like a trust receipt loan.
Yeah.
What do you think of the trust receipt loan?
So different jurisdictions, there are different interpretations of meaning of trust receipt. But really, whatever...
That's also very important. It's very different in the UAE to Singapore, for example. Okay.
India, there is no trust receipt, very negligible trust receipt funding.
Okay.
Okay.
So if
basically, if the BL, I have given you the BL.
Oh, okay. So,
or let's say you are the banker, you have given me the BL, and there is no other collateral that you have.
Okay.
And if I run away with the money, I go bankrupt or I become rogue. Honestly, there is very little you can do.
Okay. Now I want to change our scenario a little bit, and I'll be finished in 5 minutes, so bear with me. But this is really important because I've been involved in so many cases where I've heard so many guys working in banks say ridiculous things about documents of title and costing banks lots of money. So this is really important. Okay. And I'm not saying your clarifications have helped a lot, KP. Now, imagine this letter of credit is issued and it calls for, as we said, CIF contracts, as you said, CIF, invoice, insurance, and bills of lading. But then separately it says in the additional conditions, in the event that the documents are not available, the beneficiary may present a commercial invoice and a letter of indemnity addressed to the applicant.
Not
now,
to the bank.
I'm saying bold underline applicant for a reason. Okay. What do you think of that collateral?
Well,
is that a secure transaction or unsecured?
It's just, if you compare to the previous situation, there is a legal right of pursuit. This will be even weaker in this situation. Because if in the event, like it happens in oil trades, the BLs never get presented before the expiry. So if he is financed on the basis of just the LOI and he never sees the BL, so the legal right of pursuit is far weaker, despite the pledge agreement or whatever agreement notwithstanding.
I think that's a really important point. And KP, to come back to you, imagine I am a bank, okay? And the importer has gone bust, okay, whatever reason, okay? And then I learned that there was misdelivery of the cargo by the carrier. Now this is changing the story. But let me finish. If I know there is misdelivery of the carrier by the carrier of the cargo, but as a bank, I don't have any bills of lading at all in my hands. Am I in a good position? Or I've financed him for sure, but I never got the bills of lading, ever. Am I in a good position or in a bad position?
You are definitely in a bad position because the presentations criteria demands you to present the original bill of lading.
Okay.
And many a times, almost I would say very often, and this become quite rampant, I would say, in the last 20 years or so, the carriers deliver the cargo to the so-called consignee. I'm saying so-called because that itself is not very clear document in document terms, on the basis of a letter of indemnity from the charterer, who may not be necessarily even the buyer or the seller. The charterer could be a different entity.
Yeah.
So the carrier delivers a cargo on the basis of a letter of indemnity from the charterer or from the seller or the buyer, and without any kind of backup for them. You know, that means if a different bills of lading is presented, or the BL, as he says, is not presented at all, the carrier is also on a very weak wicket.
Okay, but as the bank, if I don't have the bills of lading at
Then
all,
you cannot. Yeah, you cannot.
Oh,
Yeah, you are
Yeah,
in
please.
you are not in a good. Is not where you want to be. Okay, so if you have no other collateral, he runs away or he goes bust, whatever. You are in for trouble.
Okay, now this is really, really important because on one hand, what we have discussed, you all know already. You all know already, okay? But on the other hand, by making a fundamental flaw in the understanding of the cycle of the transaction, banks have lost billions of dollars. So KP just struck me there, you know, you guys issue these bills of lading in a set of 3. And I kind of understood it, you know, 25 years ago when I was thinking about sailing, well, longer than that, sailing ship. But why are you still issuing these bills of lading in a set of 3? Surely one original will do everything that it needs to be done.
That's probably because if I am a trader and I am taking a documentary credit, I probably, either the bank gives me one of the past used LC format, or I myself may have one of the older ones, and I keep continuing, where in today's world you just do not need it. About 30 years back, I fought with the shipping line saying that I do not want 3 bills of lading. I want only 1. And I had to really fight hard to make it happen.
It's just custom and practice.
It's just
been
that
going
practice.
on.
Okay, so, but if it's just custom and practice, it could be changed and the system...
Can be, yes. I would say actually the bankers here would say that, change it saying that we want only 1 bill of lading. What does the second and the third, what function do they play? What role do they play? Nothing. They just go along with the first one.
Okay,
Whichever is the
so
first.
good. So I'm going to finish this session just in a moment, and then we move on with actually the cases, which is a nice follow on to this. Is in a lot of these cases that have come up, the question was if when it was oil being bought and sold, bought and sold, bought and sold. And remember, I said this journey could be a month, okay, from Europe to Singapore. So, you know, people talk about the oil was financed 17 times by 17 banks. That's normal. That's normal, okay? Sell one seller to a buyer, their bank will issue an LC, sold again, their bank will issue an LC, okay? So this is where there's a deep misunderstanding. But in these cases that come up, I don't know will it come up in the case that's coming up right now, is there was a question of whether the oil was ever really delivered, right? Whether the oil was ever really delivered. So in all of these cases that came up in Singapore, the recent ones, the oil was actually shipped, okay? Now I haven't answered the question, okay? The oil was actually shipped, but the question was it really ever delivered into the hands of the buyer? So then I'm coming back. I'm going to come back to you, Ashish. And if it was a CIF contract with the goods shipped on board an IM vessel in Lithuania, and then the ship goes on to Singapore, and the bills of lading are presented in court showing shipped on board, when exactly were the goods delivered?
As far as it's a CIF contract, he loaded them onto the vessel. It's delivered. May I add?
Please.
Okay, so there are 2 perspectives, 2 angles when we are discussing this case. One is purely from the bank risk for financing part of it.
Yeah.
Then you worry about collaterals, BLs, whatever, whether shipment took place or not, multiple funding, whatever. The other and equally important is the letter of credit which got issued and credit compliant documents, even if it was LOI, got presented. So LC once issued, you know more than anybody else, is an independent creature by itself. So you present documents, the bank is obliged to honor, undertake like a payment undertaking, deferred payment undertaking in this case. So these two angles, they have to collide. But at the end of the day, if the bank has issued the LC, you know, it has to honor, period. So so there are two separate things we are discussing. Not separate, but interrelated, but there are two elements to this.
Wonderful. I'm 5 minutes over time, actually. I thought it was till 30 minutes past. So I'm going to actually finish. And it's good to highlight the bill of lading is not exactly what most people actually think it is. And at the moment, there's a lot of talk about digitalization. My last comment, and unless, we'll move on. Talking about digitalizing bills of lading, okay? But really, like, if 3 are being issued and we only need 1, okay? And if it's not fulfilling the function that we think it is, people are trying to digitalize something that is not working well already. So we need to redo the workflow. We need to actually re-engineer the process first, and then you apply the digital technology afterwards. But this is something we're going to talk about, and I think only one person in the audience is really keen to talk, and that's Pavel. So you can make one quick comment if you'd like, and KP will give you the microphone if you mind. Just quick, very quick.
In relation to electronic bill of lading, I certainly see we should, and we will most certainly have only one transferable electronic bill of lading. I don't see any reason to have the same 3 like we have in paperwork. So certainly it should be done differently in electronic space for sure, to some extent.
Absolutely, because it's not really about the document. It's really about the data and triggering the change of releasing cargo to a party, or alternatively the transfer of the right to take possession of the cargo, not ownership.
Can I ask you a quick one?
Yeah.
Can the world survive without the electronic BL as it has been surviving? We just carry on with life as it is, or do we desperately need an electronic BL? How do we know there will be no fraud there? For sure.
Yeah, I think we should really clearly differentiate between, let's say, liner bill of lading for consignment shipments, when we most likely don't need it, in most cases at all. So C-way bill would do, and certainly it can be done differently. And when it comes to charter party bill of lading, we certainly need this document of title, and we will.
Yeah, we're going to move on because we're out of time. But Robert, just one quick comment, please, and then we'll move on to the next section.
Yeah, just a quick one to follow on Pavel's comment there, and that's that you'll have seen that the Digital Container Shipping Association's membership, which comprises all of the big box carriers, have committed to fully digitize bills of lading for their business by 2030, which is a pretty bold ambition given where we are now. So that's 7 years to be 100% digital. The answer is we do need to digitize. There will only be one electronic record. We will do things differently.
Wonderful, wonderful. So with that, I think we'll move on. We better, because we'll be behind schedule. But I think in our next session, if you have a question on this, it'll fit in the next session as well, because it's kind of an extension of this one. So thank you very much, Ashish and KP, for your clarifications. And sorry for being a few minutes late. But Robert, we're going to get you on board here. And again, we'll be looking at LC standby legal cases. But I think LC cases and bills of lading will feature quite a bit in this, Robert. So thank you very, very much. Thank you.
Thanks very much, Vin. If I can have my fantastic panel, please. Suchi, Pradeep, and Jin, come up and join me.
And KP, I'm sure you'll join in a little bit in this one as well, just bills of lading appearing.
Vin, do you want to look after this one? Thanks a lot. Okay, ladies and gentlemen. All hear me okay? Good. Thanks very much indeed. Thanks for my panelists who've flown in from various parts of the globe to join us for this event. Just say what a delight it is to be back in here. As Vin knows, this is my favourite auditorium in the whole world, probably the best view from any podium or from any audience area, I think, anywhere. So thanks very much indeed to ICC UAE for hosting this, and we're very much looking forward to the rest of today. We're going to be looking at a number of cases. We're going to pick up, first of all, on the theme that Vin was just covering in that last session, because the cases we're going to look at, and we've been sharing some materials amongst ourselves that we're going to discuss with you. I'm going to start off by talking about a case which specifically deals with why bills of lading are important to bankers. I know Jin's got a case in the Chinese courts that he's going to talk about as well on standbys, and we're going to look at two of the big cases over the last couple of years, which have looked at how in letters of credit, bills of lading, how they're provided for, what the alternatives to producing them are, have affected the rights of both the banks and the underlying parties. So we've got a couple of slides. I'm going to talk about a case which is not that recent, but in terms of framing how we're going to discuss the rest of this session, I think is very important. It's a case called the UU 902, and just give you a little bit of background on this. FGV Trading was both the charterer of a ship called the UU 902, and it was also the owner of a cargo of palm oil that was being carried from Indonesia to India on board that ship. And FGV had sold the cargo to a company called Avanti Industries. Avanti had in turn sold it on to a company called Ruchi Soya Industries. Now, when it came to the business end of this transaction, the money part, FGV sent a bunch of shipping documents which contained 14 blank endorsed bills of lading on a documentary collection basis to Avanti's bank, which was OCBC, obviously a major bank out in Singapore and generally in the Far East. And so those bills of lading were going through a documentary collection basis, subject to the uniform rules and collection. When they arrived with OCBC, Avanti applied to OCBC for a particular type of loan that's very common, and Sochi will know, very common in the Singapore market. I first came across it about 20-odd years ago. The oddity about a trust receipt loan, or TR loan, as it's often referred to in the market, is that it's not anything like what letter of credit practitioners have come to talk about in terms of the use of a trust receipt. Many of us who've been familiar with letters of credit over the years know that a trust receipt is typically given out by or signed for by a party when the bank is asked to release bills of lading and documents that it already has, where actually a TR loan, and so Chichi will confirm if I've got this right, is very often signed for at a point where the bank hasn't yet actually received the bills of lading. Well, in this particular case, the bills of lading came in, Avanti applied for a loan, and the vessel in the meantime had arrived, and it had discharged all of the cargo against a letter of indemnity. Why had it used the letter of indemnity to discharge the cargo? Well, because all the bills of lading were sitting in OCBC's office, and they were deciding how they were going to finance them. In the meantime, the ship had arrived, and as often happens, you can't have ships lining up out into the roads at the discharge port. A letter of indemnity was produced, the goods went off the ship, and they went off to be used in whatever they were going to be used for, cooking, cattle feed, whatever. And at that point, the loan was agreed, and the funds were then paid by OCBC to FGV. So went through to FGV's bank, which was Maybank. They received the purchase price, and the loan agreement was effectively cemented between OCBC and Avanti. So what happened next? And of course, we know the story many times over, what was happening out in Singapore, 2019, 2020. Avanti defaulted on its loan obligations to OCBC. OCBC were obviously pretty alarmed by this, but they weren't that alarmed. Why? Because they still had the original bills of lading, which had been given to them in connection with this financing. And as everyone knows, bills of lading in the drawer means happiness for the banker. So they were quite happy with that. They presented them to the owners of UU 902 and said, "We'll have our cargo of palm oil now, please." Of course, the cargo of palm oil had gone. It had probably been consumed by that date. And anyway, they were taken away. The ship owner could not deliver the palm oil. It was no longer on the vessel. OCBC sued the ship owner in the Singapore High Court, and the ship owner came up with a number of arguments. I'm familiar with these because I've been involved in litigation during the last 20 years involving a Singapore bank, another Singapore bank, in exactly similar circumstances. The first argument was that the bills of lading were spent. You know that if you look on a bill of lading, there is a bit on it which says, this bill of lading is issued in 3 originals, any one of which, when presented, discharges the other 2. So basically, or once the goods are delivered, they're presented, that's it. However, there was a second argument. They said also, in addition to the fact that the bank did not get any rights to sue because it didn't become the holder of the bill, they said OCBC acted in bad faith. Why? Because they knew, or perhaps ought to have known, that the cargo had been discharged before they lent the money. They actually advanced the funds after the goods had left the ship. And thirdly, they said OCBC consented, in effect, to discharge the cargo without bills of lading because of that knowledge. So what did the court say? Well, the good news for trade finance bankers is that the court's decision was, yes, the bill of lading still is king of documents. It is valuable. In relation to the no right of suit argument, the court said that the bills of lading would actually only become spent when they're delivered to the person entitled to take delivery. And because the goods actually left the vessel under an LOI, they didn't go to the person entitled on the face of the bill to be delivered because those were in the hands of OCBC as holder of the documents. The second point, very interesting, is that they said OCBC became the holder under the Singapore's version of the Carriage of Goods by Sea Act, which is the Bill of Lading Act, pursuant to a contractual arrangement which was the loan facility, that TR loan facility, and that was entered into before discharge. They'd agreed the contractual basis for lending the money. And this is a peculiarity for those familiar with carriage of goods by sea law, is that under Section 2.2 of both the UK legislation and most legislation around the globe, provided you've agreed the contractual basis before you lend the money, then that's fine. And that actually also applies, for example, in one case where documents end up being held by a bank because, for example, they've been presented and then rejected. And then they get back into the hands, for example, of an advising bank or a financing bank whilst the goods, in the meantime, being discharged. provided the arrangement, the contractual arrangement, which led to you holding the documents, was entered into before the goods were discharged, that's good enough. So on that basis, the court said, you, OCBC, do have a right to sue the ship owner. From there, it was downhill as regards the ship owners were concerned, because the idea that they weren't the holder of the bills in good faith didn't wash with the courts. The court said there was no evidence that OCBC knew it was financing after discharge. It didn't have people following the boat round the world or someone on the quayside checking that goods had been discharged. They're simply presented with bills of lading. It's reasonable for them to assume, if the bills of lading are there, that they're entitled to finance them. Why? Because everyone knows that under the presentation rule, as it's called, in bills of lading, that a ship owner is only entitled to discharge cargo to someone holding one original bill of lading, which of course is why we're in such a mess as regards how we move forward, and why digitization is of course so important, because in so many cases that original bill of lading is not at the discharge port in time for the goods to be discharged. And the idea that OCBC consented to the discharge, again, got short shrift from the court. The court said there was nothing that OCBC did in relation to financing this which indicated that they somehow consented to the idea. Another argument that's very often put up, but again which doesn't work and didn't work in the case I was involved with, didn't work here, is the idea that it's common knowledge that goods will be discharged by a letter of indemnity, and on that basis that any bank financing against bills of lading takes with the knowledge that the goods will have been discharged. Again, courts, time and time again, have rejected that argument. And so all the arguments failed. The ship owner was liable for misdelivery of the cargo and effectively had to pay up. So I'll briefly pause. Sochi, did I get any of my explanation of TR financing wrong?
Oh, no, you're right. In actual fact, for this particular transaction, involved 3 LOI, back-to-back LOI. The buyer, Ruchi, is in India. Avanti is a company in Singapore. FGV is a company in Malaysia. And FGV is a state-owned company, Malaysian government state-owned company, all right, FGV. So FGV chartered the vessel from a shipping company, okay? So what happened is, this transaction, the cargo has been discharged because of the LOI provided by FGV to the ship owner. So ship owner, because of that, when cargo arrived, they discharge the cargo without the BL. Then for Ruchi, they have provided an LOI to Avanti. So Avanti, after received the LOI, they also provided an LOI in favor of FGV. So because of that, FGV applied for LOI, issue an LOI in favor of the ship owner. This is the background. So because of that, OCBC knew nothing about all this. So what they receive is only documentary collection from Maybank Malaysia. All right, they are instructed to deliver documents against payment. All right, so because Avanti applied for trust receipt financing, so OCBC said no problem because they have facility. So, but they hold the BL as security. All right, so this is the background. So what happened is that when OCBC approved the loan and after that remitted the money to Maybank, OCBC had no knowledge that the cargo had been discharged. They had no knowledge, but they thought they have the BL, I have the title. So this case also have also taught us one thing. A lot of times, I hear a lot of people saying, charter party is not documents of title, but for this particular case, it is not true. The court said, no, this is charter party BL, but still a document of title because it is negotiable. Issued to order, blank endorse. All right? Interesting case, actually.
And one actually, very quick bit of terminology explanation there. You heard Soichi talking about a charter party bill of lading. Very important. Many bills of lading are issued by charterers under a permission contained in the charter party to issue bills of lading in the name. So if you look at the bottom of a GenCon bill, typical voyage charter party bill, it says that it's issued on behalf of the ship owner. That's different from a charterer's bill of lading, where it's absolutely clear at the bottom of the page that it's the charterer that's liable. Okay? One thing just to bear in mind. But actually, 100% agree with what Soichi said. Jin, you're familiar with the case. Any sort of nuance of that from the point of view how you see things in China?
But in this case, you know, we Chinese is quite familiar with the trust receipt finance, because in China we have dozens of court cases about trust receipt. We do have a very similar case happened and judged by the Supreme People's Court in 1940, in 1915, in the Supreme People's Court, and the Construction Bank of China, they holding the original bill of lading in their hands, but in the same time, they sign the trust receipt with the applicant. But Construction Bank of China, they just holding the bill of lading in their hands. They don't release the bill of lading to the applicant. So they just holding and look like stupid, you know, because at that time, the applicant doesn't have enough money to pay back, to purchase the bill of lading from the Construction Bank of China. And finally, the applicant go into the Chinese court to apply the bankruptcy. So in the same times, the Construction Bank of China, they holding the bill of lading, but they have faced several competitive creditors. One is the creditor who against the applicant. The two is when the goods is on the storage on the port, and the port charge huge fees of storage, and another creditors seize the goods on the port because the creditor in another city said that the applicant owed money to them. So at this time, Construction Bank of China, they have different competitors to competitive with the assets, the bill of lading, and the bill of lading representative the goods. So Construction Bank of China, I think at this time, they face very complicated legal procedures in this city and another city, and the case in another city and this city, and the bankrupted procedures in another court, because in China, we have a special court responsible for the bankrupt cases. So that's why, you know, trust receipt finance, you know, the bill of lading as a collateral for the bank is so important, because you are find that you are very trouble, even because you have already paid the bill of honor the letter of credit, but the client doesn't pay you back. So fortunately, the Supreme People's Court said that under these circumstances, the rights who holding the bill of lading, I mean the Construction Bank of China, under our Chinese law, is not the ownership, is not the ownership on the bill of lading or the ownership of the goods. The bank just have a rights of pledge against the bill of lading and also the goods. So under the Chinese priority rules, the Construction Bank of China, they have the first priority against another another competitive creditors. But the port who provided the storage service, they have the rights, but their rights is before the priority than the Construction Bank of China. So in China, we have a very, you have a very, sometimes for you maybe, but for us, it's still very complicated for the priority rules. Who is first, who is the second, and the queue, it's very important in your business. That's my comment.
So before any banks are doing this business in China, they better talk to you, I think, Jim. They should talk to you first.
Yeah, I took 18 years to write a book.
May I add something
about this?
I honestly, just given the time, Robert, I think we'll move on to UniCredit, but then we'll get Pradeep's feedback on the UniCredit one first, because we'll run out of time.
Let's.
And I think it's more exciting.
Before we move on to UniCredit, I have only one point here on the EU case. So basically, what happens is Jin has very rightly pointed out that it's kind of stupid to finance under a trust receipt loan and then hold the bills of lading as a pledge or as a collateral. Because normally what happens is that trust receipt financing is done when the bank wants to facilitate the delivery of the cargo to its client. In Middle East at least, or in the Gulf countries specifically, whenever you finance under trust receipt, you give the documents, the original BLs, to the importer to take delivery of the cargo. So anyway, it was theoretically this was a collateral, and the court pointed out that the good news was it was not a simple loan. It was a trust receipt loan, whereby a pledge was created. And since OCBC was holder of the BLs, or lawful holder of the BLs, it had the pledge. In GCC countries, the trust receipt means you deliver the cargo to the importer or to the borrower, and he holds the goods in trust for the bank. So this is an implied pledge, basically.
I think the important thing here is if you're looking at something called TR or trust receipt financing, work out the terminology first, because it does mean different things in different locations. In Singapore, it means something quite different than we think it means everywhere else. But I'm going to ask you, do you want to quickly talk about the facts behind the UniCredit case? I'm very happy to intro them quickly otherwise.
No, you please go.
We've already talked a little bit about this before, but the events that happened in Singapore 2009 to 2020, for many, and certainly for any involved in the legal fraternity, kicked off with the failure of Hin Leung. It was a seismic event, partly because of both the size of the credits involved, the number of banks that were exposed, and the number of vessels, importantly, that were stranded across the globe. It affected virtually every part of the business because of the way it affected both container shipping, every type of shipping. The background to this case, UniCredit against Glencore, and the details of it, I think, will circulate later for people who want to do some further background reading. But an interesting case. It's another Singapore court. I think the Singapore courts have actually etched their place in history over the last 3 or 4 years, because all the interesting cases around this time were taking place in Singapore for reasons partly connected to where the failures took place. But the background to this is that Hin Leung approached UniCredit Bank to issue a letter of credit subject to UCP 600 for $37 million in favor of Glencore Singapore. The basis on which that letter of credit was applied for is that they were buying what was called unsold oil. And in fact, what had happened was this, that Glencore had agreed to buy oil from Hin Leong. Hin Leong were repurchasing it, and essentially the bank were not seeing both sides of the transaction. So essentially this was what is commonly known in the businesses as a round-tripping type transaction, very similar to the case you may be familiar with, which was the Crédit Agricole PPT Energy case. This set off a chain of events in terms of litigation in Singapore, which has seen both bankers and credit insurers refuse to pay out on anything that looked like it might not be a traditional, 100-year-old type trade transaction with one seller, one buyer collecting on the key side, and so on. So, of course, there's a lot of these structured type transactions or transactions which were principally put together to provide financing opportunities. And this is the background to this particular case. To some extent, you know how this goes. The documents were presented almost inevitably. Hin Leong had gone into liquidation. It wasn't in a position to reimburse UniCredit in relation to the credit, and UniCredit then sued Glencore. And so the background is that the court was asked to find that the transaction was a sham transaction, that it was all a put-up job, and the bank shouldn't be responsible for it. It's worth just saying that I know from dealing with both the traders, the bankers, that in fact everyone in the banking community knew that these transactions were going on. This isn't something that jumped out. You don't get 30 of these cases coming into court without everyone having known exactly what the business was in the first place. That's part of the story to this. So there's a certain amount of hubris around the position that banks were taking in these transactions. The judge wasn't impressed with the idea that just because the transaction was principally put together for financing, that made it a sham. Vin and I can talk for a long time about synthetic letters of credit and whether they're sham transactions, because I spend a lot of time doing those. But the bottom line is that the court said, look, the fact that the transaction was there to provide a liquidity solution did not mean that it was a sham, because by its nature, there's a commercial purpose in that. The commercial purpose is to provide liquidity, and that makes it not a sham contract. These were real contracts, real legal title passing. The issue, however, was that underlying all of this was that under the letter of credit, as you'll be familiar in oil transactions, whilst it provided in principle for the bills of lading to be passed between the parties, there was, of course, a fairly complex clause, which I won't read out to you, the gist of which is that if the bills of lading are not available, a letter of indemnity can be provided instead. And that letter of indemnity includes wording which suggests that the person giving the indemnity, who is the seller, in this case, Glencore, will, if necessary, find the original bills of lading and hand them over. Of course, what wasn't apparent to the bank was that, in fact, the bills of lading were never going to move anywhere, because the oil was doing a very quick there and back in terms of the passing of title. So, in fact, no bills of lading appeared. The bank didn't have the comfort of bills of lading. It had financed a transaction in which the bills of lading were never going to go into Hin Leong's hands, and that was where things were left. So the bottom line is the bank said it wasn't a sham transaction. The letter of credit was rightly called upon, and therefore no damages were payable by Glencore to the bank. Pradeep, your take on this?
First of all, most or every oil LC is calling for LOI in lieu of original bills. except when the LC is issued on behalf of the first user or actual user who's importing. So he's asking for the BLs, and I've seen LCs issued on behalf of the oil importer asking for the BL, and oil exporter presenting the BL. However, when the traders are involved, LOI is asked for. Now the issue is to whom the LOI is addressed. If the LOI is addressed to the seller, to the buyer, it is very obvious that bank has no right on the LOI. For the reason, even if the bank wants to get the possession of the BLs, it will never be there. It is with the seller. Or it was supposed to be given to the buyer. Now, so bank has no right under an LOI. Even if he wants to exercise a right under an LOI which is addressed to the bank, people forget one thing, that it is always, an LOI is available only in consideration of payment. So if the bank wants to take physical possession of the BLs or the original BLs, it must have to pay first. And this is what happened in that Credit Agricole case also, where the court pointed out. Now, so here the bankers, from a banker's perspective, here where the banks derive comfort on the standard language of the LOI, as they think that it is drafted by P&I Club, and that's why it's acceptable globally. But the bank should assess, the credit risk, because it is completely clean credit risk when you are handling a oil LCs for traders, because the original BLs will never be there. That's one. Number two, in this case, there was a buyback arrangement by Glencore. So Glencore never presented the BLs. Even when UniCredit asked for it, they said we don't have. And there was no requirement which the court established, because I sell to Hin Leong, then Hin Leong is selling the BL back to me, the goods back to me. So why should I present the BL and take it back?
Yeah. And that's exactly what the court said. They said that, yes, in principle, there was an agreement here to go and find the bills of lading, but because it was essentially a repo transaction where the goods were doing a there and back, there was no need to produce the bills of lading, because the bills of lading were simply going to come straight back on the next plane. So why would you produce them in the first place? And that's what the court. That's exactly
exactly.
The court said.
And secondly, these LOIs which were issued. Going back to the other case. So I have this concern about LOIs. That LOIs, when the banks issue LCs calling for LOIs, they should know that there is a risk. And so the risk assessment should be there. Banks lose money because of these LOIs, and this is what happened in Singapore after these Hin Leong failing and so many commodity trade finance fraudulent transactions. And banks lost a lot of money, and I believe that I can associate this loss of court case by UniCredit taking them a decision which was probably precipitous, but the decision was to close UniCredit in Singapore and leave the country, like so many other banks have done in the past.
So as someone who's spent a life in banking in Singapore, everyone knows how this works with LOIs. Yes. And if you go into a trading, you go to Trafigura or Glencore's office, there is a drawer full of old bills of lading, which never got sent to anyone, and they're all covered by LOIs. Yeah. So there can't be any expectation that the bills of lading were going to miraculously appear here.
In actual fact, because so many cases about oil trade LOI happened in Singapore, so subsequently, Association of Banks in Singapore have decided to issue a so-called good banking practice for commodity trade finance. So when you call for LOI, the issue over here is that LOI addressed to the applicant or addressed to the bank? Which one is better?
It's a rhetorical question, I think, isn't it?
Yeah.
Yeah. So
LOI addressed to the applicant or addressed to the issuing bank? Which one is better for the banks? of course.
Yeah, this is
Because
what-
the issue over here is that beneficiary undertake to deliver the BL to the bank if it is addressed to the bank. But when they say they undertake to deliver to the applicant because it's addressed to the applicant, then if they fail to do that, bank can't do anything. But if you undertake to deliver the BL to me, you fail to do that, I can take legal actions against you.
Which is why you'll never see it drafted in those
Yeah.
terms, for that very reason. Because, of course, the traders know they're never
Yeah.
going to deliver those bills of lading.
Yeah.
They're still stuck in that drawer in the traders' arrest, and they'll stay there. And that's where you'll find them, you know, when they clear out the office. Okay, I want to move on. I know that you've got a case you want to talk about, Jin, but should we talk very quickly, because we talked a little bit before about the sanctions cases.
Robert, could I just make a quick comment?
Yeah.
It's only 30 seconds.
Yeah.
I was an expert witness in that particular case. And as an expert witness, I was asked pretty basic questions, but kind of important. So one was, but already elaborated by Ashish, were the goods actually delivered? That was one question. The second question, is there such a thing as a string sale? Is there such a thing as a string sale? You just get asked these questions. And then I was asked what I thought of the LOI, if I was an issuing bank, among other questions. But to answer the questions, it's so simple. Okay. Number one, the goods are delivered. It was a CIF contract. Goods were actually shipped once they're shipped on board. Finish. Is there such a thing as string sales, and what are there? They're referenced in the Incoterms already in black and white. And what was the third question? What was the third question? Oh, regarding the LOI. What do I think of the LOI? And in the proceedings, I said, well, I don't really want to think about it, okay? And they said, come on, Mr. O'Brien, what do you think about the LOI? I said, well, the bank should have thought about the LOI, not me think about the LOI, okay? And when I think about the LOI, the answer is, if they didn't like it, they don't need to issue the letter of credit. And finish, that's it, you know? You get these transactions, you don't like the wording, don't issue the letter of credit. If you issue it, you take the risk, and that's it. Sorry for interrupting.
And I know for a fact that the judge thought that your answer was better than 50-50, Ben.
60-40. If this kind of Hinlong case going to the Chinese court, I'm very familiar with this so-called repo transaction. Actually, we have several weaves about this kinds of transaction, like ANZ Bank case in Shanghai in 2009 in Shanghai, and the Qingdao case, another huge weave of this kinds of trust receipt, but they don't use bill of lading or letter of indemnity. They use the warehouse receipt. So they AACO goes to B, B to C, C to D, D to E, E to A back. And they use warehouse receipt. So the goods never move, but they just move the documents and move the money. So under the Chinese court case, even especially the Supreme People's Court, the judge said the letter of credit they can be an instrument of payment, not be an instrument of how to say, pure finance. And that is not compliant with the basic function of the letter of credit. So the Chinese courts and the Chinese law cannot support these kinds of so-called repo transaction.
So Robert, we'll extend this one because it's so interesting. For 20 minutes. 20 minutes.
Okay, perfect. Listen, let's just quickly talk about the JP Morgan case then. So again, the details of this, Vin will circulate it later. Really, very interesting case. We've all been talking probably for the last 10 or 15 years about sanctions clauses. By the way, quick, does anyone know what the first sanction was? The first set of sanctions? Anyone? No? Not before that. No? First sanctions, Cuba. Cuba, first sanctions. JF Kennedy, the night before he signed the first sanctions order against Cuba, he called in his private secretary. He sent him out on a shopping expedition. What do you think the shopping expedition was for? It was to buy up every Cuban cigar in Washington, D.C., because the next day he was about to make it impossible to buy them. That one thing tells you pretty much everything you need to know about sanctions and the morality behind sanctions. But there we go. That's another case. Okay, but let's just quickly talk about Kavera and J.P. Morgan. Sanctions clauses. The ICC have had their say on these about the practice of them. But a very important thing is that we've had it rammed into us time and time again. I've heard Vin talking about this, that when a confirming bank confirms a letter of credit, you've got to make sure that it's confirming the credit in the same way as the credit was issued. Very, very important issue, okay? Because, of course, there could be differences. There could be, and when an amendment is made to a credit, we know that it's important to get the confirming bank to confirm the amendment, because otherwise that is not going to be available. This case brings in all of those principles. Very interesting case. So what happened here, essentially, was that there was a trade between an Indonesian seller of coal and a Dubai-based buyer. Not many banks doing Indonesian coal these days, by the way. You know, there's lots of pressure on banks not to be involved in that business. But in this particular case, there was a sale of 35,000 tons of coal. The applicant, the buyer, asked the issuer, which was a Dubai-based bank, to issue a letter of credit to cover this transaction. J.P. Morgan was asked to confirm the credit. The issuing bank's credit did not contain a sanctions clause. But when JPM confirmed the letter of credit, as it's pretty much universal practice, because it's an American bank, it added a sanctions clause, because it's simply not in a position to deal with transactions which breach US sanctions. OFAC's long reach reaches not only everywhere in the US, but everywhere that a US bank operates globally. So the fact that this was, in fact, JP Morgan in Singapore in this case, and of course, this is yet another Singapore case. Singapore is now the center, it seems to be, for letter of credit litigation in the world. So it added its clause. Now, if you freeze frame at the moment, at this point, if you're looking at a letter of credit, you'll have noticed that, first of all, the letter of credit that's been confirmed by the confirming bank is about half a page longer than the original letter of credit. Yeah? And it's written in very large capital letters. So you ought to read it and understand what it is. In any event, the transaction went ahead, documents were presented. We talked about artificial intelligence earlier. What happens is the documents come through, they're fed into a mincing machine which produces a stream of data. It simply takes virtually every word in every document, including, of course, the key names, the parties, where the goods have come from, location, the name of the vessel, the insurance company, everyone. It feeds it into a data cruncher, which then matches up whether any of these occur anywhere in any of the OFAC legislation. And the machine went ping. Why? Because it found that the vessel which was described, I think, as the Omnia, was in fact a vessel which had previously been called the Lady Mona. It was a Syrian vessel. And at the time, of course, all of the sanctions were in place in relation to Syria. JP Morgan said, I'm very sorry, we cannot process this application. They did something quite interesting, by the way, at this point, which is that instead of putting the documents in a safe and calling in the Fed, they actually sent the documents back to the beneficiary. In any event, they refused to pay. The outcome was The credit was for $2.42 million, not a massive transaction, but big for the parties involved. What happened then was that instead of presenting the documents directly to the issuing bank, which of course they could have done within the expiry of the credit, because you're entitled to do both, they let the credit expire. They then struck a deal with the buyer whereby they got everything bar the last $200,000. And they then ended up suing JP Morgan for either the full value of the credit or for the difference between what they should have got and what they got when they did the transaction. Sanctions clause was in fact unenforceable for a variety of reasons, and that it didn't actually, on its terms, prevent payment of the amount of the credit. The court didn't agree with those arguments. It held for JP Morgan, upheld its sanctions clause, and said that in terms, when a confirming bank adds its confirmation in the same way as an issuing bank issuing the letter of credit in the first place, it is a unilateral contract. The only promise it's making, once it's given that, it's not promising to confirm on exactly the same terms as the issuing bank. It's confirming on the terms attached to its confirmation. And if it's added a term there, within reason, provided that it's not done anything extremely underhand, and you can't miss a sanctions clause, believe me, it's a half a page of extra text, then it's up to the beneficiary to decide whether it wants to either accept that credit in its modified form or go back and argue the toss with the confirming bank, negotiate it, see if they can get rid of the sanctions clause, or get someone else to confirm it, if that's possible. Now, for practical reasons, of course, that's not always possible. We know that's the case. Of course, the alternative thing it could have done, and it probably did do with its counterpart, was to ensure that the contract said that it was obligated to find a confirming bank which would confirm on identical terms. But that's between the buyer and the seller. But as regards the bank was concerned, the court said no, they were perfectly entitled to insert that sanctions clause, and as long as they did not revoke that letter of credit in that confirmed point, in that confirmed state, they'd done what they needed to do. And that the terms made it quite clear that indeed it would have been a breach of sanctions to have paid out under that letter of credit, and on that basis JP Morgan were entitled not to pay under that letter of credit. Yeah. Let's go to you again, Soichi, quickly on that. You followed the case.
Yeah.
Anything surprising about that?
Actually, over here, the case, actually, one thing is that, because from the comments given by the judge, if JP Morgan did not incorporate such a sanction clause in his confirmation advice, then in that case, JP Morgan had to honor, because else is subject to UCP 600. All right? Documents presented, all terms comply with, you have to honor. But because JP Morgan have incorporated such a sanction clause into their confirmation advice, it becomes part of the condition in its confirmation. So in that case, beneficiary must understand, in case this happened, JP Morgan had the right not to honor. And not only that, JP Morgan, as an American bank, they also show to the court, if they pay, they could be charged by the American authority. So they cannot take the kind of risk to honor. And this is the reason why they have this sanction clause. So over here, even though the LC does not provide the sanction clause, but as a confirming bank, even advising bank, when they advise the LC, they may also incorporate that. This is what happened now. So in actual fact, I think lately ICC have given the draft opinion. I think the last one also talked about that. Whether this sanction clause appear in the documentary credit or even in the confirmation advice is considered as a non-documentary condition. The court in Singapore was also requested to address this, raised by the beneficiary. But the court said, no, it is not a non-documentary condition.
Yeah.
All right? So this is very important.
I was
Okay?
going to quickly to Pradeep on this.
See, not only JP Morgan inserted its sanctions clause in its confirmation letter, but all subsequent amendments, when they were confirming, and court referred to that also, that it was not only the confirmation letter which worked for JPM, but also the amendments, when they were advised and confirmed, they also had a similar, the same sanctions clause. So it is very vital for banks. Of course, now most banks are incorporating sanctions clause. Kuvera, the litigant or the plaintiff, they refer to the guidance paper from ICC that, it's not necessary to incorporate, and it is against ICC's own advisory letter or confirmation, this guidance note on sanctions, which discourages. They said whether or not, they didn't say that we discourage. The court ruled that it is not that ICC is saying that we discourage and should not happen. They said that it is not necessary for a bank to incorporate a sanctions clause because in any case, the bank was bound by the sanctions regulations and sanctions laws. So what Sochi Singh said, that probably if it was a complying presentation, the bank would have had to pay. But then the bank was bound to abide by its own US regulations and compliance. And JP Morgan decided, and it is like a risk-based approach, that I rather like to be sued rather than violate the US regulations.
No one wants to wear prison stripes in the US, that's for sure.
And they had a bad history just in 2018 when they lost money. So one point which I would like to state is that, the first point that you raised was that an LC has to be confirmed on the same conditions on which the LC was issued. However, I personally used to add my own terms of confirmation, either to the amount, that in case I have lesser lines on the issuing bank, I'll say, okay, I add confirmation, but the amount of my confirmation is limited to the extent of this amount. And I had another issue with the Article 37C exclusion, whereby the beneficiary would bypass me and present documents to directly to the issuing bank, and then I will be losing on my confirmation fees. So what I did was I incorporated a condition on my confirmation advice that this is a term of my confirmation, the documents under this LC must be presented to us. And I sent a similar message to the issuing bank that I have added the confirmation, but with this condition. So in case you receive the documents directly, please note to remit an amount of this much towards my confirmation fee.
So no surprises.
And it worked.
Yeah.
And it worked at least 2 times. When I really saw the issuing bank asking me that we have received the documents, please, and we are remitting this money out of the proceeds. So that's why
we're going to have to really have a break. But
Yeah.
Jenna, you're going to have your chance to present, but we'll have it after the break, I think. You can summarize.
Let's do that. I mean, some really interesting points here. We could take maybe some brief questions after Jin has done his session after the break. But really important, we've seen bills of lading remain important. If you want the bill of lading, bear in mind the LOI is not the route to get that. It's not going to get there. And also look very carefully at the terms of the confirmation. It's not necessarily being confirmed in the same basis as you saw it issued in the first place. Let's have a break, have a coffee, refuel, and we'll come back.
And it was very interesting, different views, which it's all about. Wonderful, wonderful. So, dear friends, we'll have a break and we'll be back at 11:45. 11:45, is that okay? Yeah, great, okay. Well, everyone, welcome back. Please join us and take your seats. We'll be starting in actually 1 minute and 11 seconds. Lazara, come back. You did a U-turn there. You got to come back in, okay? Yeah. That's better. Khalil, lovely. Good to see you. Yeah, everyone. I think they need to ring the bell out there a little bit more. Yeah, or it needs me to get people. Yeah. So Jovel has the presentation ready. So we're going to get underway, and as you can imagine, we have a slight change of schedule, but it's going pretty good. And so here is the plan. We're going to continue for a little while longer. Oh, Mr. Jin, that's absolutely wonderful. Okay. Interesting comment or two at the break. One person said that it was really interesting that our two experts, Chi Singh and Pradeep, had a different point of view on the sanctions. And that's what it's all about here, that we have expertise, we agree, we disagree, and we move forward the agenda. So next, even though time is short, we're going to hear from Jin Saibo on a Chinese case regarding standby letters of credit. Now, this case is really important for the trade finance industry, and Jin Saibo is going to speak for 10 minutes. And if this happens, it will be a first ever that he speaks for 10 minutes. So, Jin, I'm just letting you know, I'm your stopper, okay? Okay, so you have 10 minutes. So please come to the podium and I think present from here. We're better up here. Yeah.
Okay.
Yeah, okay, yeah. Thank you.
That's why I put in the code here, then you can read the English summary of the standby cases called Ping An Bank versus Huishan Bank. And the detail of the Chinese version, full text of the judgment have been putting together online in my newsletter. So if 10 minutes is not enough, please go to the website to read this newsletter. I'm Chinese, I know Chinese Kung Fu, but I find that we should practice 3 kinds of Kung Fu against 3 kinds of Kung Fu you guys developed. The one kind of Kung Fu called letter of credit Kung Fu in the past 100 years. And we do have law and rules made and published by the Supreme People's Court in 2006. That's Chinese letter of credit rules. And after that, we developed another kind of Kung Fu called demand guarantee Kung Fu. And we help the Supreme People's Court make another set of rules on demand guarantee, because this is kind of Kung Fu against sounds like the European country, this kinds of Kung Fu. But today we find we need to develop another set of Kung Fu against American, because this kind of kung fu came from United States. This is a very weird species or animal, special animals from United States called standby letter of credit. If the case which subject to ISP 98 go into the Chinese court, and the Chinese court find in left hand we have AOC rules, but in right hand we have a demand guarantee rules. But as Jim Byrne find, we have no rules on standby. Yes, if a standby is subject by UCP, yes, we have we have a lot of cases, court cases, which subject by UCP, and the judge said if a standby subject by UCP, and that is the letter of credit. So a standby is a letter of credit if it's subject by UCP. But if a standby subject by ISP 98, and the judge confused. Here, the Ping An case, the Hui San Bank issued a standby. The beneficiary is Ping An Bank because Ping An Bank's the overseas branch giving a huge loan to the legal entities outside of China. But this company failed to pay back the loan to the Ping An Bank, so Ping An Bank claimed under this standby, which Ping An Bank is the beneficiary, the issuing bank is Hui San Bank. But the standby said this is subject ISP 98. And the Hui San Bank finally refused to honor the compliant presentation made by the Ping An Bank. And Ping An Bank sued Hui San Bank in the Chinese local court. And the court find the judge what kinds of rules, sets of rules would be applied. And he find this standby animals cannot apply letter of credit because it's subject by ISP 98. And he cannot also apply the demand guarantee because the demand guarantee is another kinds of animals compared with the standby. So the judge here, he confused. And he referenced both sides, both sets of rules. In one side, the judge applies letter of credit rules. But in the another side, the judge also applied the demand guarantee rules. But in my mind, the judge make a mistake because he cannot apply two kinds of sets in the same case. But the judge have no choice, but he must deliver the solution of the case. And the judge said, whatever the nature of the standby is, legal nature of the standby is, we must follow in the basic rules. First, which the respect of the term and conditions of standby. Secondly, the independent rules. The independent rules should be also respect, and they comply with the strict compliance rules should be followed, like that. So finally, the Chinese court judged that because the Ping An Bank has already presented the compliant presentation and the issuing of the standby must pay, must honor the compliant presentation. So I think the result is compliant with the image of the banker or the bank society. But the problem is the reasoning given by the judge is very confusing. Because we have another case happened, but not yet decided. It's the case happened in Shanxi province, Taiyuan Intermediate Court. That is the standby issued by Chinese local court. The beneficiary is in Australia. And the case have been stopped payment by the Chinese court. The beneficiary sued the issuing bank in Queensland, Australian court. So that is the litigation case. But this standby case also subject by ISP 98. So the problem will become again. And the Supreme People's Court have another case. The one party of the case is ANZ. and the case is going to the Supreme People's Court. So the Supreme People's Court have not yet made their final decision. So today in China, a standby case, if going to the court, if it is subject by ISP 98, the result will be some kinds of, unprotectable, because the Supreme People's Court, the judge, Lady Judge Sun, he is one of the judge of the panel in this standby case, and he told me that last year they have not yet decided. If the Supreme People's Court make their final decision, then we will got the final answer on these kinds of questions. Thank you.
Thank you. I don't believe it, Jen. You are absolutely on time, really.
Yeah.
But just finally, if someone was looking to a Chinese bank issuing a standby LC subject to ISP 98, what advice would you give them?
Actually, IIBOP, after the Chinese demand guarantee rules have been published, IIBOP immediately issued two kinds of official interpretation. Said the ISP 98 is also a set of laws on demand guarantee. So the official position published by IIBOP is, if the standby issue subject by ISP 98 would apply the demand guarantee laws, not the letter of credit laws. So the IIBOP already make their decision, but sorry, the Chinese judge don't know this. So if suggestion can be given by me, if you have a case in China, you should hire a very experienced lawyer who can explain to the judge said that the IIBOP have already made his official interpretation on the applicable of the ISP 98 rules as a demand guarantee rules.
Thank you very much, Jen. Can we give him a round of applause? That was absolutely, absolutely fantastic. Really, I can't believe on time. Okay. So now we're going to have a very short 20-minute discussion with Pavel Andale, who we want to talk about ICC rules and revisions, etc. So Pavel, please join the stage, and this will just be 20 minutes.
Good morning.
Good morning, everyone, and well, we're nearly good afternoon, but it's still good morning. So, Ken, I was so proud of you finishing in less than 10 minutes because I thought I was going to need to use some Irish kung fu to remove you from the stage, but we didn't need to use the Irish kung fu. It would have been a good competition, Irish kung fu against the Chinese kung fu, I think. So what I'm speaking to Pavel about is, and the reason we're having it is, last year at this event, Pavel was here and he felt quite passionately about something, and that was about an epidemic of court injunctions around the world, stopping payment under guarantees, but I think particularly counter guarantees. So he had very strong opinions on how this problem might be addressed, and I know some of his recommendations or advice has been taken on board by people. So it was helpful, even though we did not agree 100% on everything. I think what you said was very, very helpful. So now we're talking about rules and the revision of rules. And what do you think of the revision process of rules within the ICC right now? You were involved in many of the rules, so what's your snapshot take on the current process?
So the first major revision I was involved was UCP revision, which resulted in UCP 600, current version 2007. And interestingly, at that time, there was actually a vote of national committees whether to go ahead with the revision or not. And as far as I remember, the vote was kind of split, 50% in favor, 50% against. And because of this ambiguity of the position, there was a decision, just a small group to make a paper for next meeting and just kind of substantiate, find the reasons. There was no vote then, revision went off. And I don't remember since that time we ever had kind of clear vote from national committees whether to revise other rules or not, to create new ones. But at least there was always need, requirement for this substantive paper, blueprint, what is problem, what should be done, and so on, which was discussed, debated.
I remember it used to be a very structured way it happened, and actually the market actually by and large received UCP 600 very well, okay, by and large. So what is your view on how effective the UCP has been, and maybe then we'll identify maybe one or two things that could be enhanced, but overall, you know, what's your impression?
UCP 600. Yeah, a couple of years ago, there was quite big debate whether to revise. Recently as well, there was even kind of questionnaire among committees. So this question, whether after 15 years or so we should revise UCP, came up again. I don't think there is need. On the other hand, I think we can now really enjoy established interpretation. Because honestly, UCP 600, in my view, is very successful revision, but honestly, there were some major hiccups at the beginning. Just maybe to recall, very strict wording of Article 14J, which actually says if you have these addresses and contact details of applicant in notified party or consignee box, they must be as stated, which sounds like exactly must be the same. So this was too strong.
Any particular article, one or two, that you just didn't like or don't like, okay?
And maybe one more comment with, let's say, hiccups with UCP 600. I think another major problem, which is now well settled, was this onboard notations. Do we need extended onboard notation if the place of receipt is there, differs to the port of loading? This created a huge problem because actually UCP 600 deleted the clear wording we had in UCP 500. So there was confusion, inevitably. If it's done, if it's removed, what does it mean? Change of the position or the rule still applies? So this was clarified by opinions, then by this recommendation on board paper, which slightly, overwrote a couple of opinions. So now I think all these major hiccups we had are now settled, established. So let's enjoy.
But there must be some rules that you just don't like within the UCP,
I would not say there's any particular rule I don't like, but really, if I have to kind of put a candidate on the table, which article we should look at, I think it would be good if you really strongly consider removing Article 32, which is about installment drawings and shipments. And this article is not clear to everybody. First of all, I think it's a bit confusing, especially for customers, beneficiaries, because it has very strong impact.
And customers are important. We shouldn't forget that.
Yes. So basically, just to summarize what it says, basically, if you have periods of time in the LC when presentation drawing is to be done or shipment is to be done, and this is not met by the beneficiary, letter of credit ceases to be available for that and any subsequent installment. So first of all, as I said, most beneficiaries don't know this is there. This is kind of a strong trap for them.
So it's a trap. You said a trap.
I would say unless you fully understand what it means.
You said a trap.
I did.
Yeah, okay.
If you have installment LC, big trouble for the beneficiary. And I think also confusion. What does it mean? It's not available anymore. What exactly it means? So LC is cancelled? No. It's still valid? Yes. But it's not available. So if there is no installment and then you have another presentation, do you still need to formally refuse it if you wish to do so in line with Article 16? So even among banks, there is big confusion exactly what to do. What are these installments vis-a-vis latest shipment dates? And it does not work at all for standbys, as we know. Yeah. But even for commercial LCs, it is problematic.
Professor Byrne, when UCP came out, felt that this was actually quite ridiculous, okay? We have letters of credit that are irrevocable up until their expiry date. Yes. But if it happens that the credit states that the credit is available by installments, 10,000 January, 10,000 February, 10,000 March, 10,000 April, but it expires then at the end of April, any beneficiary would expect that if they miss one of the installments, they've missed it. They can't have the money, but they would expect that the other ones are still available. Now, if that was written into a letter of credit, that's fine, because you can read it. But if it's a hidden trap, well, this needs to be removed. This needs to be deleted.
I'm glad you agree with me.
I agree with you. We're agreeing on too much today, so let's disagree about something, okay? So what about the revision? Like, we've had a spate of other rules. We've had the URBPO. We had the EUCP is a supplement. We had the URDT. Is there another T? There is, yeah, URDTT, and we have the URC, and what's your impression of maybe the process or the rules? You know, because you've so much experience.
Yeah, maybe we can start with the first one when it comes to this electronic world. Of course, EUCP 2002, no use, then a revision a few years ago, 2019. And I really missed a kind of big debate, technical analysis, why we need to revise, what is the problem, what has changed. Because now we have EUCP revised and you don't see big use and you are not sure really it fits. It does not really change so many things vis-a-vis first revision. And now there is actually a request to make a change to EUCP. So I think before you really make a move, there should be much more debate, technical analysis. We mentioned these rules for BPO. That was big topic 10, 15 years ago. As we all know, buzzword, BPO will change the way we operate, game changer. Now the game changer is gone.
I just want to check, because we're using all these things. What is a BPO? Does anyone know? What is a BPO? Bank payment obligation, you're absolutely right, but I frankly always thought BPO was a big problem only. But anyway, who knows, okay. But back to you on the process.
Yeah, some people said big payment opportunity, so it did not materialize. But then there was actually an attempt to revise these rules for BPO, but then this was decided not to go forward without too much explanation and so on. But the decision was to make new rules, uniform rules for digital trade, without, again, in my view, really, there should be much more debate and clear blueprint, what we want to achieve, what are the issues. This is not banking thing only. This is about the whole industry, about companies, logistic guys working together on this. So they realized this cannot be really digital trade as such. It has been renamed digital trade transactions. So we have these rules. I don't hear them being used or so. So, instead of having rules when we don't have the services, products, maybe we can just create guidelines and kind of accommodate this to happen. I don't think it's a bit problematic, of course, to have rules before we have practice.
Yeah, I think you're right. And what's interesting as well, ISP 98, referenced by Jin, ISP 98, which came into effect on the 1st of January 1999, already provided for electronic presentation.
Indeed.
Right? It already had provision of what was an electronic record. 1998, it already had a provision for what was authentication, and electronic presentations are actually happening under ISP 98 standbys. So, yeah, I think you're right. Give me another set of rules that you thought was a good process.
Good revision process. I really think that the revision URDG was a great success, and in my view, a bit overdue, because it was almost 20 years, and the first URDG great, but we needed this big enhancement. So I'm very positive about URDG 758. It was fast, efficient, nice set of rules. So I'm very happy with that process.
And again, I'm in agreement with you, but it's always nice to hear the idiosyncrasy. So if URDG 758, if there was a rule that you didn't like you can't get everything perfect, but and we all have different opinions, but if you to identify a rule that maybe you're not 100% happy with, or you dislike? What might it be?
Yeah.
And I am putting you on the spot, so, you know.
Okay, good. It's good to mention ISDGP, which interprets URDG,
Okay.
and I'm not happy with a couple of provisions interpreting URDG in that book. So that my worry is not with URDG, but a bit more with that official interpretation. This
No, that's good. 'Cause
ISDGP publication.
Overall, you're very positive. So
Yeah.
this is a positive statement about the rules and the ISDGP. But I'm pushing you just for what you think might not, in your opinion.
In URDG, we were not, I remember National Committee, I represent ICC Czech Republic, we were not too much comfortable with article about currency of payment and force majeure in relation to this counter guarantee and guarantee scheme. Because in our view, on one hand, we always say counter guarantee and guarantee are independent from each other. But then we have provisions which, in my view, go completely against that. So many people, I think it's kind of European guarantee thinking that counter guarantee here is to provide reimbursement to the guarantor. But you know, reimbursement is different thing to independent relationship. So there is a bit of kind of conflict here, independent, but then you have kind of counter guarantee being a reimbursement in the first place. So I don't like these kind of twists in these two articles which go that way. But of course, I understand this is very much entrenched how mainly European bankers see counter guarantee to work.
Sure, and then just to elaborate, let's say, not a criticism of the rules or anything, but kind of something that has led to situations. And that is Article 34 is a URDG is applicable law. Article 35 is jurisdiction. And Article 34 states that if the guarantee or counter guarantee does not state the applicable law, it's the law of the place of issue or branch that issued the guarantee. Now that sounds reasonable to me. Reasonable to me, but in practice it's caused a lot of problems by people not being aware. So you get a counter guarantee for big bank, big country, and I won't say what the big bank and big country is, but this is an epidemic in a certain big bank and big country. They issue their counter guarantee to the local guarantor, and the local guarantor issues the local guarantee, and they're both issued subject to URDG 758. No mention of the laws. Well, then there's a claim under the counter guarantee, the local guarantee the guarantor pays. It goes to claim under the counter guarantee. There's an injunction, like you mentioned last year, and there was no reference to the applicable law, but the law and jurisdiction by default under the rules is the law and jurisdiction, Article 34 and 35. So I'm not saying that's wrong, but because of lack of awareness of it, people fall into a trap. Because as we know, with most guarantees, there's no problem. But when it goes wrong, it goes wrong. So I agree with you, Pavel.
No.
Sorry, go.
Yeah, I think, yes, it's good to highlight this. So beneficiary of the counter guarantee, guarantor should really be aware. And if they wish to have different jurisdiction or different governing law, they should make sure counter guarantee does say that. Yeah, it's good to know that the default, which was put there, again, having in mind counter guarantee and guarantee are independent from each other. So here, the intention was to really keep this.
We're going to finish in less than 5 minutes, just so Oljena can be warming up. And but just want to ask kind of you a question. Like, part of the purpose of these is to discuss cases, past cases, but look to the future as well. You know, it's a funny question, but if you had to pick A or B, you know, if a letter of credit should be leaning towards favouring one party or the other, applicant or beneficiary. Now, when we all do lectures, we say it's good for the beneficiary, it's good for the applicant, because. But if you kind of were forced, and you are being forced today, to lean towards, who should a letter of credit lean towards? Now, I know you don't even want to answer this, Kelly, okay? Because you think a balanced approach, you know? But if you had to say who it should lean towards, who should it be, the applicant or beneficiary? Just say a name, you know, I'm not going to argue with you. Beneficiary, wow, it's all beneficiary, okay?
Beneficiary,
yeah,
yes.
And I'm always educating people in emerging markets of the value of deferred payment LCs, but I'm inclined to agree with you. So ICC brought out a paper recently about discrepancies in documents, and it told us that the level, I've forgotten the number, but the level of discrepancies in documents on first presentation is what percentage? 60 or 70, I can't remember, but it's 60 or 70. So guys, if it's 60 or 70% and we're saying it should be in favor of the beneficiary, the product is broken and we need to actually fix it, okay? And yeah, I see people nodding and I see one person going no, and I see most people going yes, and I see one guy at the back going like this. I have no idea. I have no idea what that means. So we have talked about some practical issues. We came up with 1 or 2 recommendations, and I think we've opened up a new debate for some new thoughts. So can we give Pavel a round of applause, because I think he did a wonderful job.
Thank you.
Thank you very, very much. So with that, Olyena, and with that, Olyena and Bazara, if you can come to the stage. Bazara is here. Oh, yes, of course. Okay, okay. So Olyena, if you can sit over here, great. Okay. So I'm going to hand over to Olyena in a moment, but and I'm glad Robert is still here, because Olyena is going to head off and tell us what can be done, or we're going to look at what can be done if there is a dispute between the parties. Whether that is, as Pavel, we've been talking about, a documentary dispute between 2 banks, or whether it's a dispute under a contract when there's an underlying instrument. That's what we're going to talk about here. And Olyena, you can move forward.
Thank you very much. Thank you very much, Vincent. And I will start from a little bit introduce myself. My name is Olena Sharokova. I am the leading Ukrainian Business Council in UAE. At the same time, I am vice chair of Trade and Investment Commission in ICC UAE. And at the same time, I'm the head of corporate department in law firm, one of the law firms in Dubai. From my background, I think this is a very interesting topic for me, because when it comes to dispute, all lawyers are up. So this time, to make a problems and to make money, from the lawyer's perspective, I would say. Yeah. But this discussion, I think we will start from the main topic and from one of the alternative dispute resolution, and it will start my colleague from the Banking Commission. I think Mr. Bazara, yes, and we will speak about the dispute resolution process, which was created for the world of the trade finance. And this is the DocDex, ICC rules. And I will lead the floor, and after that I will come back with my arbitration, lovely arbitration.
Okay. A little bit of background, Bazara, on your experience.
Yeah. Okay, the DocDex is dispute resolution for trade finance instruments. It is specific designated for trade finance related disputes, and it gives expert opinion to make the settlements, which is, affects like letters of credit, guarantees, collections, and now it's expanded to factoring, other trade finance related instruments. It gives you a faster resolution. You get the experts' opinion. The experts are designated by from the ICC Banking Commission list of experts. They will designate 3 experts. Before the experts are designated, the case is looked by a technical advisor. The technical advisor will decide whether this case is within the scope of the DOC rules. Once this is done, it goes to the experts. The experts will have also their own opinion. They will look at it, and if they see that it is not within the scope, they will come back. Once they get that through all this expert involvement, then they will make a decision within a specific period from the day they received. The experts, once they receive it, they have 30 days to come back. That decision will not go directly. It will go again back to the technical advisor. He will look at it, make any amendments that is required, discuss within the people, and then give the answer. So this is where the step goes. The respondent will have also a chance. When the claim is made, they will send to him. He has a time to come back within 30 days with some certain documents that is required. Once this is done, and if he doesn't respond or if they have conflict, the experts will look at the case itself. When they look at the case, they will look at what is the claimant, what is the claim, what is the answer received. Then they look at the terms and conditions of that trade product instrument. Then they will see if this is applicable ICC rules there. And then they will go into the international standard practice to look at this. So the thing is, not a lawyer involved, not a judge. These are people who have been there for years doing the same practical thing from time to time. And this is where you get. This is how DocDex is
Maybe
important.
maybe a word on your background with how long you're in the business and your experience with IIBLP. Just a few words, you know.
Oh, I have been in the business for, I don't know, maybe 40 years plus, and I was a trade product specialist. I was in operation, I was in trade sales, and I also worked as a consultant. So this is how long I have been in the trade.
In fact, Professor Byrne once described the Bazara as a walking encyclopedia of trade finance. So now we see a walking encyclopedia here in front of you. But I just want to ask you, like, for example, if I was a confirming bank and the documents are refused by an issuing bank for a ridiculous, well, I think it's ridiculous because I always think it's ridiculous if I'm the confirming bank. Would this be an appropriate avenue for me, you know, instead of going through the litigation, etc.? And the case is $24 million because I'm thinking of a $24 million case right now.
Yeah, I think this is actually, there are a lot of this type of cases where the beneficiary bank wrongly dishonors, or the applicant bank wrongly honors. And the easiest way is because, you know, if you look at the time frame, from the time they filed the case, usually the average period takes 70 days. From the time they file the case, the respondent, whether he answers or not, it takes him 30 days. If they need supplementary documents from either the respondent or the claimant, they have 40 days to submit, and then the experts have 30 days. So the time frame usually doesn't go beyond 70 to 80. If you go to any litigations, you know how it takes years.
Oh, yeah. This is what we will discuss with me, because we have two types of lawyers, litigators and arbitrators.
Yeah.
And I will follow up this later. It's very interesting.
But how much does it cost, like, you know?
Oh, this is, I think, consider it free. 5,000 for an amount less than 1 million.
Yeah.
And above 1 million, it is 10,000. In rare cases where they see that there is a lot of work is done, they will increase by 50% of the standard fee. So if it is 10,000, it will be 15. If it's 5,000, it will be 7,500.
Wow.
So this is actually, when you look at any small case which goes to the court, the lawyer takes per hour $2,000.
Yeah. Really?
More
than that.
More.
And,
More.
More than that.
And expert witnesses, what do they get paid? That's top secret.
Yeah, top secret.
But there's a $1 million question here. Speaking of money, if you don't mind me interjecting, it's $1 million question here, and this is you go through this process. You know, there's the claimant. The respondent doesn't even need to join the party, I think, if he doesn't really want.
Yeah.
Yeah. Okay. He doesn't need to join the party, although I would recommend always join a party. Okay. Okay. So he doesn't even have to join the party. But then when the result is issued, is it binding?
It's not binding. Unless they have agreed and at the beginning that this is binding, and this is done in writing in the forms. There are forms that they submit when they make the claimant. There is, you'll find it in the website of ICC. Form 1 for the claimant, Form 2 is for the respondent. And if you put that, if they put that in those forms that whatever the DocDex result is binding, then it will be enforceable.
But if they
Otherwise,
don't?
they don't.
Okay.
It's not
So
enforceable.
Pavel, I know, is a DocDex expert, so please join in if you don't mind.
It's
Yeah.
really fair to say it's not legally enforceable. So even if the parties do agree with the binding, then you cannot go with this to the court and get it enforced. You still have to go through that procedure. So that's a bit of drawback, but certainly the value would be certainly enormous because parties would see all documentation and so on. So I think it would be very powerful solution to go to the court or whatever and have your position really solid.
Okay.
If it's in your favor.
Yeah, even if they have not, wrote in their forms that it's binding, it again helps when you go to the court. The court will hear the opinion of experts in this field, and then it would help the parties who, on whose favor the DocTech was, the result came.
And I think, Alina, this is why you are such a strong supporter of arbitration.
Yeah, so much. And when I will start from the beginning for arbitration, why I support the arbitration, because it's also confidential, it's fast. If I'm sure if there's someone present from the lawyer side here, they will agree with me that when we are going litigation, it takes really, can I say, a long time. It can take a long time, a little bit, and of course, for example, for my private clients, from my even Ukrainian big corporation, I really advise in terms of confidentiality. So, and we have here words are binding and enforceable. Of course, very important to start with signing the right arbitration clause in the agreement, because we always refer there when dispute starts, because it's very hard after dispute arises to make the arbitration agreement, because the party is one of them who is not in the interest, they will try to block and to negotiate, and takes long time. But when the process starts, it's much faster than litigation. And as well, I really would like to start.
But in terms of enforceability,
sure. Because of this, I'm more into it's enforceable. And of course, when it's some questions, because it's one of the most important, famous question in any arbitration week and arbitration conference about enforcement of arbitral award. So the most important, we start from when we're drafting the clause of arbitration. If it's drafting very simple, as I say, don't make it complicated, because when it's coming to the dispute, when we draft this clause, we should think about the enforceability of this clause. If it is enforceable and how it will be the enforceable award. So this is very important to put in the beginning of your business relation with any partner. Yeah, and I think I will continue. Some passion became
Robert or Jim?
Robert.
Yeah, Robert. I think that Robert has the mic. Yeah.
Yeah, I would like to start with Robert, because I have very, very important questions, and I know in Dubai, as I said, there are two types of lawyers, arbitration litigators, who is for arbitration, for litigation. And I was listening to your panel discussion very carefully, and I know your background, so I would really be interesting. What is your opinion about litigation? Especially in UAE side. In the coverage of the market.
It's a great question. What's the best way, litigation or arbitration? And actually, whenever anyone asks me that question, I give the same answer that you'll get if you talk to a real estate broker about what's the most important thing about the value of your house. He'll say there are three things: location, location, and location. And when it comes to litigation and arbitration, you're looking at the same things.
Location.
What's your location as the plaintiff?
Yes.
What's the location of the defendant? But most importantly, what are the location of his assets? So, where are you going to end up trying to enforce your judgment or arbitration award? Because that will determine which route you go ultimately. And that's the conversation that I always have with clients. We look down and we say, let's not discuss how we start this process. Let's look at how we're going to end it if we're successful. And that is what will determine. So in terms of court judgments, the problem there is that there is no universal reciprocal arrangement for the enforcement of court judgments. Even in the UK, we used to have a very nice thing that we were involved with called the European Union. Yeah, you know where I'm going with this. The B word, Brexit. And under that, we had the opportunity to enforce UK judgments everywhere in Europe, and the other way around as well. And it worked very well. So it really greatly enhanced the value of English court judgments. But if you go in a country that we don't have that anymore, if you go around the world, there are lots of independent reciprocal arrangements. So it's quite a complex issue. You've got to look at where you're going to be able to use your court judgment. Arbitration awards, much more straightforward. Because under the New York Convention on Arbitration Awards, you can enforce an arbitration award in most jurisdictions in the world. Most of them have incorporated into their law the New York Convention in a way that limits the opportunity to object to the enforcement of an arbitration award in that location. Now, there are some countries where the process is a little bit more cumbersome, a little bit creaky, but generally speaking, if you've got an arbitration award, you're going to be able to travel with it, like an asset recovery tourist. And you're going to be able to use it in different locations. Whereas if you've got a court judgment, generally you're going to be more limited. So what I'd say is, if your assets are widespread, an arbitration award is the way. If you've got a very focused idea of where you're going to enforce it, and you can do that with a court judgment, there may be some speed issues. Cost-wise will be a question. Court proceedings, depending on where you do them, can be very expensive or could be slightly cheaper than arbitration. ICC do many great things, but the arbitration process in Paris is generally for big, big cases. Costs the price of a small private jet. Yeah? Yeah, minimum, someone said. Maybe a big private jet. But if you're looking at the court processes and some of the arbitration processes, whether it's in the UK, UAE, DIFC, Paris, New York, there are different levels of arbitration that might suit either the type of case you have. Obviously, there are any trade association arbitrations as well, but there are also levels at which you will go depending on the size of your wallet.
Yeah, thank you very much. Really, thank you very much, Robert. Really.
Maybe a large private jet, Anna, would be more appropriate. Yes, Khalil, and I think Mr. Jin wants to speak. Jin is there beside Robert, and then Khalil will come to you.
When I was handling my letter of credit case before the Chinese court, but I find in the same time that the counterparty go into DocDex. So in the future, if the DocDex present to the Chinese court, because the Chinese court already have the hearing, the judge read the evidence, every piece of paper evidence, everything, cross-examination, everything. The Chinese judge, they may go into the different conclusion than the DocDex conclusion. So that's why I suggest ICC DocDex never hearing a case, already going to the court. Otherwise, if the DocDex decision's conclusion is totally different or even contradicted with the conclusion made by the judge, and ICC DocDex reputation will be deadly harmed. That's my suggestion. But it sounds like ICC DocDex never following my suggestion.
They don't like. They don't like your conclusion.
I have a case. The counterparty is Vietnam Joint Venture Bank. They just refused to pay to honor because 5 or 6 discrepancies. So just for the discrepancy technical issue, DocDex good. If your case is, hundreds of millions of US dollars about the fraud, DocDex is not the good solution. Technical, it is worthless to go into the court. Both parties hiring top level lawyer just for the one discrepancy. It's stupid. So DocDex, good, excellent. Yes, so we should have a different case, have different situation, have a different solution. That's my suggestion.
Yeah, we'll pass the mic, Joel, to Khalil, please.
Hi. One of the good uses of DocDex that I have had an experience with is when you, as a beneficiary, ensure you're exposed against an undertaking by an export grantee agency. Because what they condition is that they will pay you, say 90% of the proceeds, provided that the documents comply. And who decides the documents comply or not? It's usually the nominated bank. And you, as the beneficiary, you could have a different opinion that your documents complied. So they would not plead you. They will go into the opinion of the nominated bank, unless you have a DocDex, that they will tell them this is a correct presentation that will compel and oblige the agency to pay you.
Very good example. Very good example. Brilliant.
Yeah, I think we touch very some point which I'm usually asked about the price of the arbitration, how much it will cost us. It will cost us as a small private jet or big private jet. So this is true, and sometimes lawyers, what I now even recognized, and when I already coming to the dispute, I look at the contract. The contract price is, for example, 300,000 euros, and they put the arbitration in London with 3 arbitrators. I'm thinking, how come the lawyers work against the client? You know, so this is very often happening. So if you are the business owner, the partner, you need to look at the dispute resolution clause, because in any contract, this is the most important clause, to be honest. Because if somebody says like, oh, like before marriage, you need to think about divorce, it's true. So whatever your relation is good starting, but in any business you have a small, big, or big-sized problem, medium-sized problem, but it's happening. But when you look at this dispute resolution clause, you should understand how you're going to solve it. Is there lots of complication, or it's written not the proper way, or sometimes other lawyers write on purpose some complication to make it hard for you to solve or to challenge your rights. So in this way, you need to be very careful when you choose the arbitration, because arbitration gives you options for ad hoc when you appoint yourself and write who is the arbitrator will be, and institutional arbitration. So institutional, for me, it's much better, because people who don't have that background of organizing, arranging, sometimes it's lots of difficulties in choosing the arbitrators from the ad hoc. And institutional, it's already providing you the rules, which is well established. For example, ICC rules and ICC institution, arbitration institution. They even giving you the clause as example to put in your contract. You just modify about the place and about the numbers of arbitrators. So be careful, because in any contract, it's good to know the fees, it's good to know the payments. We look carefully about this, but sometimes we forget about the dispute resolution clause, which is the most important, by the way, from my side point of view. So.
Actually, Oljena, we're getting loads of questions coming in online on the chat, but we're not going to deal with them now. So you need to stay on, because later on we will try to answer most of the questions.
Yeah, thank you.
So
yeah.
Zara, any final word?
No, on the case of how much is the amount of the case. I saw one case where it started in 2016, and it's for large amount. It came to the dock deck just 1 year before. It shows that although they went and looked at other venues, even litigations, but then they went back to DocTech. Okay. So this is an example where it was for a large amount, and the case started in 2016. It just came to DocTech in 2022, something like that.
And did the DocTech provide a solution in that particular case?
They're working on it.
Okay, I think a final question or two, and then we'll go for lunch, and then we'll be pretty much back on track, nearly back on track with the time. Any final question, comment?
Everyone wants to have a lunch.
Everyone wants to have lunch. Well, who are we to hold you back?
Yes.
But what we're going to do is we're going to go for lunch. Lunch is right outside, so it's really, really convenient. So I really do think that we can be back on track, 50 minutes for lunch instead of 1 hour. I think it'll work. So we will kick off at 1:30 sharp. Is that agreed? Is that agreed? That's better. Okay, let's go for lunch.
Thank you. Thank you.
Well, we will be starting in 3 minutes and 27 seconds. Exactly. Thank you, everyone. If you can come on in and get your seats, and we'll get underway. Great. We're starting in 45 seconds. Wonderful. Yeah. Great. I'll have to go out again and get them. Well, welcome back, everyone, and glad to see so many of you still here. In fact, I think we have a few more in the room than we had in the morning, so that's always a good sign. So, very important feeling is question is how are you all feeling after lunch? Yeah, but that's all going to change dramatically for a number of reasons, and. The first one is, I promised there will be a prize draw today. So when we finish this evening around 5 o'clock or thereabouts, we're going to have a competition. So I'm going to ask 3 questions. And the answer is going to be a number to each question. It's going to be a number, okay? A number. So you need to listen for numbers if you have not been listening already. But the 3 winners that shout the right number, and you need to shout, they're going to get a copy of this book, which is produced by the IIBLP. And this is LC Rules and Laws, and it has all the trade finance rules in here. Everything we talked about, UCP, URDG, ISP, even as mentioned by Robert, the model law and electronic transferable records, it's in the book. So 3 people are going to win the book, and the book is worth more than $100. So that's a nice prize to actually win. With my signature, then it's probably worth $1 million, but we can negotiate on this somewhere along the line, okay? So we'll be giving out 3 prizes. But the real reason that it's kind of exciting is that we're going to move on to, this morning it was trade law, technical issues regarding trade law. Now we're moving on to the other aspects of compliance, even though, as we saw this morning, they're overlapping now a lot more than they used to in the past. So now we're looking at digitalization and fighting financial crime. And I'm really happy to ask my friend Zul to come up here from UAE Trade Connect and give us some insights into what they're doing and the progress being made and achieved. Zul, please.
Okay, so I don't have a mic, so I'll use this. Is that okay? Yeah, that'll be better. Thank you very much. Everybody had a good lunch? Now it's time for nap. By show of hands, how many people here are doing business in the UAE? Okay, yeah, about a third of people. How many of you are bankers by profession? Yes, a larger proportion are bankers. The others are probably in the wrong room, right? All right, I'm going to talk to you about what we have built called UAE Trade Connect. I stood here a year ago. Vince was very kind to invite me. I was here a year ago. At the time, we had launched UAE Trade Connect, but our results were just about starting to show. Today, I'm really, really proud to be here and talk about how something we started as a theory, put it into practice, is now showing achievement in spades. So if you'll give me about 20 minutes, I'm going to take you through what we've built, how it's helping the banks in the UAE, and how we want to take that same technology and offer it into other countries in the nearby neighborhood, which is GCC, MENA, and beyond. What is UAE Trade Connect? That isn't working, Jovel. Is that going to work? Yes, okay.
You need to put a coin in it.
Okay, so let's start with what is it that we're solving for? And the reason I asked how many of you are bankers is because I hope that what I'm about to tell you is going to resonate as a problem that you've felt throughout your career, and you're hoping to find a solution that'll solve all your problems. How many people know about overfinancing fraud? Yes, multiple financing, overfinancing, inappropriate value, goes by the same name. It's a problem for trade finance. It's definitely a problem in this neighborhood, and it's certainly a problem in Asia and, frankly, all over the world. I don't think there's a single country that's immune from overfinancing fraud. So you as bankers have always known that some proportion of the documents provided to you for financing are probably being presented elsewhere for overfinancing. You're also aware that a lot of the times that you're being given documents, some of them might be false. They might be forgeries, there might be no underlying trade, or they might be overvalued. It's something that keeps you up at night, I'm sure. It's the same for the UAE. Many of the bankers who have a lot of experience in this country felt the same. They felt that there was a problem in respect of overfinancing and multiple financing fraud, and they wanted to work together to solve this. Why did they need to work together? Because no bank can solve it alone. You can only know what's in your side of the equation. You can't know what's across the street at the other bank. Why can't you compare data? Well, first of all, it's against the law. You can't compare data with other banks. There are data privacy regulations. Secondly, why would you compare data with your competitors? How can you allow your competitors to see data that belongs to you and your customers? And that's what I'm here to tell you about, because we've built a unique set of technologies built around what we parochially call blockchain, also known as distributed ledger technology, and it's the distributed ledger technology that's the operational word. I have a video in about 10 minutes that will explain it in much more detail. That video runs to about 2 minutes, so hopefully it's the right length to keep your attention. But I want to move to why, because the problem that we're trying to solve is how to find overfinancing and how to detect multiple financing. But the consequence of that problem is what we're really trying to solve for. Liquidity in the economy is limited because of this hesitation, this reticence that me as a bank, if I'm going to lend to this company, particularly medium and small size companies, I worry about their ability to go and get duplicate financing. So the real problem isn't how do I find duplication. The real problem is how do I get confidence to lend more deeper into the economy? And that's the reason, and you'll see this a little bit later in my presentation, why we were able to get central bank support and why the ICC keeps inviting us back, because this is all about ultimately solving the trade gap, trade finance gap. There are 11 banks live on our platform today. So I was just talking to Saeed in the break that we have the largest banks of the UAE, and we have some of the smaller banks of the UAE, because this problem is not limited to what kind of segment you operate in. The largest banks here, take our neighbor, Emirates NBD, they probably lend to about 30% of the businesses in the UAE. Many of those are going to be huge, huge businesses. As a party, that party may not represent risk. Well, there's always risk. I'm sure the bankers will tell me there's always risk. But is there a risk that they're overfinancing? Well, maybe. Just because somebody is big doesn't mean that they don't get into misbehavior. Secondly, if you think about the latest products, things like supply chain finance, yes, you are taking a risk on the anchor, but the people providing those invoices who are getting the payments early, they may well be providing those invoices elsewhere to other banks. So just looking at that, I'd like to point out that there are 7 banks who actually began the journey with us. We co-created the solution with them, and then some of the other banks joined later. So just to give credit where credit is due, the founding banks were CBI, Mashreq, RAK Bank, FAB, Emirates NBD, CBD, and NBF. So these are good household names in this country. I'm sure most of you recognize them. But because the platform was successful, we started to get interest from other banks. And this is why, Saeed, I'll be calling you later. Because the more banks we have on the platform, the smaller our blind spot becomes. Today, we believe that 85 to 90% of the lending that goes out to businesses is covered in our platform. But it's that last 10% which we'd like to close the gap on. Moving ahead, I mentioned that we were a theory. Let's talk about that stage of our life. Back in 2020, this was just an experiment. We knew the technology existed. We knew the willingness was there for banks to participate. And we put together a consortium to solve the problem. For those of you who don't recognize the name EN Enterprise, this is the new name for Etisalat Digital. So those of you who operate in UAE, Etisalat is a familiar name. We've rebranded. We're now called EAND. I have to explain that in every meeting I go to. I also explain that I can't say why we rebranded. But we are called EN Enterprise now. So we're the tech in that first sentence. Banks and tech came together to work on this. In addition to the 7 UAE banks, Central Bank of UAE took an interest. They became an observer member in our steering committee. They put the head of their fintech office into the steering committee to help guide us, to help make sure that whatever we developed was compliant and that it didn't cross any boundaries. And finally, during 2020, the proof of concept was very quick. We found that theoretically we can solve this problem. You'll see in the video that one bank's data is never compared with another bank's data. No data moves between banks. This is the beauty of a blockchain network, because everything is distributed. Our system is interrogating those individual nodes to understand if there is any duplication and giving only results by exception. A year ago, I stood here and I talked about how we had launched. I think Vince invited me March last year probably. So we had been in business 9, 10 months. And it was a ramp up, which meant that there wasn't a lot of volume going through the system, which also meant that we weren't able to really say what's the size of this problem, because not every bank was putting every document through the system. That has changed in 2022. Now, in 2022, and I do have a slide that shows the numbers, not only do we know how big the problem is, we know how frequently it happens, we know what kind of patterns we're detecting, and how we can learn from early warnings about which kind of borrowers might be going, repeat offenders might be turning, might take us for a ride. and ultimately might be going bust. We can even see which companies are over trading. So I'm going to show you the results. So far, in the 23 months that we've been live, of which about 12 months were serious usage, we have built up a repository of 500,000 invoices. I want to talk about those invoices because the average value of those invoices is actually 200,000 dirhams each. We have some small invoices. Somebody puts an invoice for 5,000 dirhams. The smart banks will process that through the system. They will present it to our system for validation. At the other end of the spectrum, we have seen, Hussein, largest invoice we saw in our system? 180 million dirhams. A $50 million has been presented to our system just in case there's an overfinancing. And one of the case studies I'm going to show you is a fairly big invoice. 100 billion dirhams has been presented to our system. We're really pleased with that because what it demonstrates is that each and every month, each and every day, banks are using our system on a daily basis because they trust the results it's giving them. We believe that by this 2023, we will have probably 160 to 180 billion of value going through the system, which is, you know, $50 billion. It's a heck of a big number. Here's our findings. 1 in 6,000 financing requests are on the back of duplicate invoices. So in a way, that's a really small number. 1 in 6,000, it's not that big. But think about your customers. If 1 in 6,000 of the documents presented to you are duplicates or frauds, that's actually a pretty high incidence. I want to point something out which I didn't put on the slide. Because of the ramp up, this 1 in 6,000 represents that whole 24-month period. If I take the last quarter alone, when all 11 banks have been using the system with a high density, that figure comes down to 1 in 2,000. So the incidence of duplication is much higher than people had assumed before. In terms of values, it's even worse. 1 out of 1,500 dirhams is a duplicate finance request. Every single one of our banks who are using the platform have had a duplicate. There's no bank which is immune. So, Saeed, when I come back to you in a week or two, I will show this to your chairman, and I will say, every bank has this problem. The more banks that are in our network, they protect themselves and they protect the other banks because they're adding more and more density into the data set. Another point, it's not on the slide. Sometimes the duration of time is very short. Somebody goes to one bank on the Monday, and by Wednesday he goes to another bank. But we've also had cases of 3 months duration, 6 months duration. A borrower or somebody coming with that document thinks the bank has lost the trail. I can present an invoice a second time or a third time. Sometimes they even have the nerve to present it to the same bank. And guess what? Those banks don't have the systems to detect it. Because it's not a check that's built into your trade finance system. It is not a check that says, let me go backwards and check whether this document has been presented before. But our system does it. It checks within the bank's own database, and it checks through the repository to see if that invoice has appeared before. So we're going to show you a couple of the case studies which are interesting. We have had 87 duplicates since we started this business. To be honest, we've had 80 in the last 11 months. It's a high number. But what we've done today, we've selected 3 cases, which I thought would be interesting to you because we're trying to answer the question, are we winning in the fight against crime? And I think it's a nuanced answer. You'll say, yes, we seem to be winning because of these kinds of detections. but how long till they start outsmarting us again? But I want you to look at what's happening with these three cases, because each one is a different scenario, and each one indicates a different kind of misbehavior. So what happened in this case? This is our largest single case, 27 million dirhams in one invoice. The borrower went to the first bank and presented this large invoice for financing. That bank presented it to the UTC system. UTC system said, I've never seen this before, it's good. They did their other checks, their party checks, credit line, sanctions, and they lent money against that document. My friend, I would appreciate if you didn't take the photos. I'll sanitize the presentation and maybe we'll share some of it, because this does belong to situation related to our banks. 4 weeks later, the same borrower took the same invoice to another bank, and they presented it for financing. That bank put it through the system and immediately got a warning. This is a real-time system. Immediately got a warning to say, don't lend on this because it's been lent on before. We never tell the bank who is the other lender. Our warning that goes to the bank, it simply says, it has been financed before. It doesn't tell them who, when, or how. It just tells them, don't lend. Then they call us and they say, what's going on? And we say, I'm sorry, we can't tell you that. We have compliance rules. But we ask them to read the invoice, make sure there was no typing error, maybe some kind of what my friend calls a fat finger error, or maybe some incorrect data has been entered. We go through the invoice, then we talk to the first bank, and we confirm that, yes, these are duplicates. Now, what this does for both banks is it tells them about their borrower misbehavior. So apart from stopping the financing on this invoice, their fraud team better start looking at the account, and their fraud team better start looking at the account. Because if that borrower, he or she has done it once, I guarantee they've done it before. So this is a high-profile case for us. It's certainly our biggest outlier. It's not like it's miles away from the others. We've had many other duplicates at 4 or 5 million dirhams, but at 27, this is the largest one. I'll take you to another case. Another case that's interesting is indicating some kind of collusion between buyer and seller. As bankers, how many of you think this happens? Do you think collusion happens? Well, those who aren't raising your hand, you might be being naive. I think collusion is a well-understood problem, and now we have evidence to show how it happens and when it happens and the frequency of it. So in this case, buyer one presented an invoice to the first bank, and that bank presented it to UTC. In real time, they got an answer. You can lend to this guy. This invoice has never been seen before. 3 days later, same invoice is presented to another bank with a different buyer's name. So same supplier, same invoice number, same date, different buyer name. Now, either buyer number 2 has very good Photoshop skills, or he is in cahoots with the sellers to say, give me another copy of that invoice, but change the name. So what happened when this invoice was submitted? Our system immediately said, this is a fail, but it's not a 10 out of 10 match. It says this is a 9 out of 10 match. Super high risk. What's the difference? There's one field. We don't tell the bank that. We don't tell the bank that it's a different buyer name. Our system tells us that it's a different buyer name. So what we do again, the bank calls us, we call the bank, we say, are you sure you have typed the buyer's name correctly? Or is it some kind of data manipulation error? No, they said, no. Buyer 2, we've typed it absolutely correctly. We go back and investigate this on behalf of the first bank. We don't discuss this with the banks. We do the investigation. It turns out that these two are group companies, buyer 1 and buyer 2. They are group companies. It turns out that this is a systematic fraud. Now, luckily, the amount wasn't very big, but think about how much this is happening when people are reusing and reutilizing the same document to secure financing again and again. The third case, it's a little bit more unusual. There is a duplication. Maybe it's not as malicious or as flagrant as the first two, but it's still somebody who is taking extended credit at the expense of the lending community. So what happened in this case? A buyer, quite a reputable UAE company, brought a vendor's invoice. So this is buyer financing. The buyer presented the invoice, which was from an international company for some high-value goods. They presented it to, the bank A presented it to UTC. UTC put it through the system. It was clean. Yep, go ahead, lend them some money. A few months later, the same buyer went to a different bank and presented an invoice that had many of the same characteristics, except it wasn't from the supplier's same name. It was from the supplier's financing company. So, like I said, this is not necessarily malicious or fraudulent, but what they have done is they have used money on the basis that they were going to pay the supplier. They didn't pay the supplier. They used a finance company to finance it. And when it came time to settle the finance company's bill, they provided the same invoice for settlement. So what's happened here is extensive credit has been taken, and probably some overtrading was happening here because those funds never went to the supplier. It's a working capital leverage. People are overtrading on the strength of those invoices. So again, maybe, I mean, I wouldn't say it's not malicious. I'd say it's malicious, but maybe it's just not as flagrant as the first two. And these are the kinds of things that we're finding. Our system is smart enough to know what's called a fuzzy match. Just because all the fields don't match, we still find reasons to think that it might be the same. We've often had a case where invoice number is not the same, but all of the other characteristics match. We give that a medium score. We don't call that a high score. And we present it to the bank and we say, the score is medium. You can decide whether you want to lend or you want to investigate. Buyer, seller is the same, value is the same, currency is the same, date is the same. It could be valid. It could be that he's just shipping, the same quantity of goods in multiple invoices on the same day. Or it could be that it's a duplication and they've just changed the invoice number to avoid detection. So we have a risk rating system. We have low risk items at 2 out of 10, 3 out of 10. We have medium, 5 or 6 out of 10, and then we have the high risk, which is 9 and 10. And all of this is in real time, and all of it is done without letting banks know each other's data. That's the wonder of distributed ledger technology. I think that's probably my last slide in terms of what we do. Where are we going next? We'd like to come and visit you in your country, whoever is here from one of the neighboring countries. We'd like to come and showcase our solution. Maybe Armenia. Are you interested in Armenia? In order to make this a success, what we need is we need enough banks to be there at the beginning. 4 banks, 5 banks. If we get market coverage of 50% at the beginning, we can solve the problem for that country, because then more banks start to come. By the time where we are now, 85, 90%, we're catching almost everything. In fact, what we're saying, Saeed, to the banks which are not in the platform, you are now a higher risk of being targeted because all the fraudsters know you're not on the platform. And Central Bank hasn't been shy about this. Central Bank of UAE has been propagating the message. They've been telling all the banks, UBF, the UAE Bankers Federation, has been repeating the message that join UTC because it's in everybody's common interest to do that. So in terms of international expansion, our immediate goals are to get to GCC, Saudi Arabia, Qatar, Oman, Kuwait. We want to get to the GCC. We are presenting ourselves in South Africa this week at the GTR Summit. And other than that, the rest of the MENA region is where we want to go next. We have a success. We've got achievements. We're long past the theory that we were 1 year ago. I have a video which kind of shows how the system works. Is that okay if I play that? Yeah. It's not going to win an Oscar, but Joel, can we?
UAE Trade Connect was established in the year 2019 when thought leaders from various banks formed a consortium with EAND, formerly Etisalat Group, to apply the latest technology to combat fraud in the trade finance space. UTC went live in 2021, harnessing blockchain and artificial intelligence to its core in solving an industry-wide problem. Our consortium proudly comprises of leading banks of the country and several more in trials. Each month, our platform inspects in excess of 80% of the UAE banks' invoices that are presented for financing, of which 9% of invoices uploaded show some degree of risk. About 1% of invoices are found to be suspicious, and 3 to 5 invoices are found to be inter-bank duplicates. Since inception, UTC has been recognized in the financial services industry for its success and has won multiple awards. Here's how the UTC system works. A bank seamlessly submits invoice information into our blockchain platform, either through a web form, EDI, OCR, or an automated integration via API. Key data points are extracted and synchronized to the analysis engine using smart contracts, which performs duplicate checks and risk assessment. The selected invoice data, risk assessment outcome, and the final action taken by the bank is chronologically stamped onto the blockchain network. This, combined with the immutability of data, ensures tamper-proof and distributed storage of sensitive information while ensuring customers' data privacy. Having proven our technology, we're now expanding to other geographies. We propose to replicate UTC's platform for the broader MENA region by allowing banking and financial institutions to share knowledge without sharing sensitive data. Our unique offering will benefit banks by reducing fraud and help in building confidence, while also increasing lending and revenue opportunities. Form a consortium of banks that account for more than half of the trade finance market, deploy our blockchain network in full compliance with banks' information security standards, customize our artificial intelligence-based smart rules engine that will cater to your needs collectively, complement each bank's digitization journey, use our proven expertise to benefit your country's banking and finance industry. Let's work together to de-risk your country's banking trade finance space. UAE Trade Connect, built by the banks, for the banks.
Oscar?
Definitely. But so before you go, we're getting some questions coming in on our virtual stream. So just to put that, there's a lot, but I got to try and pick one or two that might be interesting. Most invoices are coming into a banking system still in paper. How is that paper then got into your system? I think your video goes a long way to explain it, but just it's the question.
I'll answer that question. So I don't think most invoices are any longer coming into banks on paper. COVID put an end to that for sure. So most invoices coming into the banks, particularly large banks, is through some kind of EDI or interface from the borrowers directly into the banking system. Alternatively, where PDFs are being received, those PDFs can be scanned into our system or can be punched in by an operator. We don't like the punched in for human error reasons, delay, etc.
Yeah.
But ultimately, once the data is digitized, our system only needs 6 fields. It only needs 6 fields to be captured. I mean, ideally, you want more than that. You also want line items. You also want information about pricing. That helps our system to do its job better. But if you just pick up 6 fields, which is supplier name, buyer name, date, value, currency, and invoice number, of course, that's the key. With these 6 fields, our system can do its job.
And the second question is just with the findings, have any criminal or legal actions being taken in response of the findings? And of course, no names required, because generally.
So there have been today 88 cases of duplicates detected. It represents about 50 borrowers. Is that correct? About 50 borrowers? I would say that in all cases, some conversations have been had between the banks and those borrowers. In a few cases, further credit has been stopped. And in a couple of cases, the bank has exited the relationship. In 3 or 4 cases, the fraud STRs are being raised in the GoML system of the central bank. So they are being reported as potential frauds, suspicious activity, and the central bank has begun their investigation on that.
Very good, very good. And we have a question here from the audience.
Hi, Zul. Dipesh Patel from Trade Finance Global.
I know you, Dipesh.
So if your shareholders, some of the larger UAE banks, how is the solution scalable for some of the smaller or correspondent banks who aren't shareholders and therefore have different business objectives? And also, question about the business model. Is the onboarding cost prohibitive for the smaller banks, which I've seen across many of the platforms, obviously including some of the ones that aren't around today? And on your business model, are the large amount of revenues on onboarding costs or a per invoice cost?
That is a lot of questions, Dipesh. I also need to ask if you're going to write about this or if this is off record. Okay. So let me be clear. The ownership is not with the banks. We are in discussions with the banks to become partial owners. At the moment, the entire ownership is with eAnd. That hasn't changed the way we approach the market. We are trying to solve a problem. We are on a mission with these banks. The reason we call them consortium banks is because they founded this with us. Just because somebody isn't a financial stakeholder doesn't mean they're not a stakeholder. In fact, the amount of effort that those 7 banks put in devising the solution, testing the solution, integrating their systems. Later on, the other 4 banks have also put in a lot of effort to integrate their systems. That is why we call it built by the banks for the banks. Because even though we're the shareholders, it doesn't mean that those banks haven't made equal or even more effort than we have. Secondly, between large and small banks, it's really, I'll come to the point about onboarding, et cetera. I won't answer the business model question for obvious reasons, but the scalability is ideal because what we've got is we've got a separate node for each bank. Each bank controls their own node. How much firepower is in that node depends on what's going through that node. So the largest banks will have very large, our system is completely cloud native. So how scalable it is depends on how much computing power you need. The largest banks have a lot of computing power, and the smaller banks have a smaller footprint on the cloud. But we define it for them, and then they can either use their own cloud provider, whether it's Amazon or Microsoft, or they can rent the cloud from us because our parent company owns a data resident cloud. In terms of implementation, the system can go live within 8 weeks. And most of that 8 weeks is training and integration. Our system, if we want it to be offered tomorrow to Saeed, I keep using Saeed as an example, if he comes tomorrow and signs the contract, in 2 weeks he could be live if his people are trained. It's usually going to be longer. It's going to be about 6 to 8 weeks for a smaller bank, and it's going to be a bit longer than that for those banks that want to join with APIs. That development is on their side. But we work together with them. And I will answer your question. We don't have any onboarding costs. We don't charge for onboarding. The reason for that is because the sooner the 12th bank joins and the 13th bank joins, the more it benefits the existing banks.
Great. And Zul, we have 2 short questions for 2 short answers. And first is Nikkei Nazardine, Vice Chair of ICC UAE Banking Commission.
Assalamu alaikum. I'm really impressed with the system, with the data and all those stuff. Hats off to you all. The existing problem that we have is with the fictitious transactions. So how do you mitigate that risk? Because, I've been working with many Islamic banks. So I know most of the inspectors who go and inspect the goods. Sometimes I get the complaint that, the same goods have been inspected by one inspector, and then when he leaves, the other inspector comes from the other bank to inspect the same goods. So this is like, we have to mitigate this risk. This is like sometimes the same goods have been, used by several Islamic banks to do, the financing. Yeah. So that is a major risk that we had seen. Previously, we had a system, we worked with China Systems. We built it on blockchain. It was on the inspection. The moment the inspection is done, automatically the payment was done. So it was linked in that manner, and it was a great system that China System produced. So I think you could take some of the knowledge what they have and interlink that to your system. It will solve the the original issues.
I'll answer it very quickly.
Please.
So you noticed I used the word platform. So the reason we call it a platform is because the real secret sauce of what we've done is linking banks on a blockchain. On top of that, we built a use case. The first use case is about fraud detection. Second use case could be to link with warehouses. Third use case could be to link with shipping portals so that we can see the movement of goods. All of that validation, verification, our system can do it as long as the providers of the data are ready to link. So we do have plans, and we have a working group within the consortium that's concerned with future development.
Chris from EMBD. It's a great model, but the weak link is the missing 20% of invoices. Notable by their absence were all international banks, so the whole industry is suffering by that. Why is it not mandated across the industry? Because the fraudsters will already know what banks are not using this platform, so we're all vulnerable.
I agree we're all vulnerable, but I would say those banks are more vulnerable than others because now that they're outside the circle, the borrowers will target them. I'm not at liberty to talk specifically about any bank. I will say that all the international banks have had discussions with us. Some of them have been approved by central bank to join the platform. Some of them hadn't got that far because their internal matrix organizations have precluded them. But the real fundamental reason is that most of those banks think at a regional or global level, and a country level system isn't their highest priority. That doesn't mean that they shouldn't be in it. In fact, there are a couple of names conspicuous by their absence.
And so a final one, because we need to move on, and then you'll have the floor. So Ravi.
Yeah, so Ravi Amin from S&P Global Market Intelligence. So I have a question in regards to the fact that you said you use fuzzy logic to try and match names and stuff. So fuzzy logic tends to lead to higher false positive rates in matching. So can you give some more kind of insight into the false positives that you might get and how you're trying to reduce those?
Okay, very good. So I'm sorry, Vince, I'm going to eat 3 minutes out of the next presentation. So fuzzy logic, once fuzzy logic kicks in, so when it's an exact match, it says this is an exact match. When it's a fuzzy match, not only does it indicate this is fuzzy, it tells you what are the hits and what are the misses. And a bank can make their own assessment, or post-event, we can help them with that interrogation. But our system is very clear when it's an exact match versus when it's a fuzzy match. And also we have a rating. We don't say everything is 10 out of 10. We have a 9 out of 10. We have an 8 out of 10. We have a 7 out of 10. By the way, all of this was developed in conjunction with the banks. How would they like their ops teams to see the results? So we don't pretend to be trade finance experts. Far from it. We build the tech. We build the system that's going to make it, but the output, the interface, the scoring, not only is that built by the banks, but it's refined by the banks. Hussein, who is my colleague there, Director of Product and Partnerships, he has a working group with banks representatives once a month where they talk about what should happen next. How do we evolve the system? How do we refine the system? I'm sorry, Vince, I shouldn't.
No, you're okay. We have one last 10-second question for a 10-second answer.
Thank you. I just have, I need to have this clarified for me. Do you think that as far as not all banks are in the system, everybody is vulnerable? Because you could finance it first outside, then you come.
It's potentially vulnerable, yes. And by the way, that's my sales pitch. whenever I go to the banks which are not in the system, I say, you are more vulnerable and you are making other people vulnerable. So a bit of guilt helps to sell the system. but if you go back to those logos, it'll be very, very few borrowers who are not banking with these 11.
Thank you, Zul. Can we give him a good round of applause? That was really a great presentation. Really, really great. So we're going to move forward, and Khalil, come to the stage because we're moving on again in a compliance role. So in recent times, the ICC, the International Chamber of Commerce Banking Commission, issued some opinions in the context of compliance questions. So Khalil has prepared a presentation, and he's going to join us in a moment. But while he's getting ready, let me just tell you that the books, remember the answer is going to be a number. And we saw that 1 in 6,000 transaction could be duplicate financing, 6,000. And remember when we talked about URDG, we saw Article 34 dealt with the applicable law, Article 34. And as everyone knows, my birthday is on the 18th of September. Now, if you forget my birthday, you're definitely not getting a book, okay? Forget it, okay? Okay, so Khalil, over to you.
Nizaruddin and Pavel, please come to the stage.
I like to see a man taking off his jacket. It means he's serious. Yeah. Yeah, and we'll give you the microphone.
The moment I received the communication from Vin whether I'm interested in presenting on this for only 30 minutes, I immediately said yes. And I live and work in Riyadh, Saudi Arabia. So I drove from Riyadh to Dubai for 10 long hours, monotonous. Desert, sand, dunes. And I saw a couple of tragic accidents. And I did all of this not for the sake of glory or fame. It is because this issue is important to all of us. And this is a venue to discuss and see what the experts can contribute to the solution and what we will hear from you. So what we will cover is a few basic concepts. We'll delve into an ICC opinion that has to do with sanction clauses. And we'll also highlight a legal case that you heard about from Robert in the morning regarding a sanction clause in a confirmation, in a bank's confirmation. And more importantly, we'll take a few advices from our friends and from the audience, because these are the main takeaways that will help us address the issue that we face today. The basics. The basic questions are who issues the sanctions, why, and what their impact on trade finance. As you know, the sanctions themselves are legal prohibitions against dealing with persons, organizations dealing in certain products, and these sanctions are issued by governments, by international organizations like the United Nations, governments like the OFAC, the Hong Kong Financial Authority, and issued by unions like the European Union. And why? The reason is that these sanctions seek to influence the behavior of the persons against whom these sanctions are directed. So what's the impact on trade finance? Now you'll see that according to the sanction laws, you as a bank, you might be prohibited from honoring a complying presentation, negotiating a complying presentation, reimbursing a nominated bank that has paid in good faith, returning the documents, or even disclosing information regarding why you have not acted in accordance with the rules of the UCP or other rules. So what happened? The issuing banks started inserting sanction clauses in their LCs. This is the recent past, but if you go historically, The sanction clauses have been around for a very, very long time, since the 1940s and 50s in the Arab world, if you recall the boycott clauses. But we are referring here to the recent sanction clauses, and the banks started inserting those kind of sanctions. However, things got ugly. The banks have started inserting sanction clauses that go beyond what is legally plausible. As we will see from the ICC opinion, and in response to that, the ICC has issued a guidance paper regarding the sanction clauses, and it has, I can't say suggested a clause, but it has offered the clause if you need to insert one, and the clause looks similar to what the IIPLP has had suggested. So here is the ICC opinion, and I'll take the views of my friends, but I will give you a background to it. It relates to our documents rejected. The bank says in accordance with the sanction clause, but we will see whether that was correct or incorrect. This is the opinion. A few commercial LCs subject to UCP 600 stating the following. I'll give you a minute to read it. Take your time. This minute is not counted from our 30 minutes. Take your time. This is a sanction clause that is in the issuing bank's LC. And here are the facts. Documents presented to the issuing bank. The issuing bank refused the complying set of presentation stating the following. Rejection due to internal policy and risk concerns. The issuing bank had concerns regarding its customer, the applicant, and had concerns regarding the route of the vessel, but not in relation to that particular journey, maybe to a previous journey, which was irrelevant to the transaction. Tell me what you think. What is at hand? Is this rejection, was it based on the sanction clause or not?
Not definitely.
Go ahead.
See, internal policies and of a bank will not affect the sanction clause. So that is exclusively pertaining to the bank's internal policy, and no one will know what are their internal policies. And it's not mentioned as well. So how could somebody take that as a sanction clause? So sanction clause, and this has no relevance in this. In my opinion, I always want to pay. Ethically, we want to pay the, so as far as you get the goods, payment should go to the supplier. So here you are finding excuses to not to pay.
So if you read the sanction clause, is there anywhere a mention of the internal policy?
No, it's not mentioned anywhere.
Okay. What happens, what would be the case had it been mentioned?
See, even
had the sanction clause mentioned due to 1, 2, 3 and internal policy?
Yeah, even if you mention, it is, no one knows what are your sanction clauses, what are your internal policies. So then you have to publish your internal policies. So nobody will accept your, if I'm a supplier or the nominated bank or the advising bank, I will not advise this particular LC.
Yeah, I definitely agree. It was not mentioned here, first of all. I think opinion clearly said, even if it was, it would have to be stated in a kind of documentary credit terms and conditions manner, which would be extremely difficult to do, and certainly not advised to do that. So certainly the opinion is very, very correct and very clear.
So you say that if it had been in the sanction clause, it would not have been applicable? Suppose that I were the beneficiary and I accept this kind of sanction stating in accordance with 1, 2, 3 and internal policies. would the rejection be okay, or would that be construed as a non-documentary condition?
Yeah. Even if you include, I think no bank will accept such an LC, even a beneficiary will not accept, because no one knows what are your internal policies. So it is ambiguous.
Okay, if you say this is an ugly kind of sanction clause, have you seen something similar to this that shouldn't be acceptable?
Nearly all sanction clauses are really, really ugly.
All of them?
Yeah, really, really ugly. Like really, even based on the sanctions environment, if a bank was to say to a beneficiary, and Nazardine, you're the beneficiary, if we are impeded for paying by legally effective sanctions, we will not pay you. You would say that's pretty reasonable, okay? But if you put in a clause that we may not handle, we may not hold, we may not return, and some of these things, as Robert showed us earlier, are a half-page long that are not intelligible in any shape or form. So they're not just ugly, they're really ugly.
Have you seen any sanction clause that you would not accept in a letter of credit? How much do you see sanction clauses in the LCs that you receive? Or do your LCs include sanction clauses?
We have documents, official documents of ICC that we recommend to use a sanction clause. It's document number 417-1238.
Pavel, does the ICC recommend use of the sanction clause?
You mentioned a couple of opinions which certainly do not recommend to use them. And good summary is this guidance paper, which was, I think, 3 years ago, updated. So there is this addendum which kind of gives a bit more clarity and puts some more, let's say, stuff on it. But the ICC paper actually says it's redundant, so it's not necessary because basically sanction clauses are mandatory law and you have to follow mandatory laws. So the advice is, or opinion says...
I think the ICC is neutral on this. But should you use a sanction clause? This is the sanction clause that we suggest.
Should you use a sanction clause, Chris?
I would always agree what you mentioned there, but what was interesting, what we said earlier today, the Singapore court case and JP Morgan and reference to inclusion, that puts a lot more ambiguity on it now.
Yeah. So let's maybe go back to that paper. I understand that paper says you don't need to do it. Mandatory sanctions will apply anyway. It's very good, actually, to look at that Kuvera against JP Morgan, which I did 2 days ago, learning this would be on this conference. So I would recommend everybody to read it, and I will again. I just read the article in DC Word, which summarized this. And I agree that that outcome, as far as I understand from the article, is very confusing. And it's interesting for us because it thinks, kind of scrutinizes the value or, let's say, the impact of that sanction clause. But also it scrutinizes the ICC paper. And the judge said, if I'm not wrong, kind of saying ICC does not prohibit. ICC is ambivalent when it comes to this very narrow clause, like we will apply mandatory sanctions, but does not kind of condemn strongly the kind of wider ones. So that's what judge observation was. And now I'm actually thinking about all these arguments, and I will definitely spend more time reading this judgment, because there were a lot of interesting topics. The judge answered some in bit ambiguous way. And I think now we all think about, if we don't have the sanction clause there, are we really safe? So my first really kind of impression, what I should think about, or we as an industry, really, what is the, let's say, impact of that sanction clause, right? First of all, judge said, is it a part of letter of credit terms and conditions? First question, yeah. Then what, if it is there, what is the impact of it? And lastly, if it's not there, are you still kind of covered as a bank, right? So if you look at the first question, is it letter of credit term and condition? Is it part of that obligation? And then I think it's kind of difficult to argue it's not, because it is stated in the letter of credit paper, but we should scrutinize this. Okay, so it's in there. What is it? What is the impact of it? So number one, is it documentary condition? And I would say, as we see UCP, it's not documentary condition, because it does not say which documents should show kind of compliance with it. So certainly it's not documentary condition. Number two, is it non-documentary condition? Because that's very fundamental. Then non-documentary conditions are still part of letter of credit terms and conditions. Beneficiary must comply, yeah? So that's what UCP says. We need to be very careful. Non-documentary condition, you don't have to kind of present documents to comply with it, but if your documents show something in conflict, yeah, then discrepancy. So fundamental question, is it non-documentary condition vis-a-vis, beneficiary documents to be presented? And I think this is a very tricky one.
Help me understand. Documentary conditions relate to the conditions that are to be presented by the beneficiary on the documentation.
Yeah.
But this is a condition from the bank to the beneficiary, from someone to someone.
Yeah. Can I?
It's a condition a condition of payment.
Can I continue on this? Because I see even this addendum actually says it's non-documentary conditions. Sanction clauses are non-documentary conditions. And I actually said it last year when we discussed this. And now I think actually it's wrong message. Yeah. Because if we say it's non-documentary condition, it's still part of their letter of condition, beneficiary should comply. So I think the right message would be, my understanding would be, it's even not non-documentary condition. It's like something else, and I would call it kind of sanction law clause, right? Because you are not supposed to check documents for compliance with UCP and letter of credit terms and conditions. You do it after, and you do it based on that law which is applicable, or you arguably can choose. So for me, it's really kind of, as I understand now, reading this square, thinking about that, it's kind of sanction law thing, not part of letter of credit terms and conditions. Unfortunately, the judgment does not say that. It's confusing. In one way, in other ways, it's a different thing. And I think partly as a banking commission, the paper somehow, I don't want to blame ourselves, but the message saying this is non-documentary condition is actually not good one.
Who thinks that sanction clause has value in a letter of credit or in other independent undertaking? Who thinks that it has a value to insert?
Yes, please. Let's keep comments short, but yes.
We'll try. So, Pavel, does this mean that it should be left to the interpretation, or there should be a clear guidance that it should be excluded from the LC, whether it's documentary or non-documentary, and there has to be some different type of a guidance given to the banks in order not to leave it to the interpretation?
This is an excellent question. I would like to ask you as well to know the answer, because that's not really a question for practitioners like we are. I understand it's more legal question. And as the paper says, ICC paper says, it's not needed when it comes to mandatory provisions. So you must follow them anyway, right? But I think there might be scenarios when I would be thinking whether it is enough to have only these mandatory sanction laws being applicable, because you might be issuing bank, yeah, okay, that bank is over there, confirming bank, you might nominated bank, or the other way around. If you are confirming bank, mandatory laws are related to you, but what about your right of reimbursement, which is maybe subject to different mandatory laws? So from that kind of legal point of view, I would kind of think there might be situations when it makes sense.
To me, for the sake of time, to me, a sanction clause has a value because it puts parties on notice, and it will help you in certain jurisdictions, maybe. Let's see the case and how this applied to the case.
Yeah, very quickly. I think we should move away from this discussion about whether it's a documentary condition or not. It's about the character of the instrument that's been issued. So when you say irrevocable, or when you say we undertake to honor all claims, this is typically wording that tells you how the letter of credit is going to work. So you insert a sanctions clause, it is telling you something about the character and the basis on which this payment instrument is going to work. So it's nothing to do with documentary conditions. That's the way I feel about it.
It is, yeah.
You're right. And most of the clauses don't make sense. Let's just be clear about that. So please proceed. Yeah.
Let's proceed. And this is IC analysis, which went in the same footsteps that we discussed, but never reject documents based on an internal policy. And here is a case that in which the sanction clause worked for the bank that inserted the clause, which you have heard about from Robert this morning, a confirmation advice with the sanction clause, and it has been in the specialist trade finance news. And I'll briefly discuss, go over the case. And this beneficiary, Covera, contracted with a Dubai-based applicant buyer who applied for a letter of credit issued by an issuing bank in Dubai, and the issuing bank nominated JP Morgan Chase Singapore as a confirming bank. JP Morgan confirmed the LC. However, it added a sanction clause to its confirmation. And this is the wording of the confirmation with a sanction clause. This is how it read. And it says, we shall not be liable for any delay or failure to pay, process or retain such documents, or for any related disclosure of information should the sanction be breached. Covera, the beneficiary, presented documents after the shipment. The bank had suspicion about the vessel, the ownership of the vessel, and they declined to pay, although the presentation was in compliance with the letter of credit terms and conditions. And Covera took JP Morgan to the court, and JP Morgan has been vindicated, i.e. the sanction clause worked for it. Any comment on the case?
I agree with the wording because when there are sanctions, you can't pay. Even if the trade finance wants to pay, the bank compliance will not allow you to pay, because ultimately the banks will be, forced with hefty fines from US or from UN or so. So to avoid that, banks will not take. We have come across many situations. So even though we want to pay because the documents are in compliance, but if there is a sanction party in it, they don't allow us to pay. It's the compliance, ultimately we have to take the compliance weave. So what the compliance says is not to pay. So we cannot override compliance rules. So most of the cases, we don't pay. We have come across many situations like that. We have not paid due to compliance. If it is a sanction party, clear. If we have the, our clause suffice the requirements, we have done. And then, most of the cases, what we have told the parties to settle outside the LC. Sometimes they have taken us to courts. Sometimes it goes, nothing happens. Yeah. So in this situation, I think the verdict is also fair.
We said,
this is my opinion.
Yeah. We said these issues are important for everyone who is in trade finance, and there are lessons to be learned.
Yeah. If I may add, Kelly, just a very short comment. There seems to be a consensus that because this sanctions clause was in the confirmation, because it was there, that actually that is why the judgment went in favor of JP Morgan, that it was expressly advised to the beneficiary. But let me tell you, it's coming down the road that regardless of whether it was in the letter of credit or not in the letter of credit, if the sanctions are legally effective in the jurisdiction, the court will be saying no payment, right? Full stop. Now that is contrary to about 80% of what most people are saying, but that's coming down the line. There's no doubt about it.
But at least it puts parties on the notice.
Yes.
Right. Yeah.
Can I?
Please, final comment.
What is a bit confusing about this judgment? There is no clear answer whether judgment would be the same if the sanction clause was not in the letter of credit. The judgment is based on big scrutiny.
I can tell you that judgments are coming that will state, even if the sanctions clause was not in the letter of credit.
Even I have seen a case, where it was not there. We rejected still.
That would
putting the parties on notice, including the judge.
That should have been mentioned. My understanding is that sanction was kind of mandatory, applicable, because that was U.S. bank. So these Syrian sanctions were directly applicable.
Not exactly. Regarding the shipment, it was a Syrian sanctions, and part of the ownership of the vessel was a sanctioned counterparty. So regardless, it probably would have been the same judgment. But there is an interesting aspect on the long arm of the U.S. law, but that's another argument, I think, completely out of our jurisdiction.
So the banks play safe,
And I think,
so I'm looking at time. So please, Kelly, wrap it up in a minute or two.
I'll wrap it up. And whether you are an issuer, nominated bank, assignee, or whomsoever in the trade finance transaction, they are advisors for you. And as you know, it is difficult to know in advance whether a sanction clause will be breached, because sanction clause, there will be new sanction laws that might be enacted after the issuance of the letter of credit, or new names might be added after shipment, after issuance, or so on. So it is always difficult to be aware in advance who is sanctioned and who is not. And here are a few takeaways. I will leave it for my colleagues.
No, I think you should wrap it up, Kelly. Please go ahead yourself. Yeah.
So it is important to carefully review the sanction clause, especially if you are the beneficiary or a confirmer. It's good practice that you are, as an issuer, make sure your sanction clause is plausible. Don't add things like internal policy. And if you have a set of independent undertakings, if you want to insert sanction clauses, if that's your opinion, don't limit that to the issuer, to your issuance of LCs, because you confirm LCs. You get yourself a number of other independent undertakings, like a novelization of a documentary credit collection that is maturing in the future, your reimbursement undertaking. All these are independent undertakings that you need to look at and assess the risk whether you should or should not insert the sanction clause. And if you do not have an automated way of screening the names on the hard documents, look at how you will manage this risk, because there will be so many names that it is difficult to screen manually, whether they are going to automate the process or not. And always keep a line of communication with your compliance, your risk management frequently, and you might have once in a while forum to discuss these issues with them. Thank you so much.
Thank you so much, Kelly. And your slides, his presentation is amazing. And I love the way you have my photo in the bottom right-hand corner. I just think my photo adds a lot to the presentation, okay? Yeah, that definitely is me. So we're going to continue with, for me, is the hottest topic of the afternoon. And lucky our moderator is right beside me. So correspondent banking challenges in the current environment. So Srinat, please take the stage. And I think your panelists, they'll follow you up. Go right ahead. Go right. Oh, yeah. Oh, sorry, Anna. You're the, I know. Sorry, I get confused. Yeah, there you go. Oh, dear. Yes. There you go. Yep. Perfect. Over to you, Anna. Sorry about that.
You mentioned it
no,
right way.
Go right ahead.
So good to be here. Back, and so good to see very many familiar faces I have not seen for a quite long time, and thank you for the opportunity. And that's a big honor to be a moderator with such a great panelist. Let me introduce ladies first. Ines Amirbekian, representing Armenia, coming from Armenia, ID Bank. I am FI and head of FI and trade finance, as well as representing quite young ICC Armenia in the role of executive board member. Thank you, Inessa, for being here. And of course, Srinath Keshevani, who most of you know very well, who was probably the right person to moderate today's session as well. It's a great honor to be on the panel with the fellow panelists, and we all know that Srinath has a very long-term expertise and experience in trade finance, commodity finance, financial crime, risk mitigations, and various topics all related to trade finance. So I think we will have a good discussion, and we will try to leave the floor for the questions as well. As Vince said, it's a very hot topic. We listened, and I had the opportunity to listen to many interesting panels, and most of them related to trade, but of course trade cannot happen without remittance and without cross-border remittance. So we had last year, exactly in March, Vin and IIBLP gave us the opportunity to, and left the floor and opened the floor with correspondent banking being a vulnerable topic by then. And it all started, and we all felt it during pandemic due to the supply chain disruption. But later on, it got more and more severe. And I would say that last year we thought that this was the hottest topic and the most difficult topic. But nowadays, the outcomes are even more severe, I would say. And there are many reasons behind, so we'll try to take you through the regions and discuss on the examples and provide you the live examples from the various angles and institutions. We will try to show you it from the perspective of the mid, small, and large banks, respondent bank issues, which are mainly the biggest pain for the emerging markets nowadays, being landlocked from the global economies of the correspondent banking. And also we hope Srinath will take us to the different part of the world, providing us a different angle and the picture, what's happening in the reality. And we'll try to summarize with some conclusions which we can provide and takeaways. So, Srinath, we talked a lot last year. It was a very good and lively discussion about the problems which we had, and we thought that it was the worst. Nowadays, we are feeling that it was nothing compared to today. So, what can you say about the developments, and where do you see it going?
My view is that the problems have gotten bigger. So that's the disappointing perspective that I have. We've realized the power of geopolitical events affecting the world. Before the geopolitical events, we had the most extraordinary event, which was a pandemic, which completely changed many of the ways in which we're doing our businesses. But specific to correspondent banking, I don't see the situation as having improved at all. It's getting worse. The world is very divided on many of the geopolitical issues. For example, in Ukraine and Russia, the conflict. If you look at votes in the United Nations, it shows quite a division of opinion. In my part of the world, the US-China dispute was very discomforting because, speaking from the perspective of countries like Singapore, which is a part of ASEAN, the chorus we've been singing is, we never want to be in a position where we need to choose between China and USA. And it's completely unrealistic to expect that being in ASEAN, being so geographically close to China that we can live independently of China. China is always going to be an important partner.
Absolutely.
So that being the case, it raises conflicts, it raises contradictions, and it raises tensions. Now, some of the impact was in terms of the supply chains. Because of the conflict between the two countries, many manufacturing processes and facilities were moved to Vietnam, moved to Indonesia, and more recently to India. And as a result of which, there's been a change in how the supply chains are operated, the type of country risks that are dealt with. For example, when you move from China to Vietnam, Vietnam is not as well banked as China is. China attracts a lot of attention, but Vietnam doesn't attract that much attention. So in correspondent banking, the banks and the businesses are finding it a challenge. Then you've got another hotspot in my part of the world, which is ASEAN. I'm sorry, which is Myanmar. Yeah. Myanmar is posing a challenge both socially, politically, and financially. But the fact of the matter is, it's a huge population that you're supporting out there. And yes, while politically there may be differences at the government level, the people are suffering. And we don't have any ready-made solutions. This is one part of what I would have to say coming from the Asian side.
Thank you very much. And probably I would, because Inessa could take us to a different part of the world, it's very interesting to discuss, especially with current geopolitical situation in the region where we come from. Myself, I come from Georgia. Inessa comes from Armenia. And Inessa has a very interesting position in terms of representing both ICC Armenia as well as the mid-sized bank from Armenia. So what would be your evaluation of the situation, and where do you see is the problem same for the whole banking sector, or it's a problem for the specific business lines? And it's interesting to hear from you, and how do you see it, and how do you see it moving? Where do you see it moving?
Thank you, Anna. Thank you very much for the introduction. Thank you for addressing this topic, which is indeed very hot, actual, and also sensitive for many banks and countries worldwide, especially nowadays. Correspondent banking relations in small countries, small economies like Armenia, like Georgia, it creates and provides significant essential infrastructure for economic growth, for financial inclusion, and for international trade, of course, and international trade finance, which is impossible without assistance of correspondent banks for our countries. Accordingly, the withdrawal and termination of correspondent banking relationships in our countries, and like small countries and vulnerable regions, may bring about financial exclusion, and such tendency is currently addressed by World Bank, by IMF, different large institutions and organizations. About Armenia, I would like to present you the picture what we have. We have dollarized, mainly dollarized economy, dollarized trade flows, and the main settlement currency we have are US dollar and euro. And at the same time, during last years, due to de-risking policies of our correspondent banks, we have a slightly gradual historical withdrawal of correspondent relations, and currently only 2 Armenian big banks have, for example, dollar accounts with United States banks. The other banks used to work through European and Russian banks until last year, until February of last year. Last year, the things dramatically changed because it was no longer possible to work through Russian banks, and our bank, as well as many other small and medium-sized Armenian banks, started to look for new correspondent relations, which is very, very difficult to find now. Of course, some banks managed to open some accounts. For example, our bank, we have success, but most Armenian banks currently have limits for making payments, both for their customers, cross-border payments, and for themselves, because of limited geographies, because of sanctions, impact of sanctions. It is not that easy. What we do, we work with our customers and convince them to switch to the currencies, to the payment in the currencies of exporting countries. At the same time, we make negotiations with the banks in those countries. For example, we opened Chinese yuan accounts with China because we have trade flow. We are currently here to establish relations with banks in Dubai. It is not an easy job, but this is the way out, I think.
Thank you very much, and thank you for some solutions and the tricks that are very important, actually, because I don't think that there is one single medicine or one single solution for this very difficult issue. And I think that we have discussed this previously throughout several panels, that it's affecting not only the banks, it's not only the cost income issue for the respondent banks as well, because it's very costly for the banks, established banks, mid-sized banks, to lose its opportunities of doing business in the country or in the region, and to have also the competing power basically is it's something. So it's evenly felt with commercial banks, with the country and economy, and the SMEs. And the SME, we all know that are the main drivers of the economy. So Srinath, you have many titles, many titles, and I'm very honored to be here with you today. And I really want to hear from you. What do you see as type of a solution? Let's call it this way. You also represent trade assets today. So
thank you for mentioning that.
Do you see that there are any opportunities besides suggestions that Inessa gave to us today?
Having worked in the correspondent banking space, particularly through trade assets, the one thing that you realize very quickly is that the correspondent banking architecture globally is somewhat atrophied. You have a hub and spoke architecture where each bank maintains its own set of correspondents, and you've got these multiple hub and spoke formations across the world, but there's no proper connectivity, interconnectivity. So correspondent banking, unfortunately, is an area where pricing of bank risk is not transparent. Mm-hmm. When you talk about foreign exchange, when you talk about commodity prices, when you talk about other financial assets, you turn on a Bloomberg, you turn on a Reuters, and you get some indication of what's the going price in the market. You don't have anything similar in correspondent banking. And in fact, I recall an instance where when I was working for a trading company. It was a French bank, and the quote between the French bank's Singapore office and the quote for the same risk of the French bank's head office was a multiple of 3 times. And so it's more a question of supply and demand rather than assessing the riskiness of the asset in terms of a bank's obligation to pay on a future date. So we need to bring some light, we need to bring some transparency into the whole process, which is one of the things that we in trade assets are attempting to achieve. Other than that, I think there needs to be a consensus. More importantly, I mean, trade assets is one small part of the bigger solution. The bigger solution is there needs to be a consensus that it is in nobody's interest to engage in financial exclusion. We need to get a way to get over this hurdles such as the cost of maintaining accounts and compromising on connectivity. Because everybody stands to gain when we're all connected. And that is something that I'm hoping platforms like ICC and other parties equally prominent will champion. I know a lot of work is being done in this area, but I'm hoping that there'll be louder voices and more influential voices. Like, for example, I know the multilaterals are also, saying their pitch, but we need the governments to come in and actually give a push to this. We need the central banks to give a push to this. And that's hopefully when we might gain some momentum.
Thank you very much. So basically, while you were speaking, I wanted to ask if the regulators have the role here as well, and you definitely defined it very well. On the other side, from my perspective, and I think Inessa would share that multilaterals really play an important role here. And this role is evenly seen in many countries where they have their representation. Especially when you, as a member, banks for the TFP programs, for example, for all MDBs, you have an advantage to talk to and to get connected to the correspondent banks as well. That's one story, but after pandemic, we see that there are a lot of constraints, and these constraints have driven the attention to a different side, which are also very important, like digitalization, law on electronic documents, and various other very important topics. But at the end of the day, and please correct me if I'm wrong, that the cross-border trade cannot happen without a remittance at the end of the day. So we should not lose the focus. And your comment on ICC getting a leadership, or other regulatory bodies and getting leadership in this area, it's very critical.
Yep. Thank you.
And from your expertise and experience in financial crime, would you think that this has affected recent changes as well, and how it has affected, and where do you see the developments? And the previous panel actually somehow attached this point of the sanctions as well. So
financial crime is growing, seems to be growing at a pace that the banks are not able to keep up, is my sense of the market. There's also different ways in which certain jurisdictions are addressing the problem of financial crime. Some are quite frankly paying lip service. And they're not being really serious in implementing controls for financial crime prevention. And there are others who are very strict about it, but the question is, are they fighting a losing battle? This is not to suggest that they give up. It's not to suggest that it's not worth beefing up our resources, but this is such an insidious problem, and we need to have the agreement as well as the common view that this is something that we cannot coexist with. I do not foresee a day, at least in my lifetime, that I will be completely exterminating the impact of financial crime. But even if there's some reduction, and that there's a trend of reduction that goes on for the next few years, that will be such a huge improvement. Now, there is a lot of activity happening in terms of trying to address this problem. We saw two presentations just prior to this, our presentation here, which address this issue of financial crime, and a lot more work needs to be done. But again, it's the central banks that set the tone. And unless they are, doing strict enforcement, the banks too will not take it as seriously as they should.
Cannot agree more. And we, I think, have some time.
Yeah, you have. and just for questions, because a lot of people are so interested. Oh, okay. So good.
Inessa, my question to you, and I think you very rightly pointed out your ways and solutions, or ways you're finding out to solve the issues for your customers and for yourselves as well. And I suppose that many mid-sized banks are trying to do the same in the region. But as long as we do not have on the panel the correspondent bank today, unfortunately, What would you agree with me in the saying that there has to be a better? I mean, there has been a wake-up call for past couple of years for the respondent banks and for the correspondent banks as well. So, what has to be fixed? What is the solution in the dialogue or in relationship with the correspondent banks and what they are expecting? You said that you had one recent good onboarding, and how did you achieve it? What is the secret behind that?
Thank you. The secret is mainly trust and sound personal and business relationship. And the wake-up call was about, in Armenia, was about compliance, better compliance, faster compliance, knowing your customer, knowing your customer's customer. So recently in Armenia, all the banks who had correspondent accounts, they had to do compliance audit in order to be eligible, not just to be onboarded, but to continue their existing relationships with correspondent banks. Our bank also had done the compliance audit and received quite a good mark, as I may say. So we continue this approach, compliance approach, to all our customers' transactions. And we even hired additional staff in our compliance department in order to not only screen automatically the transactions, but also to check the goods.
So you accepted the challenge of increasing the costs in order to maintain the good relationships with your new partner banks.
Yes, because currently this was the only way out for us as a medium-sized bank.
Very good. So would it mean, I'm looking on the strict eyes of Vincent, would that means that you're trying to adhere to the policy and the requirements, and you have a constant communication with the correspondent bank, and they are communicating, and you know what they are expecting from you, and you're trying to adhere to their rules? I think that's kind of a conclusion that the banks have to communicate more. The correspondent banks should not only criticize the respondent banks, but also need to set the rules of the game. And the rules of the game has to be clear. I guess in nowadays world, especially when there have been many burning points for the respondent banks and also for the correspondent banks, because they need business as well. It doesn't mean that they want to divest from the businesses, and there are good markets where they see that opportunities, potentials, relationships, personal relationships, and they also see that it's important to keep the economies running. And I do hope that we will have the opportunities to discuss next year more optimistic outlook. And this more optimistic outlook, Srinath has provided us some hints that could come from the technology and fintech side as well. So good to see that coming as well, because it's very much needed to diversify the opportunities as well, besides diversifying the currencies and the regions. So we need correspondent and respondent banks still before the technology takes over. And we can now, I guess, open the floor for the questions. If the panelists don't have something.
KPO has a question on this subject.
The corresponding banking challenges. Is it the challenges the customer has because of the correspondent bank, or the correspondent bank having because of the customer? Jokes apart. I ask this question with a particular intention. There have been many, many occasions in the recent past after complaints have become a big issue, where the correspondent bank holds the funds not for short time, sometimes a week, 10 days, without any response to their counterparty. Does the ICC has got any norms that the correspondent bank has to react or respond to, a transaction in their hand within a certain period of time? Or if they don't have, do they intend to have one? Thank you.
Would you like to take it? Or?
Okay, I mean, if we're talking about LC reimbursements, yes, there is a time limit.
No, payments. It's payments.
Yeah, but if it's any remittance, then it's clearly a malfunction of the system.
Yeah, and it's up. I mean, let me answer you from the last point of your question or comment. No, ICC doesn't have any control or rule, as you know. And unfortunately, it very much depends on the correspondent bank and the chain of the payment. And banks and the customers just need to be patient. Is it right or not? Of course, it's not. But
I work in ship chartering, where every second the clock runs, huge amounts of outflow happens. And here is you, a customer like you and me, remitting a freight or a charter hire, and you don't know, next 1 week, 10 days, you don't know anything what is happening. Your bank says they are giving you copies of the messages they are sending into correspondent bank. The correspondent bank not reacting at all. And this has to stop. I mean, if they take up a role in the business, they should work to that role. I mean, I don't have any problem in compliance. If they don't want to do a business, let it be. I had many cases in the recent past where, I mean, they sit on the funds for 1 week and then it comes back, or 10 days it comes back, and or they say that they complete the transaction, but after a substantial period of time.
Unfortunately, this is not a new thing. It has been there for at least 10 years and more, I would say. And the term of holding the payment, it's also not defined. And usually we see this with the USD clearing mainly, unfortunately. I would ask a question if the technology can solve this, but I doubt that there is an answer.
And as Srinath kind of said, this problem is actually increasing. And one thing I find so disturbing about it is 10 years ago, you're right, Anna, it was there, but people would try to give you an intelligent answer or at least something to explain, you know, but now nothing, you hear nothing sometimes.
Now answer is AML, KYC.
Yeah.
My question is slightly different. Correspondent banks are heavily reliant on message exchange using SWIFT. SWIFT neutrality is probably questionable at the moment. So do you see groups of countries, regions, using more blockchain and fintech to exchange messages with each other, and by default SWIFT dropping down?
Srinath, would you like to answer that as well? Or should
well, good question. Very good question. In my experience, and speaking from what is available on trade assets, for example, we do have a messaging system on trade assets, but it doesn't have the security features that SWIFT has. So I wouldn't say it replaces SWIFT. SWIFT is still very important, so it's connected to the core banking system, whereas many of the fintech solutions are not necessarily within the linked to the core banking system. Depends on a case-by-case basis. But I do not see any of these systems at this point replacing SWIFT. Now, the recent instance where Russian banks were excluded from, or they suspended their access to SWIFT was suspended. I read that somewhere. I believe they came up with their own system of communication, which is a parallel to SWIFT, and they are trialing it out with some friendly countries. But I don't think anywhere close to the dominance of SWIFT.
Yet.
Yes.
And after the break, we have an intervention by Herman Hannick, and he will be talking about the fragmentation, not just of the communication system, but the fragmentation of the global trade system as it stands. So that's coming about after lunch. So after break, sorry. I got no lunch, so I'm hungry, you know. Yeah, okay, sorry, Anna. Continue for about 5 more minutes or so, you know. Question? Yes. Question? Oh, sorry, Pavel. Yeah.
If I can maybe add to that question, I'm wondering whether you see a surgence of using non-bank payment platforms such as Wise. So basically making payments not using banking channel as a primary.
We touched this points, not directly, but through fintechs. Probably, Pavel, you mean through fintechs, right?
Well, you have the likes of Western Union, for example.
I think they're still not
but at
ready.
the end of the day, there are banks involved there too. I mean, Western Union also uses banks, ultimately to move the money. So it's just that at two ends you have the Western Union office. So right now you have fintech platforms that are involved in, you have the telecommunication providers who are major movers of money in many parts of the world. Like, for example, in Kenya, you've got the M-Pesa system, which is very successfully moving money between two subscribers of the phone service. But at the end of the day, it has to go through some clearing system. And that's where the banking system comes in. So there will always be, I believe, as of now, some interface. Even when it comes to financing, receivable financing, which is done on fintech platforms, at some point a remittance has to be made. So how does that remittance reach? It goes through the banking system again. So there is always this interface, so far as I've seen in my experience. So I'd be open to being corrected by anybody who has more experience in this matters.
Yeah, I would just add that it's still very far from substituting the bank transfers when it comes to trade.
I'm not sure whether there's a serious attempt to want to move away from the bank system.
Yes, and we are challenging ourselves here today, and I guess that many banks are challenging themselves today as well. It's that the difference is that we are doing it from the stage and others are doing it from their offices. Otherwise, all the attempts which INESA provided to us and all the attempts or the insights we tried to provide is just our insights from challenging ourselves how to solve the issues, because the economy has to develop, otherwise there is no future for the countries to evolve, and it's impossible. Of course, there is always ways, and it's better to avoid those bad ways. Otherwise, we know that we discussed it today during the lunchtime, that we see that some goods are reinvented as well, from the origins of the goods are reinvented as well. So do we have time or not?
Well, we're kind of wrapping up.
We just wanted to touch ESG point, if you don't mind, because Srinath has something to share from the payment side on the ESG as well, which is very important because we see correspondent banks quite actively interested in the ESG.
Okay.
I'm reminded of an instance that happened quite recently. A Singaporean bank was part of a consortium of banks in a syndication, and they refinanced an Indonesian coal company. The Singapore bank has a well-defined ESG policy, but now its credentials were being questioned by the community at large because they refinanced a coal company. So, it sort of puts banks in a very difficult position, because at the end of the day, you don't go cold turkey on fossil fuels just because there's a policy. There's a transitionary period by which you try to reduce your exposure. And for all the talk that we see about fossil fuels, as in coal, we don't see the bank shying away from financing oil cargoes. Mm-hmm. There may be some policy statements being made, but oil cargoes are being financed very easily. There is no problem in getting banking interest for that. Mm-hmm. So there's a lack of clarity again about ESG. And ESG is also, while it's certainly a global challenge and it's certainly a priority, I have no doubt about that, no two ways about that, it's changing trade patterns. Mm-hmm. So for example, if we're going to have a very large solar power generation grid, then the type of metals that will be required, the demand is going to just shoot up. And commodity markets are already seeing these signals and are looking to see how they can monetize these opportunities. But then again, the correspondent banking system has to catch up with these changing trends. And therefore, appetite for risk, country risk, bank risk, this has to be reviewed in line with what their customers are going to need. And we're not there yet.
Thank you. Hope to get there. Sooner than later.
Eventually.
Thank you. That's wonderful. And this was such a practical panel, and you managed to navigate very sensitive issues, but I think you did it very, very intelligently. Like, the reality is hydrocarbons can't go away, because if they go away immediately, cold turkey, I like it, the world will just stop running.
Mm-hmm.
The usage of coal is actually going up. It's not actually going down. But I'm all up for ESG, etc. But now, seeing as we were talking about chicken wings earlier on, and now cold turkey, I got to have a break and eat something. So we're going for the coffee break. So we'll be back. We'll be back in 20 minutes.
Thank you.
And then we're back following on with Tales from the Trenches. So it's actually getting more, well, continuing with getting into the nitty-gritty of trade law, but mostly compliance. Tales from the Trenches. You'll hear some words from Graham Baldock, head of fraud and in fraud management, etc., in commodities, and Herman Hannick and Susanna Ali from DP World. Have a break. Great.
And Susanna, maybe you can introduce Susanna Ali from DP World Bank here. Let me see your background.
Make borrowers and financial providers to enable trades, because we find that our particular target is on SMEs, because we find that there is a huge gap where a lot of people or a lot of financial institutions are trying to be away or not wanting to finance trade finance due to the high risk profile. And we feel that there is an opportunity for us as a logistic provider, because we have certain capabilities that probably financial institutions do not have, and we'll be able to contribute to a large extent to the society at large too, because this could be also part of our corporate social responsibility that we can contribute to the world. Yeah.
And Susanna, what's really interesting about what you said, you mentioned the words high risk profile. And that's an interesting word to use right now, because in terms of traditional trade finance and the core of trade finance, it's always going to be low risk profile. But you're absolutely right. In terms of the way the world has evolved with compliance, regulation, export controls, KYC, anti-money laundering, it has kind of flipped it on that side into being a high-risk activity to be engaged in. But separate to our discussion, I think you have a key selling feature in DP World, and that is you have a lot of visibility on the movement of the goods, the supply chain, how the supply chain evolves, how the supply chain cycle develops as it goes forward. Would that be fair comment?
Yes, that would be fair, because I think if you are from UAE, you probably know JAFSA, and JAFSA is under DP World, and we have got a huge logistic and port and terminals that we are operating. So as a result to that, our visibility on the trade, the underlying assets that is moving from one part of the world to the other, is actually giving us the competitive advantage for us to actually offer financial services to the importers and exporters. But we are not a very greedy people. We wanted to share that with everyone as well. And as a result to that, our shareholder has come up with this idea of opening up this platform, to which we are saying to financial institutions that come join us. Let's lend to people who really wants to do business. I don't deny that in trade finance there is a lot of abuse where, trade finance is being used by money launderer. But at the same time, I would say that 98%, and I can safely say that 98% of this trade is trades. And as a result to that, we want to move this trade and join us so that we'll be able to also help you to fund, or we can do it through either risk participation, or you can actually be a finance provider on our platform and offer this kind of services to any of the borrowers who is applying.
Okay, and now getting closer to the subject then, but tomorrow, we start off all morning with the Multilateral Development Banks, chaired by Mark Aubin of the WTO. And our second panel tomorrow is Africa, the Last Frontier. And actually, it'll be interesting that DP World will be mentioned tomorrow, the pioneering work that DP World is doing in Africa, and the fact that lots of goods coming out of Africa, not just commodities, would not be moving out of Africa unless you were creating this distribution channel. So it really is a wonderful success story that's unfolding. But now we're here to talk about fraud. We're talking a little bit about fraud, and we're going to talk about it started off with sanctions, but I narrowed the focus down to export controls. So I hope the technology doesn't let me down, because the sound was a little bit strange at the coffee break. This is before we come to your session. So I have, I hope we're going to have Graham Baldock, who is now, he used to be the head of our task force on fighting financial crime in ICC UAE, but now he's in Standard Chartered in Singapore, but he's been a part of the community here, as we know. So I caught up with him last night and I asked him some questions about what he thinks happening in the world of fraud. So the first few seconds will definitely be sounding bad, but then it hopefully will sound okay. So I will try. I think we'll have to skip it. Okay. Sorry about this. Okay. Really, because we had a great presentation. But I'm going to try and summarize what happened for a second in my conversation with Graham. So this one was about fraud. The second one was about sanctions and export controls. So in the first conversation, first question, I said that, and we heard it today. Some people say trade fraud is going up dramatically. Others say it's actually going down because banks are looking at transactions so much carefully and using technology, you know. Well, the gist of Graham's response to going up or going down, he said it's constantly going up and going down. He made a point then that globally it's impossible to have your finger on the pulse of what the level is actually at, okay? And I said, well, that's a bit disappointing. But he said, now we have tools to actually monitor, okay? And we have tools to educate people, and we have tools to actually make it more effective in our monitoring of fraud. It was fraud mostly, but also, I guess, other aspects of financial crime. So I thought that was an interesting comment. But then I actually said, surely the fraudsters, because we were talking about fraud, are keeping ahead of the developments in the technology. And his kind of view was that in instances, probably so, but globally, no. So in instances where there can be a big hit, he said they're getting probably more successful, but in terms of a global problem, he thinks actually we are getting to grips with that as a challenge. There were other comments as well, but I won't go into. But Suzanne, before we talk about export controls, what do you think in terms of fraudulent transactions? Because they must turn up occasionally, you know.
Yes, of course. You can't avoid fraud, and like I always say, even in the most perfect system, there is always a room for abuse. And people would then take advantage. And if you look at today, the regulatory requirement that bankers are requesting from all these entrepreneurs, especially SMEs, they are very simple. They are simple business owners. They just want their trades to be executed. And to them is that, oh my God, you know, I have to produce 1 million documents, including audited financials and whatnot. These are not something that because not all of them are Nestle's or, you know, Procter & Gamble. So we are talking about SMEs who sometimes are being cornered by financial institutions because they are not given that access of financing. And as a result to that, they will look for alternative. And this is where the fraudsters, or this is where the money launderers and the crooks will come in and say that, why don't I fund you and I'll provide you with this funding, you can get your business and how much you're willing to pay for me. And so it meets both parties' objective. One party wanted the business to be executed, the other party wanted to launder the money. So you have a mutual objective that is being met. So these are the things that we in this industry must then start to look out and ask ourselves to what extent we can help. Because we know how much this entrepreneur paid for the price that they pay, especially when it involves all these illegal money launderers and whatnot, you know?
If I can jump in again, sure. You reminded me of a story where I was talking to a particular gentleman who was, he was done for fraud in the United States, but he wanted them to help combat fraud and share his experience. But he used very interesting words with me, talking about his story. Yeah, because he said, yeah, I've been charged with this, wire fraud, this fraud, that fraud. And, but then he said, I became an accidental fraudster. And I said, how can you become an accidental fraudster? He said, it was completely by accident. I said, come on, give me a break, an accidental fraudster. So I said, how do you become an accidental fraudster? He said, well, I have a small business, okay? And I'm discounting invoices. And I was very efficient presenting the invoice and discounting, okay? And honestly, I never intended to take any money or steal money from anyone, but I got in a bad pinch. And then I knew the system. And I knew that I could get my hands on $500,000 that I only wanted for 10 days, okay? So I got my hands on the $500,000 for 10 days, and I paid it back. And I wanted to pay it back, so I'm no fraudster. And I said, but how come you didn't get away with it? He said, yeah, but I kind of liked it. I kind of liked it, and it's a very efficient system. Really, you should try it. No, I said, I won't try it, okay? So then what actually happened, he did it again, but this time he got caught. He got caught in mid-flow. And probably this guy is you know, you say it on live, it sounds, someone will ask you, do you say this? But, you know, he probably wasn't really that bad of a guy. He was just in a pinch and he was trying to survive. But once you start, you're on a slippery slope. And once the slippery slope starts, it gets bigger and bigger and bigger and bigger. And that is the problem with these accidental fraudsters. So when you come across a fraud, like I know you can't be specific, but or what you come across as a suspected fraud, what do you do or what can you do?
So usually it is a red flag when you look at the pattern or whether or not it makes economic sense. Okay. At the end of the day, trade finance is all about how much can you make, and everybody is trying to make a living. And it is impossible to actually sell something for a price, a fraction of a price, when you know that the market price is of certain amount. Okay. And this is where, you know, you sit down and you ask yourself, is this transaction economically make sense?
But how do you do that? Like, you know, that, of course, that makes perfect sense. But in day-to-day, given the volume you're dealing with, how do you do that in a reasonably effective manner? Because sometimes dealing with a regulator, I just know in another jurisdiction, okay, it's not that you have to be 100%, but you need to be taking steps that are, maybe it's not the right word, that are reasonably appropriate, that you are taking the correct action to monitor, manage, identify, and eliminate to the best of your ability. But you can't catch everything. But you're such a big operation. How do you do it?
So what we do is usually we are looking at a system right now, but currently we are doing it manually, where we Google. Okay. We Google search and we look at how much is the price of a goods and underlying goods, how much is it sold, you know, how much is it from an export perspective, and we use HS code from the World Custom Organization.
Very good.
So based on that, it helps us to give us an indicative price, and there is a standard. So we give a deviation. We kind of give about approximately 10% below or above the price. Okay. So anything that is above or below the price, you know that something is not right there.
Okay, that's very practical. And now, given our time, I want to shift over to sanctions, okay? Yeah. And so if I was to say to you, which is your biggest headache, okay? You know, fraud, anti-money laundering, or sanctions? And I know this is not a fair question, but there's only 3 buttons and you have to press one. Which one are you going to press?
I think sanction.
Okay.
Sanction, essentially, I think it gives a chill to every MLRO to their spine. If you guys are MLRO here, I think you all would probably agree with me. If you look at and you read the news, the kind of penalty that financial institutions are getting, it essentially tells you that, you know, something is amiss here. And as a result to that, a lot of financial institutions just take a very easy way out by saying that I'm not going to deal with you, without even wanting to understand the entire sanction regime. So this is where compliance or MLRO need to sit down and evaluate, read the sanction, understand the sanction, what kind of sanction that is being imposed. There are 5 types of sanction. So ours is on the economic sanction, you know, and trades. So you need to sit down and you need to understand that aspect. And trade embargoes, if you're not dealing or you're not financing any, you know, weaponry or whatever, then, you know, you're safe from that perspective. But, you know, these are various things that you need to know. And sanction does not only confine to your client. You need to know who is your client counterparty, who is his counterparty, and there is a whole chain of things or people that you need to identify. You need to obtain information, you need to probe, because not everybody is transparent. Not everybody is going to share the information with you. So you need to be proactively asking questions, and sometimes it will annoy the clients, but unfortunately today we are in a world of which we need to be really careful, because we do not want to be slapped by any sanctions.
Okay, well, to narrow the focus, following my discussion with Graham, which we didn't hear, okay, on the fraud, then I turned to with Herman Honey.
Yeah.
And the conversation started on sanctions, but I knew we'd be talking about sanctions a lot, and we have today, sanctions clauses, etc. Actually, it's very interesting when we had one opinion saying, two people were discussing on stage earlier on sanctions clauses, and one of them said that because the sanctions clause was in the letter of credit, you know, it applied, okay? And the other one said it doesn't really matter whether it's there or not. When the person was saying that doesn't really matter there, I saw you nodding. Looked like you were agreeing with this party. Was that right?
Yes.
Okay, why?
Because, you know, sanction, whether you have it in your legal document or not, you are still subject to the sanctions order. So if the sanction says that you cannot deal with Mr. A from ABC, so you just cannot deal with it. And it would just, whatever clause that it is, this is where probably Robert will be able to help me as a lawyer, you know. The sanction regime would probably prevail over the rights of the contractual parties, because this is something which, you know, it is imposed.
Well, I'm really relieved because you said you can't deal with Mr. A. I'm Mr. OB, so everything is okay for me. So that's really, really wonderful. But narrowing the scope, talking to Herman, like we're talking about sanctions, I said I don't really want to talk about general sanctions. I want to talk about export controls, which I said I believe are sanctions. And he said I wouldn't define them exactly as sanctions. I'm a very simple person. I would, maybe I'm wrong, but I see it as a sanction. So in recent times, okay, we've had an escalation of export controls in the United States. Okay, we've the Buy America Act, the Supply Chain Act, etc. So, and this is restricting exports of lots of things, but predominantly tech, okay? Tech, chips, etc. But then on the other hand, Jin Saibo is here as well, and I'm no expert again, but China. China brought in very significant export controls about 2 years ago, the infrastructure for the export controls, but I don't think has turned up the volume on them, but they're there that the volume could be turned up very, very quickly. So is this a challenge for you, or do you see this as an unfolding new element in your job?
Well, it is, because I think a lot of people wanting to understand that, can I actually deal with this underlying product? And it is a very lengthy document. One needs to sit down and understand the description of the product.
Okay.
And then if you don't really understand it, because we are all compliance officers, most of us are either lawyers or accountants here. We are not engineers, we are not people who develop the product. So for example, I encountered very recently something called crankshaft, which I have no idea what it meant. I mean, in my 50 years of life, this is the first time I heard of this particular device, and I said, what is crankshaft? And this guy came to me and said that, oh, you can use for weapon, and as a result to that, we are not going to do the case. And I said, hang on a minute, please do not make such a hasty decision. Yeah. Let's sit down and understand what exactly this device is. And I did some research. It took me 2 days.
Oh, okay.
And I went through the OFAC sanction list as well as the UAE dual-use goods. And I went through that, and I realized that crankshaft is not something that falls under dual-use goods list. And as it is exempted. So it may be in the list, but it is under the exemption clause. So people tend to, because of time, they tend to control F. I find crankshaft. It is in there, we cannot deal with it. So there is an easy way out. But actually, if you do more due diligence into it, you will realize that the product, you can actually use it.
Okay, so we shouldn't be so hasty in our decisions. Okay, otherwise we just stop all trade. That is actually allowed. That's actually allowed. A little example is many years ago, working in a bank in Ireland, we were doing business with Yugoslavia. And of course, then the situation in Yugoslavia, and then the sanctions came in, okay? And everyone quit doing business, but certain specific transactions, food, medicines, etc., were allowed. Yes. So I kept a channel of business actually going with Yugoslavia. And then, of course, when the sanctions lifted, I was their hero. So all the business actually came back to me. But sanctions come and sanctions go. And if you're dealing with if you are sanctioned and the money, you should pay out under a letter of credit. Well, you can't pay because of the sanctions. Well, what do? You put the money in a block account. You don't let it go anywhere. Yeah. But when the sanctions are lifted, okay, with some checking with the law, etc., then the money can flow. But if you don't take steps at the time you make your decision, would you agree you could be in trouble?
Yes, because if it is, if the particular product is being sanctioned and you are not taking action and you just let it go without any license, you don't go to the authority, you kind of make a decision unilaterally, then you are putting yourself in a hot soup. Because right now, even the UAE has got executive office that permits you to actually, and they say if you are not sure of that particular product, provide the description to them, they will help you. So you go back to them, they are the experts, they'll be able to give us the guidance. And on top of that, they provide us permits.
Okay.
So that permit will essentially save us. And sanction, UK recently had decided that to classify sanction as a strict liability cases. That, sends more chills to my spine, and, you'll be having sleepless night thinking, what if I actually violated any of these sanctions?
I'm getting really worried about all your chills and sleepless nights, I must say. You got to take some therapy or something. Oh, you do? Okay, you do. Well, I'm looking at our time, and unless anyone has any questions for Susanna or for me, and so we're going to we've identified a lot of challenges, but I think we're going to now start talking about some solutions. So, Todd, I think my video may not work, okay? So I'm not going to try running it immediately, but I'm going to hand over to Todd. But if I can check out and I find that it works, in a 50-50, then we'll play the video a little bit later on. And if not, I will leave it in your capable hands. But could we give Susanna a nice warm round of applause for being so open?
Thank you so much. Thank you.
Thank you so much.
Oh, sorry.
That was wonderful. Oh, sure, Sven, go right ahead. Oh, and you conveniently have the microphone beside you. Okay.
Hi, Suzanne. Thank you for that presentation.
Thank you.
And the Q&A. Thank you, Vin. Is there an exhaustive dual-use list?
No. It's a very dynamic and fluid list.
Does every country have its own?
I think yes. Most of the country, I won't say not every country. I would say countries that are more developed. EU has it. UK has it, US has it, and UAE also have it. So even in India, they have it. So you have to look out for it. It is not something that some countries don't have it. Where I come from, it is not. In Malaysia, we don't have it right now.
But surely it can't be a complete list. It can't be exhaustive.
It cannot be, yeah.
So there could be products that actually are of dual use but pass through.
Yes.
Because it's not on the list.
Yes, there is a possibility.
Sure. Right. And I guess you use the data you gain in one country or a few countries that is saying something is not a dual-use good to color your decision of yes or no.
Yes, correct.
Okay. Well, we have people who just cannot resist. We'll have 2 questions, and then we'll hand over to you, Todd, if that's okay. Yeah, please, here, and if you could pass the microphone back here, and then one at the back to Ravi, and we will be moving on. Thank you.
I have a question about RBA action sheet.
About?
RBA, Real Basis Approach.
Okay.
Oh, yeah.
Yes.
And his rules in the due diligence.
Yes.
The question?
Oh, you mean applying RBA?
The rules of RBA action sheet in the due diligence.
Okay. So, risk-based approach, like I said, if you know a client, then, obviously your approach towards the client's risk profile is based on what you know the client. and as a result of that, how much amount of time and intensity of due diligence and in-depth or ongoing due diligence monitoring that you apply on the client. If that client is somebody that you don't know at all, so I always classify all my clients as high risk until I know them. So the period for me to know the client is usually 6 months, and within that 6 months, if I develop or I started to see a pattern, then I would then reclassify the client again.
Really good. I think you have a very balanced approach to actually this, to developing the business, but also monitoring and making objective decisions. Our final question from Ravi, please.
Yeah, so it's not more of a question, it's more of a comment.
Yeah, please. Yeah,
so answering your question, actually, I can probably shed some more light into that. So I wouldn't say that there's an exhaustive list when it comes to dual use goods, but there are kind of multinational regimes that come together from different countries to essentially decide on what goods will be determined to be dual use or military. So you have the missile technology.
I can hear you. Yeah, lift it, but we can hear you.
You have the missile technology control regime, the Wassenaar arrangement, nuclear suppliers group, and they're made up of countries all around the world that will come together and decide on collectively, what should be a dual use item, what should be considered a military item, and then make a list. And then it's up to each individual country's government to decide, okay, let's add it onto our list. So Susanna mentioned the EU has a list, UK, Singapore has a list that comes from the MAS. UAE has their own list as well, and then other countries do as well. But there's a lot of crossover between all of the countries, and what they actually say is dual use and military. So that's how it comes about. And then just one more comment.
Please, please.
So you mentioned the fact that you considered export controls to be sanctions.
Yeah.
So yes and no. Yeah. I would say it depends on the country that's enforcing the export control.
Yeah.
I'd say probably in the last year, the US has used export controls as sanctions, and specifically in relation to China and what they did in enforcing rules about semiconductors. Because what they did is they essentially looked at the end use of their goods and where their goods were actually going to in terms of user. And in that particular example, they found US-made components going to China, being used in Chinese military items that could then be used against the US in the future. So they enforced kind of strict restrictions on specific types of semiconductors and microcircuits. And they said it was export controls, but in reality is a sanction.
I think you're absolutely right. Yeah. Okay, with that, thank you so much, Susanna. That was really, really wonderful. And Todd, I'll call you to the stage, take a seat, and your panelists, I think, can join you. And I'll be checking out the video, but proceed as if with that. Yeah? As if it doesn't exist. As if it doesn't exist. Thank you.
I guess I'll sit here and get comfortable wherever you like. Can you all hear me? Can you hear me? No. Yeah. Yeah. You can. Okay.
Not through the microphone.
Not through the microphone. So. Tell you what, I will just speak loud, or I'll try to speak loudly. So, first, thanks to Vin and to the ICC for having me here. I think this is hopefully going to be helpful to talk to you about, I think, a tool and some guidance, which is not only relevant, but I think it's specifically relevant for this region. But before we get into that, maybe we can just do a quick introduction of our panel. So I'll start immediately to my left with Scott, and then we'll work our way down.
So good afternoon, Scott Ramsey, Global Head of Compliance for Mushrock Bank. Apparently I've turned up to the right place. I was formerly Regional Head of Sanctions for HSBC for MENA, and also Asia Pacific and National Bank of Abu Dhabi. Over to you, Nish.
Hi, my name is Nishant. I'm the head of AML, Anti-Bribery Corruption and Compliance Technologies for Mashreq Bank. Prior to that, I was the global head of transaction monitoring for HSBC for about 6 years and regional head of financial crime Intel Ops for Standard Chartered Bank in Middle East and Africa and Pakistan, and before that KPMG. Financial crime professional for about 18 years now.
Hi, this is Murli. I'm an advisor in CBD. I used to be the global head of trade operations for Standard Chartered, and subsequent to that, I was the head of wholesale banking operations for ENBD Group, a trade finance professional throughout.
Very experienced group, so when you have hard questions, they will go directly to the people to my left and not to me. So for those that don't know me, I'm Todd Burwell. I'm the president and CEO of BAF. Many of your organizations I know are members of ours. And those that are not, we'll welcome you if you would like to join. But I think the topic of the day is really around, we want to anchor it around a guidance paper that was published last year in October, I believe it was, which was a product of the Global Coalition for Fighting Financial Crime. And I am a huge fan of guidance papers. In my experience, the regulators are there to try to stop a problem or what they perceive to be a problem. And they will go through a process of issuing regulations. And in many instances, those regulators don't always have the practical business understanding to know how to take those regulations down to a desk level. So what do I do? And that's where it's important for other organizations to be able to help facilitate that through guidance documents. And so the paper that was published in October, and maybe I'll start with you, Scott, because you were really one of the co-sponsors of this paper. Why then? Why this paper? Where was the push coming from, and what were you trying to solve for?
Okay, thanks, Todd. Look, the project was a very coming together of a group of experts. It was the creation of the MENA chapter for the Global Coalition for Fighting Financial Crime, which also partnered with the MENA Financial Crime Compliance Group, of which happened to be a member of both, so got asked to be the sponsor for this specific project. And our problem statement was, how can we get everyone talking the same language? We've got people in banks who know sanctions. We've got people who know trade. We've got customs people, but no one has the same language. So the idea was, can we produce a bilingual document that addressed all the risks, have nice diagrams so those people who need the picture can see the picture, those people who can read the risks, and be able to go at a top level down to a low level, so that when we're talking to law enforcement, when we're talking to the judiciary and those private-public partnerships, we can bridge the gap by using the same language. How can we use that as a go-to practitioner's guide, not just for banks, but for everyone who's wanting to join the fight for financial crime? And that was really how we got together.
So, quick show of hands. How many people in the room here have read the paper? Okay, so the next most important question, how does everyone get their hands on the paper?
We tried to be environmentally friendly, so we didn't actually produce too many copies, but we published it widely. You can get it on the Global Coalition for Fighting Financial Crime website. I'm not here to sell anything, so don't take that as a sales pitch. That is www.gcffc.org.
You can email it later on.
We can provide it as a PDF to be shared to people.
Excellent, excellent. And so I think one of the things that I read about this paper is that this was not just a paper for paper's sake, but to your point about regulators actually being consumers of this, talk a little bit about how it's been supported, how it's been received by the regulatory community.
Look, it's been quite positive already. I'm sure Nish was recently Bahrain that published their trade finance guide.
Yeah, Central Bank of Bahrain.
So we've had the Central Bank of Bahrain acknowledge this paper and use it as one of their references for the new document they've just produced. We've also seen the AML Executive Office in the UAE share this on their LinkedIn page as a go-to guide for practitioners. It's there as a reference guide. And this is just step one for the joint project between the MENA FCCG and the Global Coalition for Financial Crime MENA chapter. They've actually signed an agreement with the university to create a course so they can train people on it. And this will be stage 2 of the course, which is already in process. And they're actually just trying to create stage 1, which is to actually teach people about trade finance. Although our document is quite good, there is a underlying knowledge that you need. So that's the next steps.
Yeah, so just from my experience, regulators will not officially endorse anything. But when they refer to the work that you've done, they've endorsed it. So what that means is that they are going to examine you in accordance with the guidance that's been published. So I would take it with that level of seriousness. So let me switch over maybe to Nishant. So you've had the pen, right? You were one of the authors of this document. Tell us about what's in it. What were some of the key points, some of the key takeaways that people would be able to get from it?
Sure. So essentially it was born out of a lot of frustration in my own lifetime as a practitioner in financial crime. As I said, I used to be in Standard Chartered Bank as a regional head of financial crime, intelligence ops, as well as global head of TM at HSBC. TBML was always the hardest nut to crack. And you can't really have that not cracked in the largest bank, HSBC, which is the largest trade bank of the world. So it was, and as we started getting really in depth into it, I experienced a lot of frustration because, one, I did not understand trade finance. Yes, I had basic stuff that you read, but when I speak to even a mid-level trade finance specialist, I could see the knowledge gap was so huge, essentially, between myself and that person. And then when we go and speak to technologists who help us with the tools and capabilities, they were talking a different language, and none of this was really meeting up. And then you had regulators walking in and saying, oh, TBML is the hottest thing, and it's been going on for like many years, and what have you done? All we could say is, yeah, we got a bunch of scenarios in our systems. Nothing really worked, essentially. So it was frustration built over like 10 years of my practice that led to saying, okay, we got to really do something about it. So the GCFFC and their initiation was a good starting point. And what I was able to bring, or the key value that we were able to bring, is bring the best experts in the world who knows their subject across the platform to come and contribute. So we had individuals like, for example, Graham Baldock, who used to be the global head of financial crime for trade finance in HSBC.
Who may or may not be on a video.
and we had a professor from King's College who also used to be the UN 1737 expert, evaluation expert. We had the regional head of sanctions of other banks. So there was a bunch of people who came together, and we were led by 2 key principles. Number one, it must be a document that all the key practitioners, whether they are the law enforcement or the judiciary or the ministries of, for example, economy or ports or customs, the bankers, the technologists, and the regulators at all levels should be able to open and read and not go beyond the second or the third page. We really wanted them to read it. So we wanted to bring the crux of the whole knowledge into it, but in a way in which it is easy to read. And the second key principle that we drove ourselves with was, we wanted to change the focus from trade-based money laundering, because money laundering is just one part of it. We renamed it as trade-based financial crime because I wanted to cover fraud, money laundering, sanctions, as well as bribery, corruption. And the whole document has been built in such a way that it covers all the 3-4 major facets of underlying criminal activity, but also talk about very practical ways to build your capabilities at all right kind of levels. Finally, we also had to set the scene very clearly, saying 80% of the global trade happens in open account. So there's no real trade financing in 80% of the trade. and this is one of the biggest mistakes that a lot of people who don't understand trade does. They try and throw off and say, oh, TBML, the only way you can fix it is by building scenarios, etc., and covering how LCs are being written and so on and forth, etc. So we kind of wanted to change that narrative to say, hey, you got to combat this in different ways based on the dimension. So that then led to a year-long effort to write up this document.
So, and you mentioned you recruited, subject matter experts, the best and the brightest, and they always agree. Right.
Then, well, I had quite a few instances where there was disagreements, but which is the case with the experts. And me as a project lead, my job was to, help them bridge those gaps through good conversations and debates, and sometimes I had to twist the arms a little bit too.
So tell us a little bit about where were some of the areas of conflict, and I'll use that word to differentiate between, style of writing as opposed to substantive differences on a view of how practice should be conducted. So give us a couple of examples and how did you resolve it?
So one of the team members was an expert in the UCP and the trade loss part of it and the rules, etc., and was taking a more academic view of some of the risks, essentially. And it was rightly so, because he or she was a brilliant expert in that area. But I kind of felt that it was, and of course the rest of the team members were feeling, oh, are we kind of going a little bit away from the core objective of this document? And we had to kind of dial it back down. But we kind of then agreed that there is a lot of value in that conversation, because there will be people who would want to read it to that level of detail and link up the requirements. So we then built a full red flags piece for running to about 20 pages in the last pages of that document, which actually brought the value that the project team member brought in, but change the dimensions to make it sensible when you're building out your controls against the specific set of risks that you want to kind of pick up from.
Yeah.
Just one example.
So Murali, let me bring you in here. So you're a consumer of this guide. Give us your best critics review. What have you found to be most helpful? And where do you think there's additional guidance or additional work that the industry needs to do to really be helpful?
Yeah, before I get into that, I thought I should also give a context into why this guide is required for this region in specific. If I were to give you some facts, the Dubai International Airport is the busiest one as far as the world goes. The Jebel Ali seaport is roughly the 9th busiest in terms of cargo handling. The Doha one is about the 10th in terms of cargo handling. If you were to look at the expectations in terms of non-oil revenue trade, it's about 540 billion in terms of dollars. And considering the sensitivity of this region with the disturbances all around, there's an absolute need for people here to increase their awareness in terms of trade-based money laundering. So that was probably the need to bring out from the basics down to the advanced stage. And I think this document addresses all that through. So whether it is a newcomer into trade or a newcomer into compliance or a regulator who's probably seeing it for the first time, he can relate to it.
Okay.
And it also helps with some case studies which have come in there, which probably are global, but give a context to the regional people.
Yeah.
So I think it covers all those aspects. But where I would probably like to see much better of it is the implementation in terms of various financial institutions. I think if you were to go for the information that exists in many of these places, it starts from manual to semi-automated to automated. None of them are fully automated. And there exist many data points within the organization, which probably the various departments, like if you were to go into a bank, it starts right from the account services where you open the account, the due diligence, which does the enhanced or the standard due diligence, the operations, the payments or the trade operations who use it, the relationship manager who handles the account, down to credit who disburses the facilities.
Yeah. And
compliance probably is a link into all of them, giving the policy guidelines and then trying to get all of them together.
Right.
Now, most of these departments, TBFC, as is in the document, is one of the core activities. It's not the only activity that you do. And they may not be giving it the attention, or they're not expected to come up with this level of information.
Yeah.
So bringing them all to the same page, like what Scott said, bringing them up to the same page in terms of at least a language that all are able to relate to was the need. And that's why this document steps in.
Yeah, so actually you just triggered a thought for me, right? So you referenced sort of the evolution of trade becoming more digital. Certainly we've heard a lot of interest and push for trade becoming more sustainable. So there's going to be increasingly changes in the way the business is done, the expectations on each of the parties. And so maybe I'll come back to you, Scott, and ask any of you to jump in with this. Tell me what you envision to be the periodicity with which this document may need to be revisited, right? Because obviously any point in time is great for a point in time, but business is always changing. You know, do you think that this is something that foresees those evolutions, or how soon do you think this may need to be revisited?
Look, I'll give the initial answer and then I'll get Nish to jump in. Look, one of our things when we put together the scope for the document was to try to foresee where future technology was going, but also to go to what are the general concepts. And if you look at how the payment systems are going, if we just look at payments aside, it's the same principles. And so they are directly applicable. But if there's a need, it will be updated. But over to you, Nish.
Absolutely. I think there is two key drivers for an update. And as Scott rightly said, the changes in the technology is what I look forward to as being one of the key triggers for rewriting it. Because right now, I believe that still, even today, a good part of the whole trade operations is still very much the same as what it has been for the last, say, 40, 50 years, essentially. Despite all the efforts to do digitization, etc., there's been good progress, but there's not been a sea shift, essentially. And I think there are technologies out there that could potentially shift the game significantly. If that happens, I think significant parts of the document have to be rewritten and updated to reflect for the new changes. The other thing that I would really look forward to is the shifting position on sanctions constantly. I mean, we all know Russia sanctions and how it has changed the landscape in barely, 12, 18 months now. And previously we have all been exposed to Iranian sanctions, but that's been existing for decades, essentially, with minor gradual shift. And here, if this is the speed at which things are changing, and the fact that there is geopolitical pivoting going on in terms of East versus West, and well, it's not just East versus West, there's a multipolar powers, etc. We might have to look at trade-based financial crime in a very different way, because crime itself could be defined in different way by different people. Yeah. So as being probably one of the few Americans in this room, I will take all of the heat for the extraterritorial nature of my countrymen and how we approach sanctions and export controls and so forth. And I'll maybe just add a little bit of my own personal anecdotes that it's interesting at how few people really know or understand trade until we get mad at somebody. And then trade is the first place that we go to try to punish our counterparts or our geopolitical adversaries, so to speak. And so I think that that's existed probably since forever, and I think you're right that it probably will continue to exist. It also brings me to a point that I think is relevant for this region as well, and something that we've heard quite a bit is the energy from policymakers and regulators on sanctions avoidance, right? So there's been a lot of discussion around sanctions. In the last section, we talked about sanctions. And, you know, clearly the point of sanctions is to try to penalize certain behavior. And what often happens is you have the collateral damage associated with it because it interrupts natural commerce. And in this region in particular, where there may be quite a bit of dependence on energy flows, on grain flows coming out of the Ukraine and what have you, means that financial institutions will be under increased scrutiny, and the expectations will be raised
for you to identify sanctions avoidance. I wonder if any of you on the panel can comment on the discussions that you had in this process about how organizations, particularly in this region, should be approaching sanctions avoidance.
I suppose that's me. Firstly, carefully. Look, if you look at if we speak mostly Russia, February 24 last year, I think by August, my legal updates on change in sanction regimes was up to about 40 updates over a multiplicity of regimes. You may tell from my accent that I'm not from here, from New Zealand. So New Zealand decided to enforce a Russian sanctions regime to make it extraterritorial and apply to me, which is the first time that's ever happened, being a sanctions professional for the best part of 15 years. So it has caused a lot of issues, and you've had to look at problems so many different ways. You've had to look at the goods, you've had to look at the currency, you have to look at the actors involved, you have to look at the people involved. You know, down to the point that I've, for my bank, had to do a diagram of who holds what nationality about what we need to do and the different policy objectives that different regulators might have. And I think you kind of hit the nail on the head when you talked about grain. And, you know, grain is such a core ingredient for the food security in Africa and in the Middle East, and about trying to make sure those things still go and how you support that. So sometimes as banks, we do find ourselves in the middle, but, you know, we have law firms on retainer. We talk to the other banks as well, and we talk to our correspondents, and we just keep talking about what we can and can't do. And the number one thing you can always do is transparency. If you're transparent about what you're doing and who you're doing with, that's your key defense to anyone coming along later and complaining, you didn't tell me you were doing that. So if you have good transparency in your trades, when you're dealing with your counterparties, it's your number one defense.
Yeah.
Probably the best answer without going too much detail. Sorry.
If I may add, I think knowing your customer is the most important. So earlier we used to talk in my previous bank, we used to talk about ecosystem for sales that is covering right from start to end. Now I think the ecosystem applies for compliance. Yeah. In terms of knowing end to end who your customers, who their parties are, who do they engage with, etc. So knowing your customer obviously is the beginning part of it. And then the enhanced due diligence, the standard due diligence, the relationship knowing the account quite well, the credit people knowing the account quite well, trade operations looking at every transaction with the customer behavior in mind. So probably if you asked me an earlier question, how would I like to see trade operations doing? So when I get a trade transaction on hand, there should be a customer dashboard which exactly tells me what has been passed with us. Yeah. And then that should relate to the industry in terms of the information available. Yeah. And then we should have the governmental agencies who probably have their lists, etc. So all the three combined together, you have the data points that are required to decide on the transaction. Right. But not one transaction decides the customer behavior. Yeah. So you need to combine all of these together. Yeah.
I suppose the only thing I will add is because of the complexity of what we're facing at the moment, and look, you know, Iran took forever, took a number of years, is that your customer may not know what they're doing is wrong. Yep. They may not know that they've got a hook into them. I can remember one case with a customer in Germany, 5-6 years ago. You know, it takes a lot for someone to complain to the chief operating officer of HSBC about someone in the Middle East. They duly did complain. And then 6 weeks later, there was a letter of appreciation when they finally understood what we were saying to that person and how they were personally liable, because the person, while he owned a German company and was German nationality, he was a dual citizen and he was a US national. So as the owner of the company, he still had those obligations that passed over. So sometimes, especially in these places, it's about not just understanding your customer, but understanding the different risks that the regimes are bringing in so that you can do thematic reviews to identify some of your customers that may not know that they're doing something that's wrong. And that's where the educational piece comes in, about working with your customers. Nish, do you want to add?
Yeah, I mean, sanctions avoidance, sanctions circumvention. I guess just like tax avoidance and tax evasion. Tax evasion is, it's like black and white, but there is something called now, third thing called aggressive tax avoidance, which is almost bordering on tax evasion, or at least that's the way in which regulators are. So I guess from our perspective, it's two things. There are certain areas where even if you had X amount of data, it's just not going to help if the intention was always to mix up. Like, how do we ever know that 1/3 of the molecules in that crude that is being transported by that particular crude ship actually has its origination from, let's say, one of the sanctioned government crude oil producers, because it has been mixed up in 3 different places. Yeah. And then it has been transferred ship to ship in high seas where they have switched off their transponders. And then, you know, the money has flown through about 15 different layers of companies all mixed up. Stuff does happen because we have, I mean, in my personal experience previously also I've seen such kind of actions related to different sanctions regimes in the past, like, 10 years ago. And these kind of things never change. Yeah. So I think transparency is one part. It's not just banks alone. Everybody in the ecosystem has a role to play, including shippers and customs. There's a lot of data out there, as Murli rightly said, but it's not coming together into the right place. I guess maybe one of the fintechs who ultimately crack that problem and bring all that relevant data, including HSI harmonization and the right kind of pricing information, we're going to be billionaires.
Yeah. Vin, I sense you wanting to jump in the.
Well, regarding the video from the chair, Ibtizam Lassoud, we're going to play it. It's 50-50, okay, whether it'll play, but I'm an optimist. But Nish, regarding your comment on that ship, I want you to know that I'm the owner and the carrier, so be careful what you say about this ship.
Oh,
okay. So let's try roll the video, and it's only 2 minutes, so 50-50. Let's give it a go.
Assalamu alaikum everyone, good afternoon. First I would like to say thank you to the ICC for the endorsement of the guide and its efforts to promote its use among the trade community. The guide itself is the culmination of a lot of work, so it's really great to see it being given the recognition it deserves. And ultimately, we hope that this means that it will be as widely used as possible. Already, we have seen the Central Bank of Bahrain reference it as a reliable guide, and with the added endorsement of the ICC, we are moving towards our goal of providing widely utilized, high-quality, accessible resources for this intensely difficult issue. So the guide was released back in October of last year. It's bilingual, English-Arabic, but this is by no means where the work stopped. So once Nish and Graham and the rest of the team had finished compiling the English content during the summer, we then went through an extensive translation, but also design process to get the guide into the final format that is accessible on the GC, FFC and MENA FCCG websites today. So the team that was involved in that process has now moved on to the second phase of the project, which we are extremely excited about and which I will use the remainder of my time discussing today. So keeping our eyes ahead to that long-term time frame, the other benefit to our extended partnership, up-to-date thought leadership from the industry, building in timely and relevant, ultimately ensuring that they are equipped with the most recent thinking by the time they return to practice. So this combination of practitioner expertise, so we want to create a more mature knowledge base amongst the regional trade financial community, and hopefully encompassing the other sectors who are involved in detecting, but also preventing and prosecuting trade-based financial crime. I'm really sorry I cannot be with you in Dubai in person today. I'm currently in Saudi Arabia, but I have no doubt that you have all had a very constructive and informative day, and I hope to see as many of you in person as possible in the near future. Thank you very much.
ICC UAE makes it possible.
Yes, we do.
It worked.
So thankfully it worked, and nice message to kind of round up the panel. But I think we will have some questions, please. Yeah, can we?
It's more of a comment. It's more of a comment. I appreciate the point that Mr. Scott brought, because sometimes we think very narrowly of KYC. We think it is know your customer business, know your customer's capital, but it is important to understand the quality of the management and whether the management is vigilant or naive regarding the transactions they get themselves into, and they might drag you into a violation of sanctions unknowingly.
You forgot one of the KYCs, know your customers' criminals, okay? Don't forget that one, okay.
Mine's also an observation that the unintended consequence of all these regulations is just pushing importers, exporters away from the banking system. There'll be more open account, they'll find different ways of doing things, they self-insure, it won't be covered by banking anymore. So the regulations will not have the intended consequence.
Very good. Oh, great, Robert. And great, then we can respond, yes.
It's worth just saying, because I've been on stage where I've had the banker with alternative non-FI financier, the banker saying it's okay for you, you don't have to comply with anything. Of course, the reality is AML is for everyone. Yeah, it's not just for bankers. Anti-money laundering, financial crime, it applies to me, you, non-banks. So it's really a universal diktat. So I think there is some misconceptions out there. I think there are some things on the KYC side which are done in a different way because of the nature of the way that regulators enforce those. But I think broadly speaking, there is a leveling up going on.
Yeah, if I may just add one small. One of the challenges that we face today, and by the way, just to confirm exactly what it is, like most of these regulations that are applicable to banks are now very much applicable to all the non-banking services. For example, payment service providers. Now in the UAE, we have a pretty strict regulation that is bank-level regulation applicable to the PSPs and payment aggregators. And what we have started noticing of late is payment is also getting disaggregated. Essentially, banks are no longer seeing the end-to-end movement of funds around the globe anymore, because there's a lot of these payment aggregators and PSPs that have come into the picture by way of fintechs, etc. That's all right. If they're able to do this job much better than banks, so be it. But what I've also seen increasingly is in the name of disaggregation and intermediation, etc., they are also bunching of transactions into one single payment and netting off and so on and so forth. There's a lot of that happening because they are no longer following the FATF 16 requirements of payment transparency. So I think it's only a matter of time before regulations will catch up, regulators will catch up, because it truly does impede the ability for regulators and law enforcement to understand the end-to-end picture of payments, for example. And if it happens in payments, it's only a matter of time before it gets extended to other forms of value transfer mode.
So,
yeah. Yes, absolutely.
Correct. So I'll just add to that. I think it's an add. That issue is one of the issues. We have a working group right now that is hopefully a month away or less from publishing a paper on uneven regulations in payments. And the ultimate goal is to establish a model code for global payments. But what it attempts to address is the unevenness in regulation, both geography to geography, as well as between bank and non-bank. Because what we have heard clearly is that you have non-bank payment providers that ultimately still rely on the banks to settle, and ergo, the banks become the regulators for those non-banks. And so we have also seen is that with different, for example, different faster payment schemes, and particularly where you have one leg in, one leg out, there are different rules that apply for who can participate, who can't participate, what level of KYC is required of the banks, what's required of non-banks. I had the joy of, this was a memorable meeting, sitting in front of a regulator. I won't tell you the country, but it was literally on the day, and in the middle of the meeting, they had just passed a fintech law that was a big deal in that particular country. And I said to them, I said, so we want to talk about, this fintech law. And he stopped me before I got going, and he said, you're going to tell me about an unlevel playing field, right? And I said, of course. And he said, I don't care. This is a regulator. He said, I don't care. Because in that particular instance, they had an objective built around financial inclusion. And what they saw was that from a country government perspective, that the goal of achieving a greater level of financial inclusion was more significant than any of the concerns around unlevel playing fields, even from a compliance and an AML perspective as it related to non-banks. So this is a real issue. It is going to take some doing to try to tackle this issue, but recognize and know that different countries have different objectives when they're conducting trade or they're conducting payments or they're thinking about how they use non-banks as part of their ecosystem, and we're going to have to take that one by one.
Just one point to add, based on what Chris said, I think in UAE itself, we have banks which are local, regional, the international banks which are based out of DIFC, ADGM, etc. All of these banks have varying practices. So as a customer, I probably would divert business, given other factors equal, I would divert business to the banks which sort of are more accommodative. Because what also happens is, this is like searching for a needle in the haystack, right? The number of false hits are much, much more. It's about 90% compared to the 4 or 5% that you get as true hits and which you do further investigation.
Yeah.
And from a customer's perspective, he probably looks at how I can churn my liquidity faster.
Yeah.
So it's a balance that you need to strike. Nobody has probably the answer.
One other thing I just want to make sure that you're aware of before Vin cuts my mic off for good is just another tool. We released a guidance document last year on helping to evaluate, I forget the title of it, it's way too long, forgive me. It's like evaluating potentially suspicious or potentially unusual vessel behavior. We have to come up with a better name for it, but the point being that with this increase in sanctions avoidance regulation, we felt it was important to help provide some guidance on how institutions are identifying this unusual vessel behavior. And you may be called to account for this by your examiner, and that could be another helpful tool in your operations.
Yep, no, I'll definitely just add to that. Look, you've got some great vendors out there. I think Win-Win is one, yep. IHS Fair Play, I think, is the other. And, you know, you look at a vessel like this, you can go, okay, where's it been? They've all got their IMO number. They go down to the level of, they can look at it from the satellite and see, you know, you've got the Plimson line there. You can see how high that's been, how low it's been, when the transponder's been turned off. Has it got any dark activity? Mm-hmm. Like, for example, you know, off the coast of Taiwan is quite a known spot for ship-to-ship transfer to North Korea. So that type of information is available and easily used from vendors. Some of those vendors you can tag your ships and the data will come to you. So for example, I've got 30 ships that I want to look at. If there's an alert, that will come to you. So there is solutions out there, and papers like that are definitely, just like this trade finance one, are great, just to help the whole community upskill.
Yeah.
Wonderful. So I think they deserve a really wonderful round of applause. The last session and the room was pretty much full. So just to let you know, on Thursday the 16th, at I think it's 11:40, we have a wonderful speaker on the shifting sands of compliance. He's really a wonderful speaker. You'll enjoy it. He could be here with you. So I'm going to wrap up the show right now, if that's okay. And but a really wonderful session. And just a few things that I have to do. I have 3 prizes to give out. And as you know, I'm going to ask 3 questions, and the answer to each question is a number. And the book is the LC Rules and Laws, I mentioned it before, sponsored by our sponsor, China Systems. So first question is Zul today. He said that in terms of duplicate financing,
1 in so many thousand is a duplicate transaction. How many thousand? 6,000 was right here. Here, congratulations. Take your book. Okay, that's wonderful. Give him a round of applause. That's really excellent. Okay. And the next one, Pavel here. Pavel, oh no, Pavel is here. Pavel is here. He was talking about ICC rules, and he said there was one set of, well, a few sets of rules he liked and a few he didn't like, but he really liked the URDG. And in the discussion, we had a conversation about guarantees and counter guarantees. So one of the rules, wait till I have the question. One of the rules deals with applicable law. Article? It was a lady's voice, but I'm not sure which lady. Oh, Inessa, congratulations from Armenia. Wonderful, wonderful, okay. And the final one is also going to be a number, because we talked about many numbers today, Brian. It was really, really detailed and important and everything. But the most important number of all is my birthday is on September. Okay, yes. I'm not sure which of the ladies won it, but you got one already and you were last, okay? So I'm not sure which of you ladies got it.
I don't remember my wife's birthday.
Yeah, well, congratulations. Now, the final thing, before you leave the room, you should look out this window, because when you look out the window, you'll see a swimming pool, okay? So the swimming pool is at the Sheraton, Dubai Creek and Towers. So all of you are our guests of China Systems to the reception at 6:30 this evening beside the pool. Not in the pool, Robert, just beside, maybe later, okay? Okay, so we'll see you there at 6:30, and of course you're all complimentary guests to the summit for the next 2 days, okay? Starting at 9 o'clock tomorrow, registration at 8 o'clock. And the summit is taking place in this wonderful building, pretty much on the first floor, ground floor. It's kind of ground floor auditorium, the big auditorium. So let's give everyone a round of applause, and thank you very, very much, okay? So wonderful job, guys, and see you later. Yeah, thank you, Ellen. The video worked. Wow.